And wow, I don't know.
No, my lord, the Lordship has to be very, very strong about this, my lord. Otherwise, my lord, our High Court will get a bad name.
I am
And it
telling,
is getting a bad name.
I am telling in the open court, nothing will happen in this court. Nothing will happen. I have taken all these
My lord,
steps.
my lord, in fact, I was in a
All
position to advise my advocate on record to make a complaint with the Registrar General with a copy to the Secretary General of Supreme Court of India.
nothing will happen because I have made all endeavor.
But how many times I will
The
mention
last
this matter?
2 months, I am taking all the endeavors so that the function of the court continue without any. But I failed.
If your lordship feels, my lord, then
That is
kindly
that
consider
is
the position of the
that's why I'm
litigant.
telling in the open court.
I know that. Your lordship had told.
I'm telling in the open
And
court.
your lordship, remember, lordship directed the matter to retain its own position and to come
Today
to.
I passed, then yes, not today. Let it be
Yes.
repaired.
So, yes, and this matter is now missing.
Okay, give tomorrow. It will be taken.
I am giving it, but not assure. There is no surety the matter.
No, I will. I will assure. Eta करी कल के just a minute. कल के टॉप अर्जेंट मोशन टॉप करी दिन और शाम को हमको बता देना. This list may be bring to me in the evening. It's still in the urgent motion. Urgent motion. Now, which number? Which number? Serial number? 130 under urgent motion. Adjourn motion. Yes. I understand. I understand. एक काम करो उसको लेके 10th को रखो अर्जेंट मोशन विद इन 10 मैटर्स. Today is not the mentioning day. What is the urgency? हाँ. When it was open? It will be open on 9. So what is the cause of action? हाँ. 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 So they have cancelled the first tender. Then the second process is started. Should be started. Ah. Huh? Correct. Second tender notice has been issued. So what is the difficulty? You participate in that. What is the reason for cancellation? I don't know when it can be fitted and I don't know. No, not this week. What is the last date of the tender? 9th of? When the tender notice was published? It can't be. Second it was published and 9th will be last date. It can't be as per law. Where is the tender? Show me the tender notice and the last date of the tender. Show me the second tender notice. The 9th was issued and the next date is the last date of the 9th. Corrigendum has been issued. So Corrigendum has been issued for what? Extended date, nothing. Yes, give. Time, date is extended. What is, yes?
My lord.
Time is only extended. No condition has been changed, sir. Sorry.
Due to extreme urgency.
Yes.
Due to extreme urgency, I am mentioning one matter. Initially,
Today is not the mentioning day. Come tomorrow on Thursday.
my lord. What happened, my lord? Initially, I have mentioned the matter, and my lord was pleased to fix the matter on 10th February. During the pendency of this petition on 21st January, the respondent authority issued a notice to the petitioner to remove your articles within 5th February. That's why I am mentioning it.
So 5th February is tomorrow.
Day after.
Yes, what can be done?
Can you fix it on tomorrow? Otherwise, matter is.
Okay, fix it tomorrow. Fix it tomorrow. No problem.
My lord. My lord.
No further. Yes, start.
My lord.
I need to mention one matter, my lord.
My lord.
Today is not the listing.
It was assigned, my lord, to your lordship. The matter is, another matter is fixed to your lordship tomorrow. Relates
What
to
is the matter?
Relates to the 100-point roster, my lord, the handicapped candidate, fitting on the handicap.
Correct.
The similar matter assigned to your lordship by the Honorable the Chief Justice. Well, only praying that let this matter be, my lord, appear along with that matter.
Let us see what will happen in the tomorrow.
My lord, 20. My lord, on
assigned matter, it is assigned to your lordship.
my lord, on 29th, this matter was.
This matter has been assigned to your lordship. I have already annexed the assignment matter notification.
Assignment, it will come in the list.
Since your lordship has fixed the matter tomorrow, similar issue.
That issue I already heard the matter.
But
I don't know what is the issue in your.
But similarly, that's why the coordinate bench of
Let that matter be that matter be disposed of, and let any order be passed. Then you mention that I will pass a.
My lord, this matter was directly listed today, my lord.
What can be done? To be mentioned, what in the mentioning you can argue the matter. For what?
But it is similar here. Today, within 5 matters, it was ready to be listed.
Day after tomorrow to be mentioned. Mein rakho.
But this was, in fact, mother.
To be mentioned.
It was initially fixed on 6th. Then, your lordship preponed it to for today. Within first 5 matters, your lordship directed, not in the list. Can it be taken up tomorrow, Mlat? SIR matter, that's the urgency. That's why your lordship preponed the matter from 6th to 3rd.
उसको Friday रखो.
मतलब leave may be granted to move this matter on an urgent basis only because मतलब under section 14 the possession will be taken on 5th. मतलब the petitioner is willing.
Section?
मतलब 14 of the SARFAESI Act order has been passed.
This court is not having.
No, my lord. मतलब this we have filed this under group 9. The order has been passed.
Yes.
Under this comes under the group 9 applications, my lord. What I was placing, the order has been passed. Now 5th.
Who has passed the order?
My lord, ACJM Shialda.
The
equivalent to the DM.
Correct.
Now, my lord, no section under my lord, the order has been passed. The date 5th. This is date fixed of this month. My lord, to take possession. The petitioner is willing to pay the amount
under the SARFAESI Act.
Under the SARFAESI Act.
That this court, you go to the other court.
No, my lord, the order has to be stayed. The other court, my lord, doesn't have to use the police. Staying the police, my lord, would want help. My lord, the order has to be stayed. For that, my lord, we have placed this matter before this jurisdiction. No, my lord, kindly, my lord, kindly considers, my lord, only the order has to be stayed to pay the petition.
Go to the SARFAESI court. Under the SARFAESI, it was ordered. Go to the
SARFAESI.
The court will not, if the court will not accept, come here.
My lord, I do not have chance within 5th, my lord.
No, this court is not find any urgency. 2022 motion. Today is not the mentioning date.
Earlier was mentioned, my lord.
Give. Call the number 1 matter. Yes, who is for the number 1? Who is appearing for the petitioner? None appears.
Advocate record in this matter is not available.
For non-persecution, advocate is required.
to
My lord, I am appealing on the respondents, my lord.
the notice and the documents.
Record. On mentioning by the learned advocate on record of the writ petitioner, the matter is listed as to be mentioned as item number 1. But when the matter is taken up today, counsel for the petition prays for time. Let the matter appear in the month of June 2026.
My lord, respondents' appearance may be recorded, my lord.
Give the name. Next.
My lord, I am for the petitioner, my lord. There is a correction in the order dated 22/2026, and its the date will be 2026 instead of 2025.
6th February.
Yes, my lord.
26th February.
Yes, my
Last
lord.
date.
Yes, my lord.
That is only.
Yeah, that is only, and another is, my lord.
It is listed as to be
my
mentioned
lord,
for correction in
my
the
lord,
order dated.
in the list the can number is showing, but my lord has shown his concern that the can is not in the file in the last occasion, my lord. So please check and pass necessary direction to the department, my lord.
Can?
Can number 1.
Ah.
It is showing in the list, but
Ah.
my lord has shown concern that the can 1 is not in the file. So my
Yes.
lord, kindly, my lord, direct the department to.
The matter is listed as to be mentioned for correction on the order dated 22nd January 2026. Counsel for the petition submitted in paragraph 6. The date is wrongly mentioned as 6 February, wrongly recorded as 6 February 2025 instead of 26 February. Yeah, 26 February 2025 instead of 26th February 2026. Accordingly, in the order dated 22nd January 2026, at paragraph 6, the date shall be read as 26 February 2026 instead of 26 February 2025. The department is directed to place the record of can number 1 of 2025
Yes, my lord.
on the next date fix.
Oblige, my lord.
Next. Next.
Now that the problem has been deed of 20, 25 years back, my lord, has been traced. Report has been shown to him. We were talking together. 3 months time may be given to complete, because stamp verification has to be made.
What?
Collector.
Ah.
Stamp duty collector.
Respondent already filed a report according modified the dispensing with the person affairs. Yes.
So, my lord, 3 months time may be given. Parties to cooperate with the IG. Parties to cooperate with the.
What is the claim in the writ petition?
My lord, at 97 deed.
Ah.
No steps were taken by the parties.
My lord, we have received the
Thereafter, my lord,
Instruction of the sale deed.
sale deed,
Executed on 16 January 1997.
1990.
So you are traced out. What is the report?
Report is, my lord,
page was due to missing of the first page of the deed.
Ah.
Presently the matter is pending before the collector stamp revenue officer
Ah.
for ascertain the court fees paid and everything.
Hmm.
So my lord, that's why we are praying, my lord, the matter can be disposed of with a direction to complete the process within 3 weeks or 4 weeks or 12 weeks.
12 weeks, my lord, will be required.
My lord, paragraph 8, my lord, of the report, it says the matter is now pending before the learned collector stamp revenue of Kolkata.
Second page is important. First page has to be supplied by the petitioner after duly signed. Then, my lord, stamp verification would be made. Then collector will give, my lord, as to whether the adhesive was purchased from the collector of the, my lord, the stamp revenue. These are the formalities to be completed. Yes, sir.
What is your case?
My lord, page 9.
Page 9 of
is
the
the
writ
first
petition.
page of the first page of the deed. That page is now missing.
Correct. What is your writ petition?
My writ petition is, my lord,
He wants, my lord, in 1997 deed be completed.
complete.
No steps taken up.
2018, my lord, we are pending
97,
representation and
2018,
everything.
20 years.
Several representation were
No, no, no. Only one.
চার-পাঁচটা representation.
তাহলে পরে affidavit টা দেবে।
The same is not yet registered.
No matter.
The petitioner has filed the present writ application praying for a direction upon the respondent authorities for registration of the sale deed executed on 16th of January 1997. It is submitted that the petitioners have executed one sale deed on 16th January 1997 in favor of Magma Leasing Limited, that is the respondent number 5 in the present case, and has submitted in the office of the respondent number
3 mile.
3 for registration, but till date the same has not been registered. Full stop. This court has called for the report from the respondent number 2 and respondent number 2 and the additional registrar of assurance dash Roman 2 Kolkata and the registrar of assurance Kolkata have filed their joint report stating that the petitioner has submitted the deed in their 1997 but has not made any endeavor to register the same for the last 20 years. And on receipt of the communication from the petitioner, the respondent authorities have traced out the deed submitted by the petitioner on 16th of January 1997. But it is found that the first page of the deed is not available. And as such, the respondent submitted that the petitioner will provide the first page of the deed or reconstruct the first page of the deed, the respondents will take appropriate step for registration of the deed submitted by the petitioner within a period of 3 weeks.
No. I 3 months.
Within 3 months from the date of submission of the first page of the deed. Had the learned counsel
Duly signed and
had the learned counsel for the respective parties peruse the report submitted by the joint report submitted by the additional registrar of assurance -2 as well as the registrar of assurance Kolkata. This court finds that the respondents have admitted that the petitioners have submitted the deed on 16th of January 1997 for registration, but the petitioners have not made any endeavor for registration of the same, and after the period of 20 years, the petitioners have made request to the authority for registration of the deed. On receipt of the request, the authorities have traced out the deed lying in the office of the respondents, but it is found that during the shifting of the records from one office to other office, the first page of the deed has been misplaced. Accordingly, the petitioners are directed to give the fresh copy of the first page of the deed duly signed by the parties within a period of
4 weeks.
To the respondent number 2 within a period of 2 weeks from the date of this order, and on receipt of the first page of the deed duly signed by the parties, the respondent number 3 shall take appropriate steps for registration of the deed within a period of
3 months. Stamp duty
within 3 months in accordance with law. WPA display.
Because verification has to be made from the stamp duty collector. They will comply with all the directions that
the petitioners are directed to comply with all the provisions for registration, of the deed as per the direction, if any, by the respondent number 3.
Deeply applied.
3.
Deeply.
Opposition reply হয়ে গেছে, hearing এ করে দেন। Yes, next.
I appear on. I don't know
Yes.
what correction, my lord.
What is the correction?
I don't know, my lord.
Huh?
I don't know, my lord, because of that, on the date of my lord, this moving this application, they have filed the affidavit.
What is the
Alleging,
correction?
my lord, regarding my lord, the admitted amount which has been, my lord, this admitted by the authority concerns, I am accepting the admitted amount. My lord, this is the my lord, the communication which has been made by the video.
So what is the correction?
I don't know, my lord, why they
How it has come?
Wrongly.
Give.
So, my lord, so I have already handed over on that first date of hearing.
1,73 to 182.
Yes, that is.
नहीं mentioning उन लोग रखते ही नहीं है. They are not keeping the mentioning slip.
Order হয়ে গেছে তো অনেক আগে।
Nothing is required. Out of list. Already disposed of.
Yes, yes.
Already disposed. Next.
For the petition.
Yes.
The interim order will expire on 4th, tomorrow.
Tomorrow. Who is for the other side?
MSME Council, my lord, I have sent by post for the order, communicating the order twice. Nobody.
Have you saw the copy?
Yes, yes. Initially, I have saw. And
This is a-
again, my lord, I have saw.
This is the fourth extension. Fourth extension.
Second.
Second extension. No, earlier it was extended on
No,
6th
my lord.
January.
6 January, thereafter no extension.
Okay. The matters listed to be mentioned for extension of the interim order. Counsel for the petitioner submit that in spite of service of notice, none appears on behalf of the respondents, and the interim order is till 4th of February 2026 and prayed for extension of interim. At the learned counsel for the petitioner, this court finds the petitioner already enjoying the interim order. Accordingly, the interim order is extended till 25th of March 2026 or until further order, whichever is earlier. Let the matter appear on 25th of June.
It may be before 25th, my lord, to appear. Either 24th or 23rd.
Let the matter appear on 20th March under the same heading. Under the heading urgent motion. Yes, next.
The 7, my lord, I am
Yes.
Praying
What is
for
the
rest.
application for?
well,
I am
restoration.
for
my
the
lord.
National Jute Board, my lord.
Well, restoration. Well, the matter was dismissed. That I was on default, my lord. I take it upon me, my lord. Well, it was taken up at the last. If my lord restores it, my lord, I'm ready with the writ petition.
Well, let it be fixed on a
Today,
date, my lord. But today I am not ready, my lord.
Huh?
Well, the main writ petition, my lord, has to be.
What is the application? What is the writ petition?
Well,
What
the
you
writ
prayed
petition,
for?
my lord, 39 lakhs and odd is due and receivable from the Ministry of Textile, my lord. Upon publication of a scheme by them, I am one of the jute mill owners. I had constructed Shulab sanitary facility for the workers. And my lord, in the scheme, it was
Sulabh
said that-
Shauchalaya.
my lord, Shulab Shauchalaya, my lord, for the workers, for the benefit of the workers. And my lord, it was in the scheme, my lord, 90% of the amount was promised by the Ministry of Textile. My lord, I completed it. My lord, there was a dispute.
Who has awarded the work to you?
My lord, they awarded the work to me.
Ministry or the local government, local self-government?
My lord,
Because it
was
has to be
not
there.
directly.
What is the difference?
My lord, it was by National Jute Board. National Jute Board gave me a letter in which, my lord, in the approval letter, it was said that it's 6 months from the date of approval. My lord, now this,
Okay, then they want the time. Oh, affidavits filed, not.
my lord, my lord, no. This is
Not filed. In the writ petition, no affidavit.
in the
is
writ petition, no, my lord, coming up for the first.
You will argue the matter without writ application.
My lord, let them file the affidavit, my lord.
Well, we will file an
Why you
opposition, my
not
lord.
appeared?
My lord, we will file an opposition.
Not
My
appeared.
lord, I take it upon me, my lord. It was taken up, my lord, at 4:30, my lord. I was not
My lord,
well, my lord,
disputed question of facts, my lord. We have also taken the maintainability
The
point, my lord.
petitioner has filed the present application being
my lord, affidavit of service.
can 1 of 2025. for recalling of the order dated 13th May 2025, wherein this court has dismissed the writ application for default for non-appearance of the petitioner when the matter is called. Counsel for the petitioner submit that the petitioner was suffering from illness.
My lord.
The advocate on record could not appear before this court when the matter is called. And immediately when the petitioner came to know that on 13th of May 2025, the petition was dismissed. On 19th May 2025, the petitioner has filed the present application. Had the learned counsel for the respective parties perused the cause shown for non-appearance of the petitioner when the matter is called, this court finds that sufficient cause has been shown. Accordingly, order dated 13th May 2025 is recalled. WPA 1601 of 2025 is restored in its original file. Police of C can number so and so disposed of. Affidavit of service be kept with the record. It is found that police counsel for the petitioner respondent prays for time to file affidavit in opposition.
Yes.
Let affidavit in opposition be filed.
3 weeks. 3 weeks.
Let the affidavit in opposition of the main writ application be filed within 2 weeks. Reply, if any, there to be filed within
1 week.
within a week thereafter. List the matter on 11th March under the heading adjourn motion.
Well, if your lordship takes it on 3 weeks time, my lord, because these are national jury, it's an old matter, my lord, I'll to take out the file also.
1 week, 11 March.
Very well. Grateful.
1 week, 11 March.
11th March is fixed. 11th March.
11 March adjourn motion.
Grateful.
Next. Seriously.
Item number 10.
I appear for the state.
Item 10, I'm for the petition and advocate Sandipto Bose is down with high fever, my lord. Kindly make it not this week and retain its position next week.
Very for the respondent bank, my lord, on staff petition has directed the bank officers to cooperate with the police, my lord, as per your lordship on the police welfare, and all the documents have been handed over, my lord.
My lord, I have the interim report as directed by my lord. Documents have been seized by the bank, from the bank by the police, my lord. My lord, on the last occasion, we were to find out the SOP process as to who are the individuals that were involved in the approval process of the loan. Those individuals have been identified, my lord, and they are being questioned. My lord, may I file the...
As per the prayer made by the counsel for the petitioner, the case is adjourned. Okay, not this week. Not this week, next week it was.
Lord, let it be retained in the same.
Yes, next week.
Item number 11.
Great 11, my lord. That matter, my lord, court is...
Yes.
Lordship, I'm for respondent number 2, 3 and 4.
Okay, doctor, and that, yes.
But we have come up with a concrete instruction, my lord. Just need to make an application to the judicial department, my lord, along with the account details, my lord, and they will get the money in that account.
When?
My lord, kindly adjourn the matter for 2 weeks, my lord.
2 weeks.
Within that, my lord, probably, my lord, within 7 days or 8 days.
Why? What is the problem for the...
My lord, that has been deposited in the judicial department head, my lord. I have got the instruction, my lord. We are acknowledging the receipt of the money, my lord. Last page, my lord. My lord, kindly give us.
Needs to make an application to the judicial review all relevant details, including the bank account details, into which there is a refund to the on receipt shall verify and forward the matter to the end group through proper channel for necessary after receiving the necessary correction. Shall issue a sanction order directly.
Let the assistant secretary be appear before this court.
My lord, kindly, my lord.
No.
My lord, 1 week, my lord. My lord, 1 week.
So much water has flown from the head.
My lord, one thing, my lord. I will-
This is the way you are submitting the report before the court.
But this is for myself, my lord.
Correct. This is the report. You are telling that he has to apply. Then they will take the concurrence of the judicial department. Then the judicial department will transfer the amount. Then it will go to let at 2 p.m. At 2 p.m. the secretary who has given the report had to appear before this court.
Well, only one application. Rest of the thing, my lord.
This court finds that this is the fit case wherein the finance secretary is required to be appear before this court. Let the finance secretary appear before this court by tomorrow at 10:30 a.m.
And so on, loss.
My lord, kindly, my lord, I will personally, my lord.
By 2 p.m. you bring the amount, I will recall the order.
My lord, 2 p.m.
Otherwise, no problem. Yes, call the max. You are playing with the court.
My lord, no, my lord.
Then, and the report be kept with the record, not to return to him. I will see how the state will act.
My lord, only one thing, my lord.
Sorry. I heard the other advocate. I heard the advocate general. Now you are the fourth person. You are coming before this court with this instruction.
My lord, one application, my lord.
No. Why the application? When the petitioner has filed the writ application and the court is calling for the report, what is the application is required?
The judicial department is.
Why the judicial department if the payment has been made by the petitioner? Why the judicial department has been transferred? Okay, you do whatever it is. Let the finance secretary come here or you challenge this order. I will see. Tomorrow at 10:30, I want your finance secretary before this court. If he will not come, then tomorrow at 2 p.m. he will bring the police. Sorry. Call.
The 12, my lord, the 3rd September report called for by my lord Justice Amrita Sinha. Then your lordship directed to file a report. Still these days, the same video, my lord, is the Mathura put 2. So now it is the admitted amount which has been withheld regarding, my lord, after my lord, the repairing of the, my lord, the school as per the work order. Till this day, the report has not come.
What?
My lord, this is the admitted amount which has been withheld.
My lord, from the documents appended to the writ petition, my lord, and annexure P1 is, my lord, the work order, but which indicates the amount for which, when the tender was called for. But there is no such document which show.
You file the report. Why you are not filing the report?
Yes, one thing before your lordship, your lordship's kind of. But the representation is there at page 13, my lord. If your lordship kindly directs the respondent number 3, that is the video, to consider the representation and come to a finding as to the admitted amount, and therefore take necessary steps for.
Where is the report?
But kindly then grants me a week's time, because
We will give the. Let he also come before this court tomorrow.
but respondent number 3 will file.
Yes, he will appear before
Only
this
one
court
thing,
tomorrow.
Only one thing, my lord. But respondent number 3.
I know how the work is to be done.
The difficulty.
I have good experience with the state authority. This is the 3rd time you are taking the time.
Difficulty is, my lord, all these officers, my lord, they are all, my lord, with able for the SIR purposes.
Maybe SIR. SIR is only not one work for the administration.
Sir,
There are so many works.
I know, my lord. Kindly grant me a week's time, my lord. I'll come with
Sorry.
comprehensive report.
You tell if you file report by tomorrow, I will adjourn the matter. Otherwise, I will pass an order. Let you appear tomorrow in person.
Then kindly grant me 48 hours time, my lord. 48 hours time, my lord. 48 hours. 2 days.
Well, 15 matter, they have come with the report. Matter disposed of your lordships.
Counsel for the respondents press for 2 days time to file report. For the interest of justice, the case is adjourned. Let the matter appear on 9th of February 2026 under the same heading for filing report by the authority. It is made clear that on the date fixed, if no report is filed, appropriate order will be passed.
My lord.
Next.
Lordship, on 9th my father's day, on 9th of my father's day.
My lord, 10.
10th कर दें.
Okay.
10.
I'm getting.
May it please your lordship, I am for the petition. Lord, in this matter, my lord, the lordship may recollect, my lord, this is a matter, that matter, my lord, pertains to the freezing of the bank account. On 13th of January, your lordship was pleased to consider this matter and directed the petitioner to communicate the order, my lord, and complied the order, filing affidavit of service.
Yes. Have you served?
My lord. They have received, your lordship will find it at page number 7 of my affidavit of service. They have received it on 16th of January. 19th of January. I stand corrected. On respondent number 8, my lord.
Yes, what is the case about?
Lord, the petitioner, my lord, is a proprietorship concern, Lord, dealing with the business of jewelry, retail jewelry. And my lord, he has, my lord, sold an ornament and issued tax invoice. The lordship will find the tax invoice at page number 20.
What business is doing?
My lord, retail gold jewelry.
Retail gold jewelry.
Gold jewelry. My lord. The lordship will find that tax invoice in page number 28. The tax invoice that the name of the customer Kiran Ghosh is appearing, my lord, and the transaction is also appearing. And thereafter, what happened, my lord? Suddenly, his account has been freezed by the bank authority.
Where? When is the freezer? Where is the note of freeze?
Lord, I am showing you. Page ball. Amount freezing is later term. Page number 2. Communication, your lordship will find at page number 25 of my petition.
25.
This is the communication from the cybercrime. This is a respondent number 8 authority. Lord, communication to the bank authority, my lord.
Huh?
My lord, annexed at P3 at page 25 is the communication to the bank from the cybercrime police authority, which is the respondent number 8 before your lordship, with a request to freeze this account.
Which account? What is the number of your account?
Lord, the account number is appearing at. Lord, this is the middle of the page, my lord. Account number is appearing. 70.
Then what has happened?
Lord, my account has been frozen. This is the current account and my only business account, my lord. The difficulty is I could not run the business. My livelihood is at stake. I could not pay even the salary to the poor workers. Lord, at page number 27, in point number 7, my lord, the disputed amount is appearing as 19,167 out of that transaction, the 45,000. My lord, for this entire 45,000, I have issued, my lord, tax invoice. My lord, being the business entity, I am not supposed to, my lord, conduct a forensic scrutiny of all my customers. And now, my lord, the law is well settled that so far as, my lord, freezing is concerned, my lord, that is the attachment. That is not the seizure. Now, my lord, 107 of BNSS is there. Judgment guloke make or that
Yes, recorded. Yes.
My lord, from the bank side, my lord, we have only to submit before your lordship that we have received an instruction from Kerala, specifically directing us to freeze the account.
Yes. Recorded.
Lord, I'm citing, Lord, two
The
judgments
petitioner has
for your
filed
lordship's
present
assistance.
application praying for a direction upon the respondent bank.
For your lordship's assistance, your lordship.
Upon the
On Bombay High
respondent bank 2.
জজের নিজের order আছে।
Which bank? Bank of Baroda?
Bank of Baroda.
That's one bank. That is the respondent number 4, comma, Bank of Baroda. Baroda.
কোথায় গেল?
RC Datta Road, Alkapuri, Vadodara, Gujarat. Vadodara?
My lord, the instruction is from Kerala.
No, the Bank of Baroda, Gujarat.
No, my lord,
my lord,
it
it's
is in Kalna, West Bengal.
That's one number 5.
This one.
Yes, five.
Bank,
Branch is at Kalna.
Bank of Baroda, Kalingapara, Kalna branch. Full stop. Counsel for the petitioner submit that the petitioner is the proprietor of Datta Jewelry and Sons, carrying on the business of retail jewelry at Sonapatti, Kalna, Purba Medinipur. Full stop. The counsel for the petitioner submit that all of a sudden, when the bank account was seized,
In the month of
all of a sudden, पढ़ के नहीं आते सर. Only in the month of August.
But our
2025,
instructions arrived on 11th of August 2025.
the bank account of the what is the current bank account or saving bank?
August 2025.
Key account.
Current bank account or saving? The current bank account of the petition being account number 36230200 5 times 0 379 was freezed by the bank. Full stop. Counsel for the petitioner has made inquiry from the bank, and the bank has informed that the same has been freezed as per the written instructions of the Inspector SHO Cyber Crime Police Station, Thrissur City, Kerala, dated 11th of August 2025. Police. Until for the petition submit that the disputed amount is, and the transaction amount is 45,000 and the disputed amount is 19,167, but the petitioner has paid the total tax of rupees 45,000, and without any information to the petitioner and without any inquiry from the petitioner, the bank has freezed the account of the petitioner on the instruction of the police authority. Counsel for the petitioner has relied upon the judgment in the case of Headstar Global Private Limited versus State of Kerala, reported in 2025 SCC Online Kerala 3546, and in the case of Karthik Yogeshwar Chatur versus Union of India and others, reported in 2025 SCC Online Bombay 477578, and submits that it is settled law that unless and until the investigating agency will not obtain an order from the jurisdictional magistrate under section 107 and 108 of the BNSS, the investigating officer cannot freeze the account of the petitioner. He further submit that in the present case, there is no record that the investigating agencies has obtained any order from any magistrate for freezing of the account of the petitioner. Learned counsel appearing for the bank submit that the bank has received a written instruction from the Inspector SHO Cybercrime Police Station, Thrissur City, Kerala, on 11th of August 2025, with the direction to freeze the account of the petitioner being account number 362302 5 times 0 379, and as per the instruction of the investigating agency, the bank has freezed the Full stop. Learned counsel appearing for the state submit that the state has no role to play in the instant matter as the bank has acted upon the instruction of the police or cybercrime police authority of the Kerala. But the learned counsel for the respective parties produce the materials on record. This could find that the inspector SHO cybercrime police station Thrissur city Kerala had requested the bank for freezer of the account of the petitioner on the ground that a case has been initiated being crime number 45 of 2025 under section 318 within bracket 4 BNS, 3 within bracket 5 and 66 within bracket capital D of IT Act of the Cybercrime Police Station and in connection with the investigation of the said case, the police has the investigating agency has requested the bank to freeze the said account. Initially, the petitioner has not made the investigating agency as party to the instant case. Subsequently, as per the order passed by this court, the petitioner has made the investigating agency as a party and notice has been served. In spite of the service of notice, none appears on behalf of the investigating agency. Full stop. None, full stop. By an order dated 13th of January 2025, this court was of the view one opportunity should be given to the added respondent, that is the respondent number, added respondent, that is the inspector in charge of this station was officer cybercrime Thrissur city, and accordingly directed the petitioner to serve a notice upon the respondent number 8 to give an opportunity to bring and to us and to hear the said investigating officer with what is the necessity of freezing the said account. In spite of service of notice, none appears on behalf of the respondent number 8. Full stop. None of the authorities have placed any record before this court that the investigating agency have obtained any order from the London magistrate for freezer of the account. The Kerala High Court in the case of Headstar Global Private Limited within bracket Supra has held that while section 106 speaks of seizure and section 107 deals with the attachment, forfeiture and restoration, seizure under 106 can be carried out by the police officer and an ex facto report submitted to the magistrate. On the other hand, attachment under 107 can be effected only upon the order of the magistrate. Full stop. The logic behind the distinction between the purposes of seizure is more to secure the evidence during the investigation, whereas attachment is intended to secure the proceeds of crime by preventing its disposal and thus ensuring its availability for legal procedure such as forfeiture and distribution to the victims. Fully. In the case of Karthik Yogeshwar Chatur, Supra, the Honorable Division Bench of the Bombay High Court has held that approved the order passed by the single bench of the Kerala High Court. In the present case, though the bank has acted upon the request of the police authority, that is the respondent number 8, wherein the respondent number 8 has requested the bank to freeze the account of the petitioner. The petitioner has made the investigating agency, that is the cybercrime, that is the respondent number, has made the cybercrime police station as party to the instant case in whose jurisdiction the case has been initiated. Notice has been served, but none appears on behalf of the respondent number 8. This court has, by an order dated 13th of January 2026, has also given an opportunity to the respondent number 8 to appraise this court whether the investigating officer has obtained any report from the concerned magistrate for seizure or for attachment of the account of the petitioner. But in spite of service of the notice, the investigating agency choose not to appear before this court. Considering the above, this court implied that the investigating agency have not obtained any report, order from the London magistrate for attachment of the account of the petition. And there is no record, there is nothing, no record available on record to presume that the investigating officer, investigating agencies have acted in accordance with section 106 and 107 of the BNSS. Considering the above, this court find that the attachment, the request of attachment made by the investigating agency, that is a response number 8 to the bank, is illegal, and accordingly the bank is directed to immediately defreeze the account of the petitioner, and the petitioner is allowed to operate the bank accounts.
Extremely grateful.
Much obliged.
Extremely grateful.
WPS disposed of.
Let me just indicate only one thing on purely points of law, my lord. My lord, the petitioner has also not received any show cause notice from the magistrate, my lord. That is settled. That is settled in 107. I'm extremely grateful to you.
Next.
Madam, for the petitioner. The matter relates to my tiger attack.
Tiger attack.
My lord.
Yes.
The husband of the petitioner.
How many persons have been injured?
But 1%, the petitioner, the tiger taken away the petitioner. Wife, husband of the petitioner.
Husband of the petitioner.
Of the petitioner.
So what you have prayed for?
Prayed for compensation in terms of the government order. May I place the government order?
Page 43. 43.
Page 40.
Undersigned directed to order the governor to say that the matter of the
43. 43. Page 43, as you will see. To the family of the deceased for loss of life, 5 lakhs.
5 lakhs.
5 lakhs. The police has
when the incident was occurred
24th February 2019.
2019.
My lord. And police report.
What was the amount at 2019?
There is no such rules at the material point of time. It is introduced later on.
21 it was introduced.
Introduced as a ex gratia compensation to the victim.
Correct. So what is your instruction?
My lord, only one thing, my lord, that issue has been already been decided by the court. My lord can see in the various orders annexed with
but
that.
I have annexed.
My lord, only one thing is there, my lord. Every coordinate bench is allowed the application on the point of that the government has introduced a beneficial legislation, and that should be done. But all the cases, my lord, post-mortem report was annexed. In this case, my lord, post-mortem report is not annexed.
Where is the report that you the deceased was died due to the attack of the tiger?
Page 24 police report.
24.
Yes, lordship. That point has already been decided by the court.
Yes, I am not standing in the way. The point has been
if body is taken away, body could not be traced out, so that in that case, compensation can be awarded. But may I read, regarding page 24?
24.
Yeah, my lord.
Yes.
Regarding police report against death incident of Prafullo Mondal, son of Sarad Mondal, husband of Tulsi Mondal, the present petitioner of Lahiripur, Sundarban Coastal Police Station, South 24 Parganas and Sundarban Coastal PS, GD such and such. This is to certify that on 26/12/19, one Koruna Sindhu Mondal of Lahiripur, PS Sundarban Coastal, PS South 24 Parganas came at PS and reported that on 23rd December 19, the complainant and 2 others, fishermen, left for Panchomukhani, number 2 number block, Khal under Sojnekhali Wildlife Sanctuary range under STR for catching crabs and fishes with prior permission of Forest Authority. Such and such, during catching crabs on 24 December 19 at about 10 AM, when they stay beside Panchomukhani, number 2 number block, Khal near STR, one tiger suddenly attacked one Prafullo Mondal, the husband of the petitioner, son of such and such, the tiger dragged away the victim Prafullo Mandal into the forest. This refers SDB Coastal PS Ajanama. The range officer SWLS range STR was contacted, and it was learned that late Prafullo Mandal, son of Sarachanda Mandal, husband of Tulsi Mandal of Lahiripur, Sundarban Coastal PS South India, had taken away by a tiger while catching.
My lord, I am not standing in the way. My lord, my only
that point.
contention, compensation should be issued after proper verification. My lord, that line should be added. Well, as because my lord knows that it is the 19 incident, all the orders, my lord, if your lordship kindly wants
Page
looks
40,
into
50
my lord's 108, my lord, the last order annexed. They are, my lord, on the first line, the postmortem report of the husband is annexed.
My
My
lord,
lord,
page 50, my lord.
No, that's correct. But once the tiger
If
has
Malad
taken
taken
away
away
the body,
then my lord, there is, but after proper verification, nothing else, my lord. I cannot stand in the way.
who has issued the certificate? 24?
20.
Inspector.
Inspector, Sub-Inspector of Police, SDB Coastal Police Station, South India Province.
Yeah, GD is recorded.
Yes.
19. Now we are on 26.
No, bhage খেয়েছে, আমি আর কি করবো? We cannot stand in the way. My lord, it's a beneficial matter ex gratia. But after proper verification, my lord, X has applied, Y has taken the money. Well, that our contention is only that.
The petitioner has filed the present application praying for a direction upon the respondent authorities for payment of ex gratia payment of rupees 5 lakhs to the petitioner in terms of, where is that order?
Page 43.
Page 43, my lord,
In
government.
terms of the order issued by the Government of India Department of Forest dated 26 February 2026, as the husband of the petitioner died, is the victim of tiger attack on
24th December
attack.
2019.
Tiger attack on 26 December 2019
24
at
24 lordship.
24.
Mile.
Where is that?
But page 24. And on 24, 12, 19 at about 11 a.m.
24 12 2019 at about 8:10 a.m. when at Panchmukhini number 2 block Hall under STR. ठीक है? Police counsel for the petitioner submitted that the husband of the petitioner, while catching the crab on 24 December 2019, the tiger has become the victim of the tiger attack. Full stop. The forest authority, the police authority, full stop. And after the incident, the matter was reported to the concerned police station, and accordingly, the SI of police, SDB Coastal PS South 24 Pargana, has issued the certificate certifying that the victim, the body of the victim could not be traced out, and the victim is the husband of the petitioner is the victim of tiger attack, due to which no postmortem examination could be done. Counsel for the petitioner submitted that after the incident, petitioner has made several representations, but no ex gratia payment has been granted to the petitioner. The petitioner has relied upon several judgments passed by the coordinate bench of this court and submit that this court has granted the ex gratia payment to all the victims who are the victims of wildlife attack, but the case of the petitioner has not been considered. Per contra, learned counsel appearing for the state submit that the case relied on them, submit that the petitioner has filed the present application praying for ex gratia payment on the ground that the husband of the petitioner is the victim of tiger attack. But the petitioner has not filed any postmortem report, and the judgment which the petitioner has relied upon has been passed by the coordinate bench of this court on the basis of the postmortem report. Full stop. He further submit that there is no unless and until the postmortem report is not disclosed, it is not possible for the authority to consider the cause of death of the husband of the petitioner. Heard the learned counsel for the respective parties. The only dispute raised by the state authority that the petitioner has not disclosed the postmortem report. The petitioner has relied upon the certificate issued by the officer in charge, Sundarban Coastal PS, Baraipur Police District, which reads as follows. Page 24, data. From the said certificate, it is categorically reveals that the husband of the petitioner is the victim of tiger attack. And in the certificate, it is also mentioned that the body of the forest department could not trace out the tiger victim. Could not trace out the body of the petitioner and body of the husband of the petitioner, and as such, postmortem could not be conducted. Considering the above, this court find that it is admitted by the authority that the husband of the petitioner is the victim of tiger attack, and the body could not be traced out, and the postmortem could not be done. The order issued by the state by the government of West Bengal Department of Forest states that ex gratia will be given to the victims or legal heirs of the victims of depredation caused by wild animals in scassios shown in the table. As per the said category, the petitioner has lost his husband due to the tiger attack. And as per the said order, the petitioner is entitled to get rupees 5 lakhs. But the case of the petitioner has not been considered by the authority. Considering the above, the writ petition is disposed of, directing who is the authority?
Respondent number 3.
Respondent number 3.
The respondent number 3 is directed to consider the where is the representation? Consider the representations submitted by the petitioner for grant of compensation in terms of the order dated 26 February 2021 for grant of ex gratia payment to the petitioner on proper verification and identification by the state authority, and after giving an opportunity of hearing to the petitioner within 6 weeks. Within 6 weeks from the date of receipt of this order. WPH was called.
It is found in favor, my lord, consequential steps will be.
It is on verification, it is found that the petitioner is the claim of the petitioner is genuine, the authorities shall release the payment within a period of 2 weeks thereafter.
Identical matters are pending before your lordship's list. Item number 520, 521, 522. Let the matter is to be mentioned as your lordship has passed the order, since they are suffering. 520, 521 and 522.
Mention tomorrow, mention day after tomorrow.
I believe, my lord, my learned friend should give a service to the state before mention, so that it can represent it. Grateful, my lord. Grateful.
Inform.
My lord.
Come on Thursday, we'll see.
My lord, I'm grateful.
Next.
Okay.
My lord, I am for the petitioner. This is our every service. The matter, my lord, regarding my lord, tender. One tender notice has been issued by the Agri Mechanical Department, State of West Bengal, in the district Baharampur.
Where is the tender notice?
Tender notice is that my lord, page 35, my lord.
Yes.
There condition on that is 36, page 36, you kindly come to. Para
What is,
7.
what is the work? Invited on behalf
I
of
am the lowest bidder, my lord.
What is the work?
Work is the, my lord,
Renovation of the balloon major.
balloon.
Yes.
This is a mechanical thing, my lord.
Yes.
There, you kindly come to my 7, para 7, page 36, para 7, 3, 2, my lord. In a if the bid is made by a fund partnership, it shall be signed, digitally signed, all the partners of the fund by a partner holding power of daughter. That is the condition, my lord.
Yes.
I have participated and also submitted all the conditions.
You are the partnership firm.
Yes, my
No.
lord. You also kindly come to, my lord, page 53, my lord.
Page 53.
That is their letter dated 24th of November 2025.
Yes.
While checking the document submitted that home ato tender number ato, it was observed that you have submitted declaration non-judicial stamp wherein you have that wanted to carry business partnership firm in lieu of your existing proprietorship firm under same trade name style Pradeep Kumar Das. If you have declared new partnership firm, you have taken over asset and liabilities. That condition I have already submitted, my lord. Then my next page, my lord. You know, she kindly come to, my lord, page 54, my lord.
No. In view of the above, you are requested to you submitted the document.
Yes, my lord.
Yes.
That has already done, my lord. Then, my lord, I made representation before the authority in the next page, my lord. That is 8th of November 2025.
Yes.
In reference to I am declare I have not departmental order, that is their condition. If you next paragraph, if you have such order, I will request to scope gate of all the documents have followed, constitute partnership firm as per norms, constitution, partnership liability and other things, my lord. So I have, my lord, annexed all the things, my lord. You will kindly come to, my lord, previous documents, my lord. That is page, my lord, P1, page 18 onwards, my lord. That is the payment, my lord, enlistment.
18.
Enlistment, my lord. Yes.
Permanent certificate of enlistment,
Yes,
declaration.
Declaration, all the things, my lord, which partnership.
So what is the problem now?
Problem is that the authority not, my lord, accept this my documents, my lord.
Where is the rejection?
No rejection, my lord. That is pending, my lord. That may be considered, my lord.
What is the last date of the tender?
No, that is already over.
Over.
Yes,
Tender
ma'am.
issued.
Yes, no, not yet.
Not issued.
Fresh tender.
My lord, on the other hand, my lord,
a fresh tender should be invited because, my lord, what had happened?
That is not
petitioner. My lord, petitioner. That is the page 53. My lord, we wrote to the petitioner.
Yes.
To confirm whether the credentials in respect of the proprietorship firm has been converted into the partnership firm. That is not yet received from the department concerned. My lord, we have written a letter to the GST authority. Justice, kindly have a look to the letter. My lord, these are the records.
Which page?
That is page 35.
It is there in the page 35.
No, it is not there. It is not there.
It is there.
It is page 34 and 35. If your losses kindly have a page 34 and 35. We have written two letters. That is, my lord, first is 1st December 2025. Here we have asked for, there are two firms under the same trade name. Pradeep Kumar Das, out of these two firms, one is proprietary firm, GST number such and such. No, my lord. And another is partnership and a GST number different. So now he has applied for the for getting the job in respect of the proprietary firm by furnishing this GST number, second one, partnership GST number.
Which?
Right, 19 ABG.
IZV.
Right side, my lord.
Yes.
So previous partner proprietary firm still there, my lord, still is existing. Now, so far the credential is concerned, my lord, petitioner is saying that my previous credential should be converted into the proprietary firm and take it into consideration of that credentials.
That is
but
in the
no, my lord,
What
no,
is the answer?
now, my lord, the answer, let's say kindly, next page, no, not next page, page 38. My lord, it has been written by the GST authority to the executive engineer, the tender issuing authority. My lord, here, may I be permitted to read it? In this regard, it is intimated that Sri Pradeep Kumar Das, son of late Rohini Kumar Das, such and such, my lord, was the sole proprietor of the proprietorship firm being GST IN 19-ADY-PD-8525E125. He applied for cancellation of the said GST on 28/11/2025. That was after the tender is closed.
Correct.
On the ground of change in constitution of the business leading to the change of PAN. As per records available on the GST in portal, the status of the cancellation is showing the pending for processing. So it has not yet been changed, my lord, that previous. So now, so far the credential is concerned, his my lord, submission is, my lord, is not correct because he could not show his credentials so far to obtain the.
That is pending, my lord. That is not.
If that be so, until
that
and
is
unless
not, no communication has been sent, my lord. I have credentially that ownership firm converted to my lord partnership firm.
It
So
has not yet been
automatically
converted.
according to partnership act, my lord.
No, then you come to the paragraph page 39.
Page 39, yes, that is also next one.
Both partners had their willingness to start and carry the partnership business under the name and install of
My lord.
Pradeep Kumar Das. Accordingly, Sushanto Das had agreed to join the partnership firm and take over all the assets liability of
Yes, my lord.
as
Yes.
well as Pradeep Kumar. The GST and so and so was granted to the partnership firm with a yes. So what is the
Only
yes,
my lord, change of partnership has been granted. So, but so far the GST number has not yet been, my lord, changed.
But see, as per your requirement, if it is a partnership firm, they have to show the document and all these things. They have shown the document and they have given the GST. They have applied for cancellation. Now the GST authorities already granted the GST number. Correct. Once GST number. So once this GST number, so you are not concerned with the other GST.
No, that is, my lord, correct, my lord. So far the other GST number is concerned, but that credential is still there. That GST
Maybe
has needed, but so far the present.
Where is the terms and conditions?
Yes,
The pump cannot contain the two GST number.
My lord, I'm showing you. If you losses, kindly have a look to.
There are two sister concern. There
No, my lord, page 104. My lord, losses, kindly flag M.
104 of here.
Yes, my lord. This is our Central Goods and Service Tax Act 2000. Central Goods and Service Tax Act 2017.
Correct.
My lord, serial number 4, clause 4,
Ah.
section 25, procedure for registration.
Hmm.
My lord, a person who has obtained or is required to obtain more than one registration, whether one in the state or union territory, more than one state or union territory, shall in respect of each other registration be treated as distinct person for the purpose of this act.
Correct.
And my lord, losses kindly thereafter losses kindly come to page 107,
Yes.
clause 23.
107 cross 23.
Last page, my lordship. Last page. Change in constitution of firm. This is also a same act. Clause 2, where the contractor is a partnership firm or a consortium, prior approval in writing of the engineer in charge shall be obtained for any change made in the constitution of the firm, consortium, where the contractor is an individual or Hindu, undivided family, business concern, such. Well, first, where the contractor or property partnership firm or a consortium, prior approval in writing of the engineer in charge shall be obtained for any change.
This is regard the pending contract.
Yes.
Engineer in charge will come subsequently if you have issued the work order and he is continuing the work and he wanted that this firm is to be changed in the name of the other. Then the officer in charge has to give the no objection because there was some problem because one work order has been issued. Here, how this cross 23 will affect?
Only so far the credential is concerned, my lord. Now the present partnership business, they don't have any credentials.
What credential?
So for the whether they, well, that is the
What are the
condition of the,
credentials? Show me.
well,
What are
that is the condition of the terms and condition of the tender, lordship. Lordship kindly no clause 8.
Kindly come to clause 7.
Clause 8.
Just a minute. Let me.
Clause 8 of the in the writ petition, my lord. Lordship kindly
Page
have
number.
Page I'm showing you.
Page number.
My lord,
Page number 36.
Page 36. Page number 36.
In petition.
Eligibility criteria for participation in tender.
Ah.
To qualify for award of contract, each bidder in its name should have at least 5 years and has to fulfill all the
This.
Malad.
Tell this, he is not having the credential of 5 years
Malad, that is-
experience.
Yes, that is.
Not their intention, my lord.
No,
they are inquiring, my lord, that partnership, whether it is
That
partnership
is
firm or
correct,
not.
that is correct. But once you are the proprietorship firm,
Yes, my lord.
correct. After the tender, you wanted to become a partnership firm. You applied for cancellation of the earlier proprietorship.
All the credentials
coming
come
to
to
the
partnership firm. Yes, that's
partnership
the
firm,
condition.
all the goodwill and all these things. Now the GST authorities correctly given the report. Yes, that is processing is pending for
Malad.
cancellation, but new GST has already been given. So for that I am with you.
Yes.
That I am with you, because they cannot say, because once the GST has been given, so authority has nothing to do that whatever the correspondence, whatever the payment is to be made in regard to that GST,
Yes, ma'am.
new GST. The second GST will cancel, first GST will cancel or not, because the authority will act in terms of the new GST.
Malad.
Now the question is, once you have become a new partnership firm, whether how you can say you are a 5 years
Experience.
experience in terms of the 8-1.
Because, my lord, I have in the agreement, my lord, partnership agreement, all the credentials.
Maybe
Yes, my
that
lord.
partnership. Now that is the proprietorship.
Yes, my
The proprietorship has gone. Now the partnership.
But all the liabilities and other
Liability might be taken, but
Yes,
how
sir.
the experience partnership firm is to be taken.
But that is not his query, my lord.
Policy.
Yes, my lord. That is not
Award
his
the
query.
contract, each bidder in its name
Yes, my lord.
should have the last in its name. Now in its name with the partnership.
Yes.
Pradeep Kumar Das partnership firm.
Yes.
Partnership firm having the 8 years, the 5 years experience to fulfill the criteria.
yes,
That
my
is the only thing.
That is okay, but that is that they are not that query, my lord. You should kindly
No,
come
no,
to my lord. His
no, no.
intention, my lord.
Then Malad.
His letter, my lord.
Eight.
Letter, my lord.
Malad,
Kindly
8.
kindly your
one-
page 53, my lord.
Malad.
Their partnership, you should kindly come to my lord. That is they are not query, my lord. Because of you should some manipulation is there. You should kindly come. Yes, my lord.
Page 36.
While
Lord, kindly have it.
checking the documents, tender ato, it was observed that you have submitted non-judicial stamp wherein you have stated.
No, that's correct.
Yes, my lord.
But subsequently.
Absolutely, no letter has been issued, my lord. Then, my lord, how can it be? You should kindly come to my lord, CPWD, my lord, settle, my lord, some similar matter, my lord, they are allotting tender, my lord. Because, my lord, Pradip Das is, my lord, similar company. Because my health, my lord, I made, my lord, my son, my lord, as a partner, my lord. So, my lord, my experience, my lord, the name
No,
is same, my lord.
that's correct.
Yes, my lord.
Name Pradeep Kumar Das is correct.
Yes,
Now
well.
the Pradeep Kumar has become the partnership.
Malad.
Yes, my lord.
Whether the Pradeep
Because of
Kumar
illness, my lord. Because of illness, my lord.
might be.
Yes,
But
my
the Pradeep Kumar partnership with regard to your experience, how the partnership experience will be
Experience
taken into the consideration the
Because
proprietorship.
all the experience, all the name is same, my lord.
Yes, what is the content?
Malad, 8A and B, Lordship, page 36. Malad, that is also very.
36.
Yes, page 36.
Ah.
Eligibility criteria. Malad, 8A,
Ah.
credential of similar nature of work, intending tender shall have to produce credential of a similar nature of completed works. of
Correct.
a
That's
minimum- Yeah, that's the intent. Yes.
Because now he has come with the new partnership. The
Malad.
credential cannot be.
Yes, Malad. Malad, and Malad, the letter written by us, Malad.
This query, they are
That
query.
is not the query.
Malad,
But the
that is
court
not-
has to balance.
Malad, page 53, Lordships, kindly. You are requested to, Lordships, kindly, last page of the, not last page, page 53.
Yes.
Malad, you are requested to attach GO or departmental order, if any, which empower you to use your credential of proprietorship firm, GST in such and such. That is in respect
That
of the
is
property.
against him.
In favor of
Property
individual.
shame, my lord. I have property some experience, my lord.
No, no.
Then you yourself can
You are requested to attach the geo department.
Yes, my lord.
orders if any.
Property shame, firm.
In favor of newly created partnership firm.
That is
So previous GST and property share and their credential should be used by the present partnership firm.
yes.
There is no such order or any.
This query is different, my lord. You should kindly come to query that query 53, my lord. You have declared partnership firm over the asset liability in view of the fact you are requested to submit documents.
No, if you come to the page 53,
Yes.
you are requested to attach the geo.
Yes.
Government order or the departmental order, if any, which empowers you to use your credential of the proprietorship firm in favor of the newly created. So who will issue this credential?
Well, he has to obtain from the GST authority that he is empowered.
Then
Use the earlier credential.
liberty,
Otherwise,
liberty. Then
it's not
liberty to GST. You should kindly direct the
But
GST
now the new tender has been published.
No, Mala,
No,
not only
nothing
that.
has been done.
No, Mala, what has happened? After the tender is closed, thereafter he has applied for change of the
There is
GST.
close means?
I mean, there was some time that in tender.
There is close means what is your
Close
meaning?
means, well, after floating the tender, if the tender, interesting people submitted their tenders, after completion of entire scrutiny, if they do not comply with all those orders, there are certain times within that period.
I am telling what is the status of the this tender process.
No, Mala, it is already closed. No,
Where is the order? It is closed.
Order.
Mala, in the tender,
It is cancelled.
yes, Mala,
Where is that?
it is already closed.
Where is that?
Close or cancel.
Closed? How you can close? How you can close the tender?
No, Mala, there is certain time is fixed.
So,
Mala, that is
where is the order? Either you have to cancel. Which authority is
Mala,
this?
10 November 2025 to tender document.
Dated? Page number?
Yes, I'm just bringing in the tender paper. It is mentioned. Mala,
Tender paper, how can it be? It's a general order. If any cancellation is there, that cannot be.
no cancellation.
How can it
It
be
is already closed.
Where is that?
Close and cancel. This is a separate meaning, I think. That is my small knowledge.
What has happened to this tender? What is the last date of the tender?
That is Mala, page 7. Sorry, the page 7 of our documents, Mala. That is mentioned. Date and time schedule. Page 7. এটা না এটা না পিটিশনটা থেকে দেখো তো এখানে পিটিশনের আছে
12/11.
Date of that is
notified. Uploading the bidders. So what has happened after this?
Well, now, since only one tender is there.
Where is that order?
But that order is not with me. Only the statement is there.
Where is that?
That is on the front page.
That is government office, Malay Lordship.
Yes. Page 3. Page 3.
Where is that?
Amalaji, page 3. Later, it was detected that whereas the bid closing date was on 10/11/2025, the agency Pradeep Kumar Das applied for cancellation of GST of proprietorship firm on 20th/11/2012. That is after 18 days of the bid closing, on the ground of change in the constitution business. The process of cancellation is not yet completed, and status of cancellation is showing the pending for GST portal.
What is the status of the tender?
Well, at present, as I understand.
My instruction, Mala, this is still pending. Mala. Still exists, Mala, because Mala.
So you file a
I shall
report.
bring. I shall.
To file the report. When?
As you Mala.
At the Leonard Council for the party.
So, Mala, GST report also, Mala.
There is IT persons.
Sound টা কমিয়ে দিও।
না না কোথাও এটা
At the Leonard Council for the
Sparking,
respective
spark
parties
হচ্ছে
at length. This court find that a report is required to be filed by the authorities specifying that what is the status of the tender process at present. Let the report be filed by
2 weeks, Mala.
No, also, Mala,
one. It is a district Murshidabad.
By 12th of February 2026, after serving the copy to the Land Council for the petitioner, let the matter appear on 13th February.
Your Lordship, one indulgence may be taken into consideration. One GST, which GST authority state has taken into consideration by later, that can be valid also. Malad.
That I will consider.
Yes, Malad. Can it make some?
Must the status come? Yes, call the.
That document.
Let it be
As
next.
Hold on.
is my affidavit of service, my lord. Affidavit of service, my lord.
Yes, what is the prayer?
Unemployment allowance.
Unemployment allowance.
Kindly come to my pair.
Unemployment allowance.
Kindly come to my pair.
Yes.
B.
B.
B. A writ in the nature of such and such.
Allot work to the petitioner
Is it
under 2006
allot work to the petitioner.
or in the alternative unemployment allowance to the petitioner under section 7 of
Scheme
11
or to provide unemployment allowances to the petitioner.
Yes.
Under section 7, 2005.
Where is the scheme?
Scheme. Pardon me, my lord. Scheme. My lord, kindly. Wait, 7 is 12. Wait.
105. Come to 105.
My lord.
Come to 105.
105 of my. Yes, my lord. This is.
You have not read the brief.
My
The
lord,
court has read the brief.
I have read it. I have read it, my lord. Pardon me. My lord, this is section 7, that's a notification. And
Yes, what is your intent? What is your stand?
My lord, kindly appreciate this. My lord, only one preliminary objection. There are 10 writ petitioners. Whether they have, yes, whether they have paid court fee for each and every writ petitioner, my lord, I don't know. Be that as it may. Now, my lord, this is, yes. Now, my lord, this is practically seeking benefit under Manrega. So, my lord, here under this scheme, the government of India is though, my lord, few days back, my lord, there is an amendment. Now, Jiramji has come back. My lord, that is a different issue. This entire writ petition drafted on the pretext of Manrega, where central government is the authority to provide fund. My lord, our sole, my lord, humble submission before your lordship, unless there is an allotment of fund from the union, the state government not is in a position, the competent authority to guarantee work as sought for by the writ petitioner. My lord, this is the humble submission.
Kindly come to.
Why you have framed the scheme?
My lord,
Why you have framed the scheme if you are not
my lord,
having
this
the
is
fund,
this is
able to provide the
lordship
all these
kindly,
things?
lordship
Manrega
kindly.
is there. Manrega is there. Manrega is there. Just a minute.
My lord, this is not.
It is better you take both the brief and sit in the
proper.
My lord,
I
I
am
am
asking the question to him. Why you are
yes, my lord.
interfering that?
My lord, page 105. Your lordship. Yes, yes.
Question is that
Yes.
okay, Manrega is there, that is the central scheme.
My lord.
Then all the state and the union territory has to follow the scheme of the central government.
My lord.
Now above that Manrega scheme, you have framed this scheme by the
My lord.
state government.
My lord.
If the state government, where is the law that this scheme
My
will
lord.
depend upon the funds of the central government?
My lord, kindly seize page 105. Your
Yes.
lordship has been pleased to, my lord.
I am there only.
My lord, Act means Mahatma Gandhi National Rural Employment Guarantee Act.
Correct.
That is definition 2A. So, my lord, under this act, this is a notification which has to be given a force, my lord, under this particular provision. So, under this act, subject to correction, the central government, the state is only the disbursing authority. The government of India has to. My lord, the definition.
Okay, you do one thing. You
my,
file affidavit.
my lord, that
is
but
the
my,
only.
my lord, subject to correction, my lord, in this matter, my lord, actually now today this is not in force because, my lord, there is, my lord, the new law has taken the field. So, my lord, subject to correction, now there is a, my lord, my lord, the liability and or onus upon the state.
So whether you adopted the Jiramji?
No, my lord, that has to be, my lord, regarding that aspect, I have to take instruction. But, my lord, the subject remains.
That's what I'm telling.
Yes.
If you adopted the Jiramji,
no,
then it has to be either repealed or it has to be amended.
My lord,
Correct.
My
If
lord.
if you are not adopted the G,
My lord.
then you have to take appropriate
My lord.
decision.
But my lord, subject to correction, this writ petition has been drafted on the pretext
Basis of
of
this.
yes.
Correct. That's
My
what I'm
lord.
telling.
That is
the
Manrega.
pretext of that.
So, my lord,
If you say that you are adopted the G,
no, my lord,
so
in,
the question of does not
my
arise.
lord, in respect of this writ petition, if your lordship wants me to come back with affidavit, I will come back with affidavit.
Yes, what is the answer?
My lord.
Come back with affidavit.
Let the file affidavit.
My lord.
This court find that the petitioner has
Short affidavit, your lordship.
My lord, short, long,
the petitioner has prayed for relief of the scheme.
उधर बोलता होगा पूरी
of 2006 and 2012. Scheme of 2012. Full stop. This court find that petition is to be disposed of only after exchange of affidavit. The respondents are directed to file affidavit in opposition within 2 weeks. 2 weeks.
My lord, 4 weeks.
Within 4 weeks.
My lord.
May I supplement?
Reply if any. Yes.
May I supplement? In respect of my lord, kindly come to my lord, the act itself stated.
Correct. I have gone
Mahatma
through.
Gandhi
Let they file the affidavit. Now the
but
circumstances.
interim measure, it has been stated in the my lord, rule section 7 and 11 and rule 3. There is a which I have stated in paragraph 4 and 5 for interim measure, interim order.
Correct. Now that's why I want whether they have adopted the G, then this cannot be taken into consideration.
It is in respect of when we have filed this.
File affidavit within 4 weeks. Reply if any there to be filed within 2 weeks thereafter. List the matter on 25th March and list the matter after 6 weeks under the adjourned motion.
Kindly fix the date, my lord. Kindly fix the date, my lord. Kindly fix the date.
That first affidavit completed. Okay, 25th March adjourned motion.
25th March.
Adjourned motion.
Deeply obliged, my lord. Deeply obliged.
Yes, next.
Fixed matter.
My lord, great.
Item number 9.
In this matter, for the respondent authorities led by learned ASG, but today the matter is speak, we have not been communicated. We are totally unprepared. Kindly takes the matter next week.
Why you persons are mentioning and not intimating?
I may just check. Milord, I am told, Milord, it was communicated. I will not get into
बंद करो इसका स्पीकर को. साउंड तो यहाँ से है ना, कहाँ से आवाज आ रहा है? वेयर इज द सिस्टम? तो यहाँ से तो जाएगा सिस्टम, इसका सिस्टम ऑफ करो. कहाँ से जाएगा फिर? Yes.
Milord, I have the communication, but I do not get into this, Milord. I leave it to your lordship. I can start today or I can come back. But Milord, there is some urgency at our end.
What is the matter? Central government policy, that has to be.
Milord, we have the service, Milord, with us.
Affidavit completed?
Yes, yes. So, Milord, I can start today. I can commence my argument or I leave it to your lordship.
When you will be available to, when you will argue, come?
But on 20th or 19th, whatever, subject to convenience.
20?
On 19th or 20th, subject to convenient of your lordship and my Latin friends also.
As per the prayer made by the counsel for the respondent, the case is adjourned. Let the matter, but specifics it will not. Then it come as
Milord, we'll wait for our turn. Milord, kindly find out a date when my lord can. Milord,
then it will go to the April.
Milord will come. April. Come back, Milord, in April. Come back in April.
Let the matter April का एक डेट दे दो. हियरिंग क्या 2 बजे का.
Look.
5th April at 2 p.m. as specific.
19th. 5th April.
Next. 5th April Sunday আছে. 6th April খালি আছে. 7th. 7th April. At 2 p.m. especially fixed. Next.
May there be a peremptory line so that we can show our face to our client.
It is made clear that on the date fixed, no adjournment shall be granted.
So grateful. At least we can save our face to the client. Grateful to your lordship.
Next.
Item number 18. Item 18.
Hey, vote ठीक करो, 18 करो. कोई আছে নাকি? Every day she's crying here. Now the matter is listed, she's not here. Huh?
As none appears on behalf of the House. The matter is registered as urgent motion on the prayer made by the council.
But when the matter is called, none appears on behalf of the petitioner. Let the matter appear in the combined monthly list of March 2026.
Item number 19.
State.
Yes.
My lord, on behalf of the petitioner, the case of the petitioner, my lord, is that.
Why? Application আছে? Who are you? Who are you?
I'm not the applicant because your lordship, I'm the de facto complainant, your lordship. On the basis of my complaint, the account of the petition has been freezed. On the while filing the petition, your lordship, being the de facto complaint, I was not made a party, your lordship.
Okay. I will hear you, no problem. You are applying for the state.
Yes, my lord, on behalf of the petitioner, and the writ petition is solely for the direction upon the State Bank of India, who has frozen the accounts. So the case of the petitioner, my lord, is that.
Who is for the bank?
The case of the petitioner, my lord, is that there is a blanket freeze on his entire account, which happens to be his salary account by the SBI in strength of a notice from the investigation agency. Dated 16/3/2025, and the entire bank account has been frozen. So this causes an harassment to the petitioner, and of course, my lord, this is a settled principle of law. For a prolonged span of time, the blanket freeze cannot happen. Only the disputed amount can be freezed, but not a blanket freeze. And even after multiple guidelines and judgments from this honorable court, the apex court, across the country, multiple high courts, this is still the same matter is going on, and is unnecessarily burdening the higher judiciary of the country. Now, my lord, kindly comes to page number 58, my lord, annexure P8.
58.
Page number 58, my lord, annexure P8.
Yes.
This is the notice sent by the investigation agency.
Rampur Station, Chandrapur Police Commissioner. To whom it has been given? To the bank manager.
To the branch manager.
Correct.
Yeah. So the disputed amounts has been highlighted in the table format, and the cumulative amount comes up to 3,47,000. However, the entire bank account has been frozen. Now, my lord, the petitioner requires an immediate hospitalization. I have the medical advice from his consulting doctor. Because of this, the petitioner is not able to avail any treatments. Besides, there are other hardships like the family expenses, educational expenses of his kids, and everything else. The entire salary account being frozen is almost financially disabled, and that too from March 2025, my lord.
Yes.
So the only prayer before my lord is that if it is in the new motion stage.
Have you served the notice to State Bank of India?
Everybody. This is the affidavit of service, my lord.
judicial orders cannot be challenged in writ. And in so far as the investigating agency steps, overaction, inaction are concerned, that should go before probably the other bench, my lord. And even if your lordships are pleased to take this up, the point has been settled and allowed to be finalized by the petitioners when they have not preferred a challenge against the order appearing at page number 56. That is my submission.
My lord, to continue with the submission, it is definitely a settled principle of law. However, there are Supreme Court judgments, I have it the copy as well, where it specifically states, since my prayer is against the bank, who...
Kindly come to the 107 and 108 of the BNSS. Kindly come to the 107, 108 of the BNSS. If you would have not been before the magistrate, it is sure not the case that this freezer has been done without the order of the magistrate. Whether the investigating officer has taken the order from the magistrate or defreezing under 108, that would have been your benefit. But you approach the magistrate and magistrate has upheld the freezing. So that amounts to the order of the magistrate. Once the order of the magistrate is 108, so then you either you have to challenge the magistrate order on the revision. This sitting in the writ court, the court cannot challenge, cannot pass. And once this court has gone, have been pointed out by the state authority, the magistrate has upheld the seizure of the police authority. So this writ court cannot. We have a division bench order of the Bombay High Court on the Bombay High Court.
Division bench order of the Bombay High Court was later revised by the Supreme Court, my lord. That is one part. The other part, my lord, the order of the magistrate, as correctly pointed out, that is a non-speaking order, one-liner.
So you go to challenge in the revision
One part.
application.
The other part, my lord, since our prayer is specifically again, on the bank,
Correct,
the respondent in the bank. So the writ still
that's why I
lies.
appreciate. If there will be no order of the magistrate, then this court would have been invoked the jurisdiction of 226 and taking into consideration of 108, 107 and 108 can pass an order if the authority is not bringing any order that they got the freeze in terms of the 108 or 107. But here now you have already taken a step before the magistrate and act of the authority have been upheld by the London magistrate. So once the London magistrate order is there, the writ jurisdiction cannot invoke. Either you go to the revisional application or whatever it is as per the law.
My lord, with my lord's indulgence. So there are two Supreme Court judgments that I have, which specifically talks about. This is paragraph number 7. Once the cognizance is not taken, the writ, before I go into that, either the writ court has a power for judicial reviews as well, or there is a power under 401, 482 CRPC. Now, relevant sections of the BNSS.
I hate to interject, Lord, but
challenge the proceeding.
Agreed. But now,
I hate to
once
interject, Lord, but if I can get at least the citation, Lord.
Cognizance, unless the cognizance is taken by the lower court.
Manso versus State of Uttar Pradesh. 2025 INSC 8. 2025 INSC 8.
My lord, so once a cognizance is not taken, then Supreme Court still says the court has a concurrent jurisdiction. So since it is a case which is pending since 2025 March, and he requires an urgent hospitalization, looking into the holistically the situation, my lord, if my lord is pleased to intervene, my lord.
If you're agreed, I will give you a liberty. You go and challenge before the revisional court. I will give you liberty. That will be better. If you want, the court has to dispose of on merit, then I will dispose of the merit. I don't know what order will be.
My lord, with your folded hand prayers before my lord, the only challenge here, this person requires immediate hospitalization.
I have totally 90% with you.
And then again,
but that 10% which you have done your work as a Kalidas by making an application before the magistrate. Once the magistrate order is there confirming the freezer order, act of the freezer. So this court has no jurisdiction.
My lord still says that 226, 227 has a supervisory power as long as cognizance is not taken.
No. You have not challenged the proceedings. You have challenged only with regard to the act of the authority for freezing. And that you have taken your recourse before the London magistrate for filing an application for defreezing. And London magistrate has rejected your application.
Without a speaking order, unfortunately.
Rejected. So you have an authority. This magistrate has passed. So you have an authority of the two. Either you go to the sessions judge.
That limitation
or
also
to the
the
High
head. Yeah, all the High Court.
If I am not wrong, if the law has not been changed within 5 years.
That
So
is the
these
law,
are
my
the two things.
My lord, agreed, my lord. So the only prayer before my lord is some relief, at least to the extent that the disputed amount be kept in lien.
I
The
could have
blanket-
granted, but the magistrate order is not there.
Let the blanket protection, the
This court hand is tight. Nowadays it is
226, 227 court has powers.
I am not telling. Even 226, you can file an application for quashing of the proceeding.
Agreed, my lord. Agreed, my lord.
Challenge that.
Agreed. But under 227, you can also be a supervisory authority to the magistrate if the magistrate's order is wrong. So under such circumstance, my lord, if the
but this court cannot invoke this supervisory procedure under the revisional jurisdiction. Under the revision jurisdiction.
Some relief, is it not possible, my lord? Because at least lien be fixed for 3,47,000. But
correct.
rest of the amount at least be the blanket.
That would have been the order if there is no order of the magistrate. That's why I have not taken the can application that I wanted to hear as a whole. But your state authorities have pointed out the one thing which is totally against you. You file it, no problem. I will hear
Again,
it
it will be taking a there is a procedural delay.
Nothing. Hearing only. The petitioner has filed the present application praying for a direction upon the bank to defreeze the bank account of the petitioner. Bank account of the petitioner. Police. Counsel for the petitioner has drawn the attention of this court to the notice issued by the Sub-Inspector of Police, Srirampur Police Station under the Chandan Nagar Police Commissioner, West Bengal, to the branch manager, State Bank of India. Which Adgong? What is the branch manager?
Hathigaon branch. SBI Hathigaon branch.
Okay. Police.
Hathigaon
Where?
Charani branch.
Charani branch. Wherein the police authority has requested the bank for freezing of the account of the petitioner. Police. Counsel for the petitioner submits that the petitioner has made the request to the bank authority for defreezing the account, but that has not been defreezed. The petitioner has relied upon the judgment, unreported judgment in the case of Messrs. Naveen Brothers Private Limited versus ICICI Bank Limited and others, passed in WPO/2898/2022, dated 22nd of November 2022, wherein the coordinate bench of this court has allowed the writ petition by directing the respondent bank to forthwith lift the deficit freeze of the petitioner's account. Counsel for the petition submit that the petitioner is also squarely applicable. The order, the judgment, unreported judgment is squarely applicable in the present case and praying for the similar order. Learned counsel for the state authority has submit that the petitioner has made an application before the Additional Chief Judicial Magistrate Srirampur Hooghly, praying for a direction upon the investigating officer for defreezing of the account of the petitioner. The application filed by the petitioner was taken up for hearing by the London magistrate on 6th of August 2025, and after hearing the party, the London magistrate has rejected the application of the petitioner on the ground that for the purpose of investigation of the case, it is not proper for defreezing the account of the petitioner. Police. So, what is the good name, sir? So, submit that. He has also filed an application being Can 1 of 2026, praying for addition of parties as the case has been initiated by the police on his complaint, and he is the de facto complainant and is the interested person in the matter. Police. At the London Council for the respective parties, this court finds that after the police has initiated a case on the basis of the complaint made by made by one Mustafa. Who are you? One Pranajit Das. He is the complainant.
Yes, sir.
One Pranajit Das, who is the applicant in CAN number 1 of 2026. During the investigation, the police has found that the account of the petitioner is involved in the matter, and accordingly, the investigating agency has requested the bank to freeze the account of the petitioner. The petitioner has filed an application before the magistrate for defreezing the account, but as per the objection raised by the investigating officer, the request of the petitioner was rejected. Considering the above facts and circumstances, this court finds that once the jurisdictional magistrate has passed an order for rejecting the claim of the petitioner for defreezing the amount and defreezing the account of the petitioner, and as such, the petitioner cannot invoke the writ jurisdiction, and the petitioner is having the alternative remedy to challenge the order of the magistrate before the appropriate forum. Accordingly, writ petition is dismissed. However, the dismissal of the writ petition will not prevent the petitioner for taking appropriate steps before the appropriate forum by challenging the order passed by the
Well, your indulgence once,
can dispose. Can
there are
also dispose.
other judgments of the Madras High Court and the Kerala High Court that I'm having who have actually agreed to take these matters in WPA. Considering the circumstance, the critical health circumstance only, is it not possible, my lord, to reconsider? So the liberty be given at least so that I can...
Already given. Not prevent you to take appropriate step before the appropriate forum.
Grateful. Grateful.
ठीक है चलने वो बाद में call the next matter.
I am for the petitioner in this matter. What happened in this matter? Yes. My lord, in respect of carrying out the SAN, the appropriate authority appointed by the government issued a challan, page 18.
Page
18 of the writ petition.
18.
Yes.
Yes.
But can you see?
11/11/25.
Yes. They have
700 cubic feet.
They have specified the time. 11/11/2025 2:10 a.m. and validity till 2:10 p.m. Suppose a vehicle is coming from Jhargram to Kolkata. Well, there are national highway. In the national highway, as per the whims and fancies of the police department, sometimes they are making a no entry board. In respect of political parties meeting, they also paste up the no entry board. Now, when the vehicles are coming, they have nothing way to, either they have to come by Durgapur Expressway or Delhi Road. But I am also coming from Srinagar. Most of the time, they have passed a no entry board. Now, rightly or wrongly, my challan has expired.
So this challan was valid up till 2:10 p.m.
Yes, 2:10 p.m.
Yes.
Because of the stock up in the national highway, in sometime repairing work and other things, that vehicle could not come in a proper time. Now, as per their version, you have no valid e-challan. Now, I made a representative when I have again go to the particular place in respect of taking the SAN, I have seen that my entire e-challan portal has been locked by the authority. I also made a representation.
Where is the block order?
Well, they have issued a notice. Kindly come to page 23.
23?
Yes. Here they are saying it appears from the enforcement case details number so and so that a violation case is being initiated for extended expired challan against the vehicle number so and so. It is a violation of West Bengal Mineral and Concession Act. Therefore, I have to appear before the undersigned.
Yes.
Now that in respect of 4 vehicles, they have issued a challan. Now, my lord, the identical case has moved before this honorable court. Page 27 is the order, and my lord also passed an order. I also paper a representation before the authority, page 37. To
What is the
unblock the.
prayer?
Pardon, my lord.
What is the prayer?
My prayer before your lordship, my lord, that
was the
in respect of the blocking of the e-challan regarding the validity some time is not a valid ground for blocking the e-challan portal in respect of, because of this fact, my lord, these particular vehicles are not been able to carry out the riverbed SAM. Despite depositing all the fees and despite comply with all formalities in terms of the particular act.
Yes.
Now, last occasion, they have submitted a report before your lordships.
Yes.
My lord, kindly see the notice. It is their report, my lord. They have stated the hearing should be scheduled on 4/12/2025. In the report. That also I have disclosed. But, my lord, kindly come to their report, page 14.
Yes.
They have fixed the date on 22/12/2025. Now they have passed an order of 22/12/2025. My submission before the lordships, where is the notice they have communicated the present petitioner that a hearing will be taken place on 26/12. Last occasion, Manada directed to produce the original tag report. Next case, Manada, I have got a tag report that after order is passed, they have served the notice.
Yes, 4/12, the notice was served.
Yes, my lord. Your lordship, my lord, last occasion,
They have to-
directed me, my lord, that I have to produce the, my lord, all the original relevant records. To not show your lordship, my lord, that the entire, my lord, that the both the notice.
No, that's why I want the 26/11/2025, the matter.
2025 and
The matter was taken up for hearing and fixed the matter on.
They did not appear. Then the second notice was served upon them, 12/12/2025. That was also served upon them, they did not appear. And regarding that, my lord, postal receipt, as well as my lord, delivery report, tag report, I am producing before the original language, my lord, of authenticate copy. My lord, this is the authenticate copy, my lord. I am not getting, I have got it in order to, my lord, kept it on record. Keep it on record.
But in the report, I have seen they have passed an order. They have to.
Report on, my lord, regarding the postal receipt, my lord, it has been, my lord, marked and in the tag by, my lord, tracking that same, I have
Yes.
shown this. Regarding delivery report, my lord, I have given the, my lord, track report. Both the notice we have issued to them in all the vehicles, in connection to all the vehicles. In
No,
last
so
occasion,
the
they-
notice was issued to the vehicle owner.
Vehicle owner.
Correct.
Yes, sir.
Vehicle owner registration number WB33F0933. So which notice?
One vehicle, my lord, one vehicle is belong to his wife, one vehicle is belong to his husband. My lord, both husband belong to two vehicles and the wife belongs to, my lord,
No, that's why if we go by this, the vehicle first notice which you have disclosed, correct? Vehicle number WB33F0933.
Yes.
So this notice, which notice has been served?
My lord, in one postal receipt,
Ah.
your lordship kindly see, my lord, sir, my lord, your lordship, I have given you lordship. Kindly come to page number, my lord.
2.
Page number 2.
Ah.
Page number 2, second column.
Ah.
That is, my lord, Fayaz
Ali.
4 to 5. My lord, postal receipt 4 to 5.
4 to 5, yes.
4 to 5. And
Yes.
then, my lord, Tahira Khatu.
Ah.
Postal receipt 439.
Ah.
Then your lordship kindly then come, my lord, 4 to 5. My lord, next is 439. First of all, your lordship kindly come Tahira Khatu, 439. That was delivered on, my lord, 5/12/2025. Delivery report.
Correct. So this was delivered on 5/12,
5/12.
and you passed an order on 4/12.
No. Then second notice was issued. Your lordship, then second issue.
Just a minute.
We have passed the order.
First is the 26/11.
26/11.
You fix on 4/12.
4/12.
4/12 notice was issued, but none appears. Then you fix on 22nd. So this notice was issued on 5th.
Then second notice was issued. Your lordship kindly come to extremely last page of my, my lord, authenticate report. Last page.
Page 24.
Page 10 of my authenticate report. Page 10 of my authenticate report, my lord.
Yes. Page 10.
Page 10.
Ah.
That is the second notice.
Ah.
That is Fayaz.
Correct.
12/25.
Correct.
Correct. That was delivered on, my lord, your lordship kindly come, my lord, 15/12.
Where is that?
Posted on 13/12. Delivery report. 15/12.
Where is that delivery
Page number
report?
8. Page number 8.
Page number 8 of?
Yes, sir. Two notices. One upon husband, one upon in both cases. First notice upon husband and wife. Second notice upon husband and wife. Two notices were delivered. That is one, my lord, 15/15, 15/12. And that is one of postal receipt number, my lord, 819. That is postal receipt number, my lord, 822.
In prior case, my lord, that is another one postal receipt and postal delivery report.
12-12.
Yes, my lord.
12-12. Yes.
15-12 and 12-12.
Correct. And the date was fixed on 22nd December.
December, on the date, my lord, expert order has been passed.
Yes.
They did not appear.
Yes.
First occasion, my lord, they vehemently,
Just a minute. Next.
That no notice.
I have enclosed the notice. Not that. I have enclosed the notice in a writ petition.
Yes.
Now the third question is, my lord, whether this order has been served upon me or not. The order of the district magistrate. 26/12. They can
You have
pass it.
challenged this order.
Yes. Malad,
You have challenged this order by
they have
enclosing
submitted on the
this.
report.
Huh?
They have submitted on the report. They have submitted the report before your lordships. But they have to communicate this order
Okay.
to the undersigned.
So, okay, I am disposing of this, giving a liberty to challenge this order
and communicate this same.
before the appropriate authority. Now, you have, and the report has been served, so you have received this. So, I am disposing of this order, this writ petition, giving liberty to challenge the order before the appropriate authority. Appeal.
No.
That is provision for under section 51.
No. That order is there. My lord has passed this order.
No, that is correct. But here after the notice you have not appeared and they have passed an order. Then you can challenge this.
Yeah, I
order
can
before the
challenge.
appropriate authority. The petitioner has filed the present date application praying for setting aside the impugned notice dated 26/11/2025, wherein the additional district magistrate and district land and land reform officer has initiated the case against the petitioner for violations of the challan issued to the petitioner. The case made out by the petitioner that the respondent authorities have blocked the challan of the petitioner without giving any notice and initiated the proceeding. And in the proceeding, the respondent authority have passed the order without giving an opportunity of hearing. This court has called for the report from the authorities. And as per the direction passed by this court, the learned counsel appearing for the authorities have produced the original record, wherein it found that in terms of the notice dated 26/11/2025, the additional district magistrate has fixed the case for hearing on 4th of December 2025. Accordingly, the authorities have served and sent a notice to the petitioner in its registered address. But the notice was served only on 5th of December 2025. On 4th of December 2025, the authorities have taken up the matter and adjourned the case as none appears on behalf of the petitioner. And again the matter was fixed on 22nd of December 2025. The authorities have again issued the notice to the petitioner by informing the date. Notice to the petitioner by speed post, informing the date of hearing on 22nd of December 2025. But the petitioner has not appeared before the authority, and the respondent and the additional district magistrate has passed the impugned order dated passed the order on 22nd of December 2025, imposing penalty of ₹1 lakh upon the petitioner. It is fine from the record, the notice issued by the authorities was duly served upon the petitioner on 12th of December 2025, but in spite of service of notice, the petitioner chose not to appear. And accordingly, the authority has passed the order on 22nd of December 2025, imposing penalty of ₹1 lakh upon the petitioner. Considering the above, this court finds that the authorities have issued the notice to the writ petitioner, but in spite of receipt of the notice, the writ petitioner failed to appear before the authority, and authority had no other alternative to pass. And accordingly, the authority passed the order dated 22nd of December 2020. Considering the above, this court finds that the authority have already passed an order on 22nd of December 2025 by imposing penalty of rupees 1 lakh upon the petitioner, and as such, the writ petition is disposed of, with the liberty to the petitioner to take appropriate steps in accordance with law, if any. Writ petition disposed of with the liberty to the petitioner if the petitioner intends to challenge the challenge the order dated 26/11/2020. 26 or 22?
26/12.
22.
No, 26/12/2020.
No, first order is 22nd. Yes. And then why is the 22nd December 2020 in accordance with? Disposed of with the giving liberty to the petitioner challenge the order dated 22nd/11/2020 December 2020 in accordance with WPS disposed. ये वापस कर. Original record is returned to the respondent. Original record produced by the learned counsel appearing for the respondent is returned to the respondent. Yes. That's all. All are same.
No, Maharaj. Second matter is very important matter. They are, I think, how they will prove that it has been served.
21.
Kindly come to page 18 is the e-challan of the writ petition. This e-challan was generated on 9/12/2025. But my submission is this,
page
18. My specific submission before lordship, before in blocking of the e-challan portal, they did not serve any notice.
18.
Page 18. Annexure P/2. Petition number 28721.
Yes.
Kindly see,
9/12/10/12. Yes.
Date of issue is 9/12/2025. My submission before your lordships, kindly see, my vicar has been blocked on 11/12/2025, page 19. These I have received from their portal. My specific submission before blocking, no opportunity, madam. Now I made a representation, page 20, before the additional district magistrate, P4.
Yes.
Thereafter, some similar order has been passed by your lordship and the coordinate bench. Now, last occasion, my lord, they have submitted a report. I do not know when the district magistrate has passed this order, but I have received one tag report, kindly see, when the item was delivered. The item delivered to Abhijit Maiti on 2/1/2026. I do not know, and lordship, can you see in their report, they have disclosed the hearing notice, my lord. Kindly come to page 14 of their report.
Yes.
Here, my lord, they have disclosed the hearing notice where it is stated that a hearing should be taken place on 26 December 2025 at 11:30 a.m.
Yes.
But kindly see the tag report which I have. I do not know when the order has been passed and whether any proper notice has been served along with the tag report. Lordship, kindly examine this thing.
Yes, sir.
In the report also, they did not disclose the original order.
17/12/2025. My lord, the kindly come to page 3 of the report.
Hmm.
It was served on, my lord, come to page 4. That is, my lord, the 1 to 3rd column. That is memo number such as the 7304, dated 17/12/2024. It was posted by speed post. And thereafter it was delivered on, my lord, the 29/12/2025, that is page 5. And next page, my lord, again, but a notice has been served on 30/12/2025 for the next hearing on 2026. And it was, my lord, the served on by the kind of page 7. That is 1, 2, 3, 4, 5. That is Abhijit Maiti on 30/12. On the same date, it was posted on 30/12/2025. And it was delivered on 2nd January of 2026.
Can you see the time? Can you see the time, my lord?
Page 8, my lord, time 2:59 p.m. 2nd January 2026.
Page 8.
Page 8.
Yes, 2nd January, 3:14 p.m.
9 p.m.
3:14 p.m.
In spite of
the notice, my lord, they did not come before the, my lord, before the competent authority, my lord, for hearing.
But the notice was served on 1st January. No, booked on when it was served?
It was received on
Delivered at 2:59 p.m. Correct. So, and when the order was passed?
that is the main thing.
When the order was passed?
Order was passed, my lord, the 17/12/2021, first hearing was, my lord, the notice was
So,
communicated 17/12.
where is the impugn order?
There is
Where is the impugn order?
Impugn order, my lord, the impugn order, my lord.
Where is the order passed by your authority?
My lord, this has not been disclosed about the when the order was passed. By the notice of hearing might be communicated to the authority.
Correct. That's why. See, the first is with regard to the first notice.
First notice was
17/12/2025, fixing the date on 26/12. Correct. But the notice was not served.
Notice was served, that is page 4.
Page 4, you have sent the notice on 17 December, but 17 December, and the notice was served on 29 December. So, but your case was fixed on 26 December. So, question of does not arise appearing. Then subsequently, what is the second notice you have issued on 30th December, fixing the date on 7th of January. So, this you have sent the notice on 30th December, which was received on 2nd of January. So, what has happened after that?
After that, my lord, they did not appear to notice for notice.
Correct. What is
by the authority.
no decision is taken?
By the authority.
So, if not taken, I will direct appear before the authority.
In terms of this order, page 22.
Yes.
Whether you are sure or not.
Sure, but this is the last instruction. That is, it appeared the notice was delivered on 2nd January 2026, and vehicle owner was absent on the sequel date on 2nd hearing. This is here for your kind information. So there is no recent order as passed by the authority.
No, this is 13 January. So thereafter no order is passed. So you appear before the authority.
And in terms of page 22 order, madam, I have disclosed the identical order, madam.
22.
Page 22 of the writ petition, annexed P by 5.
Okay. The petitioner has filed the present writ application praying for a direction upon the respondent authorities to unblock the e-challan of the vehicle of the petitioner. Counsel for the petitioner submit that the petitioner had the valid challan issued by the competent authority on 9/12/2025 at 8:40 p.m. to 10/12/2025 6:40 p.m. But during the validity of the challan, the authorities have blocked the challan of the petitioner, due to which block the challan of the petitioner. Full stop. Counsel for the petitioner submit that the authorities have blocked the challan of the petitioner without any notice and without giving any opportunity of hearing to the petitioner. And as such, he prayed for a direction upon the authority for unblock the challan so as to enable the petitioner to ply their vehicle. Learned counsel appearing for the respondent has submitted the report and submit that initially on 17th of December 2025, a notice was issued to the petitioner by fixing the date of hearing on 26th of December 2025. But the notice could not be, but the notice was served upon the petitioner only on 29 December 2025. Accordingly, the authorities have adjourned the case and fixed the matter on 7th of January 2026 and issued a fresh notice upon the petitioner on 30th and issued a fresh notice on 30th December 2025 by fixing the case of hearing on 7th of January 2025. We submit that the notice was again sent to the petitioner by speed post on 1st of January 2026, which was duly received by the petitioner on 2nd of January 2026. He submit that in spite of receipt of the notice, the petitioner failed to appear before the authority and the matter is still pending before the authority for taking appropriate decision. considering the submission made by the counsel for the parties and the report submitted by the authorities. This court find that after the blocking of the challan, authorities have initiated the case and issued the notice. The last date was fixed on 7th of January 2026, but the petitioner could not appear before the authority, and as such, the authorities have not taken any steps. In view of the above, the authorities are directed to fix another date, or can I fix the date here in now? Can I fix that date? 2 weeks. In view of the above, the authorities, the petitioner is directed to appear before the additional district magistrate and district land and land reform officer, Paschim Medinipur, on when you will appear?
After 2 weeks, madam.
I am fixing a date.
Yeah. After I receive the server copy.
On 18th of February at 2 p.m. At 2 p.m. At 2 p.m. At 2 p.m. and with all the documents, and the additional district magistrate, district land the officer is directed to pass appropriate hearing and pass appropriate order after giving an opportunity of hearing to the petitioner within a week from the date of appearance of the petition before the authority.
Authority should take into cognizance the server copy of this order, madam. Sometime, madam, they are.
You will get the order.
No, they are not.
Okay.
They are
The authorities are directed to act in accordance with the server copy. Disposed of, huh?
Well, I am for the petitioner against their police report, my lord. I am filing the objection in respect of the police report, with my Raleigh Penna submitted. Here in this case is, my lord, I am submitting what they have done. My lord, we are carrying out the riverbed sand from Jharkhand.
What you filed?
No, it is a petitioner version, my lord. Only they did not file any affidavit, my lord. Only they have submitted report. It is a petitioner version, my lord.
What is this?
They have submitted police report.
Police report is here.
Yes.
They were supposed to file exception.
Have you filed the exception?
Well, it is a. I have received the. No, yes, not. I have got a judgment and everything is there.
Okay.
But only I am submitting before a lordship, my lord, what they have done. But I am carrying out the
What is the case?
My case is, my lord, after producing the all valid documents. But my vehicles are carried out the riverbed sand from Jharkhand. But at the time of bringing the, my lord, kindly see the GST bill and challan in respect of carrying out the sand. Page 30 is the GST bill.
Correct.
And the government of India received the GST bill, and page 34 is the challan.
Correct.
By the appropriate authority appointed by the Jharkhand to West Bengal, my lord. Now, where the West Bengal police, my lord, when the brigade is crossing in the border area.
What is the prayer?
My prayer is this, my lord. The West Bengal police has got no jurisdiction to seize the vehicle or stuck up the vehicles when the appropriate government has issued a permission after taking the GST bill. Now, what they have done, my lord.
So how this court can take this matter? Police in non-action.
Now, police, no, this is not a case of police inaction, my lord. This is a case, my lord. They themselves violated the Minor Minerals Act. They can't stack up the vehicles. The vehicles are coming from the outside the state. Suppose the West Bengal government is sending the potato. If the Jharkhand, this is the challan I have produced, page 34. Page 34 is the challan, can you see? Issued by the appropriate authority appointed by the Jharkhand government, and the challan has
been. The date of the challan, vehicle number.
The vehicle number also can.
Where is the vehicle number?
Yes, other challans are there.
Where is the vehicle number?
This is the vehicle number they have stated, my lord. Can you see? Kolkata. The name of the, yes. Page 34.
Yes, 34.
The serial number, the name and address of the dealer, certain such. Home traders, name of the applicants, quantity sentence, vehicle number WB 33 L0889.
Where it is?
Malat page 34. Malat this side, Malat. Page 34, this side, Malat. Vehicle number has been.
Yes, vehicle number.
Yes.
WB 33L.
Yes, yes.
Yes, then
Malat.
so it is Home Traders.
Home trader appointed by the Jharkhand government because they are naturally generate the challan.
Correct. Then what is that?
Malat, when we are bringing this sand to the West Bengal, in the border area, their police has disturbed these vehicles and pick up this vehicle by demanding
Police seized your vehicle.
No, vehicle has been released.
Seized.
Vehicle has been released. Vehicle has been released. No
Correct.
problem is there.
Correct.
Whether the West Bengal government, West Bengal police has got authority to intercept these vehicles or not. Kindly come to page 3, my lord.
Page 3 of
my submission, my lord. The territorial jurisdiction loading point in Jharkhand.
correct.
The respondent West Bengal police authorities have no territorial jurisdiction to inquire into or determine the legality of a loading point situated within the state of Jharkhand.
Where from you are reading?
Malar, page 3 of my
Page 3.
page 3. The territorial jurisdiction, paragraph 5. Malar. The respondent West Bengal police authorities have no territorial jurisdiction to inquire into or determine the legality of a loading point situated within the state of Jharkhand in terms of section 177 of the Code of Criminal Procedure.
Correct.
1973. Every offences shall ordinarily be inquired into the tried by a court within whose the local jurisdiction it was committed. Where the government of Jharkhand, after examining all these things, Malan, after taking the GST from the vehicle owners, when we are carrying out the sand, whether this state has authority to harass this vehicle in such a manner, therefore, the right to livelihood is seriously affected in respect of that.
How many vehicles were seized?
5 vehicles.
So
Here
all the 5 vehicles were having the challan.
Yes, I have challan. Challan is there. All challans are there. Page 13. Can you see? The remaining challan I also.
One.
Yes, and page 13 in my report, Lordship, can you see all valid challans are there, issued by the approved authority, approved by the Jharkhand government.
So what has happened now? What is the status of the case?
Status of the case, they are not been allowed to.
Your vehicle has been released by whom?
By West Bengal Police.
Police has released.
Yeah,
So where is the sand?
But after taking the sand.
Where is the sand?
Sand they have taken. They have taken away. Sand they have taken, my lord. All challans are there.
So is there any case has been registered? What is the case? Where is the case?
Absolutely wrong thing is this one. This is violation of the constitution by decision of this Honorable Supreme Court.
5 drivers were arrested.
Sand without any challan.
Who says? Who says challan expired? There is no such clause of challan expired. Kindly see. Here there is no time has been mentioned. No time has been mentioned by the Jharkhand.
They have appeared, they release their vehicle, but sand is still lying.
Sand they have taken away. The police has entered, taken away the sand.
Application to the CGM for auction of the sand. If they fail to produce.
So you do one thing, Mr. Das.
Yes.
Case has been initiated that is pending before the London magistrate.
Yes.
You go and file an application for release of the sand.
No, one submission people lost it. Whether this can they?
Now that's why
they are releasing the sand.
Correct. Once the FIR is filed, you have not challenged this FIR for quashing. Please appreciate the situation. You have filed this case prior to whatever it is.
Yes.
Correct. Action of the authorities for seize the vehicle. Correct. Now the authorities have come with the report that vehicle were apprehended, found that you are not having the valid challan. That's why vehicle were apprehended, and they have uploaded. They have taken the sand and released the vehicle and initiated the FIR. FIR number is already there under section 303 within bracket 2 and 317 of the 2 of the BNSS. Correct.
I have correct. My
correct.
submission.
Now, if you are agreed with this act of the authority, the initiation of the case, then you have to either challenge this
But
FIR.
present situation is, my lord, now they have released the biggest, that is the subject matter of CGM. I am
Correct.
appreciating.
Correct.
But what they are done, my lord, not a single vehicle they are allowed to taking sand from the Jharkhand. That is the main thing.
That is
Not different issue.
How the
My lord, kindly see the order of the Honorable Apex Court in this respect. I have last
which
occasion I have
one?
handed over.
Justice decree.
Yes.
Justice decree order.
Yes. Kindly see, I am reading, my lord.
Ah.
They can't do like this.
Which paragraph?
So, well reason order has been passed by the Honorable Supreme Court that they, in the interstate transport, the authority cannot.
Which paragraph? Which paragraph?
Paragraph 42, Lord Sir, I am reading.
42. Yes.
It is in the context the word transportation and storage in section 23C are to be interpreted. Here the two words are used in the context of illegal mining. It is clear that it is the transportation and storage of illegal mining and not the mining of the minor minerals like sand, which is legal and backed by duly granted license, which can be regulated under the provision. Therefore, no power flows from the provision to make rule or regulating transport of the.
That's correct. That's why I'm telling Mr.
Now,
Mr.
Lord,
Mr. Das. Mr. Das, that's why I'm telling. Now, before you, there is an FIR. Legally or illegally, there is an FIR. Correct. Now, case has been initiated. This act, now police has initiated, the police of the state of West Bengal initiated the case for illegal transportation of the sand. Now the court is telling that if it has been
alleged illegal, but it is not.
That's why the case which they have initiated.
Yes.
Now the FIR has been initiated. So subject to correction, if you want, I will dispose of this application, giving a liberty to challenge the FIR before the appropriate authority.
That is true. That is one part. Another part is, my lord, they cannot restrict our vehicles in respect of.
But this is not the public interest litigation. This is with regard to the particular
litigation.
case.
Here, my prayer is, Lord, can you see the prayer of the writ petition, my lord?
Yes, I have seen.
I may be allowed to, because how my entire vehicles are on the loan, my lord. We have to pay the huge EMI in respect of that. Otherwise, my lord, I will be in the handicap. The bank will take up the vehicles. My prayer before your lordship that I may be allowed to carry out the sand.
Who? That's which sand?
Riverbed sand from the other state.
From others, who is restraining you?
They are restraining, my lord.
Unless and until if you are carrying the sand with the valid permit, with the valid document, who will restrain you?
Can you make it that thing? If the valid challan is there, they cannot restrict that.
The law is there. What is the necessity for recording that?
Situation is not a single vehicle has go to the Jharkhand and carrying out the sand. They cannot restrict me, my lord.
Mr. Das, unless and until if you satisfy the authority, you are a valid challan, nobody will restrain you.
Satisfy the authority. There is a valid challan.
That's why this challan, now the FIR is already initiated. You go and take all the plea before the London magistrate or in the appropriate forum, or you challenge the FIR.
Manoj Kaniki liberty, I have to challenge the inter FIR and process.
Yes, you challenge that.
Before the appropriate court.
The petitioner has filed the present application praying for a direction upon the district magistrate and district land reform officer Jhargram to allow the petitioners to carry the sand from the state of Jharkhand to the state of West Bengal. The specific allegation of the petitioner in the present application is that the petitioner is the registered owner of the vehicle and is carrying the sand from the state of Jharkhand to the state of West Bengal with valid challan. But the police authority of the state of West Bengal, without considering the challan of the petitioner, are not allowing the petitioner to carry to transport the sand. He further submitted that the police authorities have illegally seized the vehicle of the petitioners. One petitioner, two petitioners. Petitioners.
No, there are yes. No.
Of the three petitioners and have released the vehicle, but have kept the sand in their
three
custody.
petitioners are there. Three petitioners.
Yes.
Three
But
petitioners.
have kept the sand in their custody. He submitted that the petition is having the valid challan, but the authorities have not considered the challan produced by the petitioner. Per contra, an advocate appearing for the estate has submitted the report, wherefrom it reveals that the police authority of the state of West Bengal have apprehended the vehicle, and during the inquiry it was found that the petitioner was alleged to have been carrying the sand illegally without any valid permit. Accordingly, the police has initiated the case being FIR number 176 of 2025 dated 24/11/2025 under section 303 within bracket 2/317 within bracket 2 of the BNS 2003 and 2020-23 police stop. And the case is pending before the Learned Magistrate, Chief Judicial Magistrate, Jhargram police stop. He further submit that the vehicle has already been released, and the sand and the investigating officer has already made an application before the Learned Chief Judicial Magistrate for confiscation of the sand seized by the petitioner. Full stop. Considering the above, this court finds that already the police authorities have initiated a case against the petitioner for on the allegation.
They have already auctioned the sand. They have already auctioned the sand. It has
That's
been
why stated that. Yeah, bola? Initiated a case for the confiscation of the sand. Na? And this court finds that the police has already initiated a case against the petitioner for illegal transportation of the sand, and the case is pending before the London Magistrate. Thus, in the writ jurisdiction, the court cannot decide with regard to the legality whether the police has seized the vehicle and the sand of the petitioner legally or illegally. The petitioner has to take appropriate step before the appropriate court where the criminal case is pending. Accordingly, the writ petition is
and to give liberty
with the liberty to the petitioner to take appropriate step before the
instead of what dismiss, it will be disposed
again
of.
the case initiated
Disposed of.
The petition is disposed of with the liberty to the petitioner to take appropriate step before the appropriate forum against the case initiated by the police against the petitioner. Next.
Get.
You give it.
Though there was a direction to file report, I think because of recent development, this can be disposed of.
What?
EWS. Yes, ma'am. You will have to kindly look to my last order, first paragraph. The grievance now has been redressed by the authority themselves.
Redressed?
Yes, madam. To me, though it is not reflecting from the report, but from the website, I got this. Clause E.
Income and asset certificate of candidate belongs to economic
Of the relevant year, they have said. This can be disposed of in view of this.
I was coming running. We kept on.
Give the report, we kept it. All be happy.
On behalf of Police Recruitment Board and on behalf of my
the report submitted by the respondents be kept with the record. Full stop. Counsel for this petition submit that in terms of the notice dated 20 January. Dated, what is the date of the notice?
20th January 2000.
20 January 2024. The grievance of the petitioner has been fulfilled, wherein it is mentioned that inward comma income and asset certificate for candidates belongs to economically weaker section within bracket EWS, valid for the year 23-24 or onwards. As the petitioner has satisfied that the petitioner's grievance has been fulfilled, and thus no order can be passed in the present writ application, the writ application is disposed of.
Well, so far, item number 28, similar issues involved, but in that matter, they are yet to issue any notice.
Let us wait, they will issue the notice.
Kindly fixes a date after.
Let it be in the list. If they will not, then I will adjourn.
It may be taken up today.
Or you want the next week?
Next week.
28. You are Oh, that's why he is not there. If the other party will come with the any. Next.
May it please your lordship. Beg to appear on behalf of the petitioner. This has come up, my lord, pursuant to my lord's last order, where my lord the errant police officer, my lord, he was to file an affidavit. His personal appearance was dispensed with. He was to file
That case.
Yes, my lord.
According director. Who is appearing for the state?
And second
Yes.
is, my lord, submission of report by the Home Secretary and the DGP regarding, my lord, their requirements, my lord, for
obtaining permission,
etc.
For the state, I'm seeking some time for filing the report on behalf of the blood and see the para 7 of law.
Correct. That's right. And what about the
Report is ready with, I have served also.
which report?
Report filed by the
Officer concerned.
Not a report.
Yes.
So how soon you will file the report from the DGP and the Secretary Home?
Because I have consulted.
This order was passed when? December. Now we are on February. 2 months has been passed. After the election, then every day the petition will come.
They want to wait for, my lord, the model code of conduct, my lord, to come out.
That's why I'm telling. Once that been done, then every day the one application will come for the permission for holding election. They holding the meetings. That's why I wanted the guidelines be fixed so that that can be followed by the all authorities. So that this court can not be burdened with all these applications. So within 2 weeks, do. Here they are different.
If we will come up with them, serve them, they can mention the matter.
No. That's why if you give the 2 weeks, then only you will come. I will give the 3 weeks, then you will come for the action.
No, my lord, with regard to the affidavit that he has filed, my lord, I am filing. No, my lord, kindly takes it up separately, my lord.
Which one affidavit? This one?
This one, my lord. The SI, the Sub-Inspector of Police, who has filed it, my lord. But I say he has deliberately made false statements on oath, my lord. He has tried, by way of filing this particular affidavit, first of all, my lord, to vex the honorable court. Second is, my lord, it depicts extreme lack of solicitude, my lord, insofar as the dignity and majesty of court is concerned. He has made false statements which are at variance with the annexes also, my lord, that he has relied on. And the apology, he says that if the court feels that I have transgressed the authority, then I seek for
will take the matter along with let the report come.
But I am serving a copy of the. We have already served the reply.
Yes.
Today.
The respondent number 5 has filed the report, and the petition has filed reply to the report. Let the same be kept with the record. The learned counsel appearing for the state press for time to take instruction from the Director General of Police, West Bengal, as well as the Secretary Home of the West Bengal, State of West Bengal. In view of the submission made by the counsel for the respondent, the case is adjourned. Let the matter appear on on 24th February
24th
under the same heading.
But may it appear under the same heading?
Under the same heading.
24th, but if we take the period, but the election process has to be completed by the 5th of May, because otherwise, but it has to be completed as per the constitutional mandate. So there has to be a model code of conduct by then, my lord. So in effect, my lord, they are successful. Good for the lawyers. Grateful to you.
Please, your lordship, I appear for the petitioner.
Yes.
My lord's pleasure will be to kindly see my lord's previous order of 9th of January, my lord.
Yes.
Paragraph 2 and 4, my lord.
Verify the address. Have you served?
Yes, my lord. We have served, my lord. This is my lord.
Yes. Who is for the state?
My lord, Mr. Chatterjee was appearing for the state.
Appearing as a junior of Mr. Chatterjee.
That's why.
I have got instruction for deportation.
Depart.
There's a Bangladeshi citizen admittedly admitted his guilt. He has undergone the sentence. Now the question of
Yes. Who is appearing for the state? Yes. Where is the report? Which address provided to you? Huh? Come here, come here. Why? One day you will get the report. Which area do you want to reside?
Narayanpur, Rajarhat, Gopalpur.
Rajarhat, Gopalpur. So it is not possible.
District North 24 Parganas.
Yes, Mr. Chatterjee, why the report has not come?
So this is Park Street Police Station, I believe.
Park Street, Gopalpur.
অ্যাড্রেসটা আমরা দিয়েছিলাম সেটা হচ্ছে রাজারহাট নর্থ 24 পারগানাস
ইয়েতে দেওয়া হয়েছিল
চিঠি করে দিয়েছি
Next week.
There is a miscommunication because the respondent was Park Street Police Station. Time and again I have contacted Park Street. They did not let me know anything. I was little upset in fact about this, that they did not let me know. Now I find it's Mondamgam PS.
So I am fixing next week. Come with the report. So today we are on. So I am fixing on 11th. The Learned Council appearing for the state. Press for time to file report with regard to the genuineness of the address furnished by the petitioner. If the petitioner is released on bail. Full stop. Let the report be filed on 11th of February 2026. Let the matter appear on 11th February under the same heading. Deeply obliged. Deeply obliged. No, bail. Foreign national is in custody for last repayment. Next.
I am for the petitioner, Lordship. Lordship, last occasion, your Lordship directed the state to file a report in the form of affidavit. Form of affidavit. Lordship, kindly turn the order, Lordship.
Whatever is there, the contents is there.
Lordship, with a copy to us. Lordship, kindly turn the order sheet, Lordship. Right now, they are serving me. The Lordship, according to the authorities are directed not to proceed with that report. Let the meantime, the authorities are directed to file. Lordship, let me order.
Meeting, and there is only one bid received. That is why it is liable to be cancelled. The last.
On 13/11 AM, the prefix schedule was seated in the portal. Technical bid was opened and found only one bidder had participated in the tender. As there was a single bid, the last date of submission of bid, the tender process is liable to be cancelled. Yes.
Yes.
What remains?
If they cancel it, I don't mind, Lordship.
So you're cancelled.
That is the language.
No, liable to be cancelled.
Liable to be cancelled. Lordship, they had to cancel. No,
Whether
Lordship.
it's cancelled or not.
I do not know better.
So
It is liable to be cancelled.
So if I will record the cancel and tomorrow you will proceed with the matter, then it will be difficult.
And make it clear.
Huh?
Liable to be cancelled, only the language issue.
So you take instruction whether it is cancelled or not. Not to take the burden of the state on your shoulder without
Lordship.
I shall not take.
So
Language liable to be cancelled.
liable to be cancelled.
But not cancelled.
Whether it is cancelled or not.
That I remember.
So come tomorrow. When it is?
Next week.
Which area? Standard building backside.
Lordship.
Yes, government got it.
The counsel for the respondent has filed the report wherein it reveals that on opening of, as per the prefix schedule,
He has participated in the previous meeting.
so he is only one.
No, sir. Lordship,
Prefix schedule of e-tender portal.
I have not
The
participated in tender
technical bid
process.
was open and found that only one bidder had participated in the tender. And accordingly, the authorities of the view that the tender process is liable to be cancelled. but the learned counsel appearing for the state is not confirm whether the tender is cancelled or not. Accordingly, prays for time to take instruction. In view of the above, case is adjourned. Let the matter appear on 12th of February 2026 for taking instruction whether the tender is cancelled or not.
Interim order be extended, Lordship.
Under the same heading,
Interim order be extended.
interim order is continued till the next date of court.
Lordship, may I please permitted to say something, Lordship? I'm extremely sorry. In spite of that, I'm here, Lordship. This is a tender matter, Lordship. As per Lordship direction, matter is appearing before the Lordship as an urgent motion under the heading urgent motion 296. 6 is the day.
6
submission of the
6 is the date. Please wait tomorrow. If it is not, you mention it. So today I have reached 25, 26.
Yes.
What is the number?
96 item number.
96. When is the opening date? Last date of the opening of the tender?
6 February.
6 February. Sure.
Yeah. Submission of the bid as well as the
कल के ना ये वाला मैटर को हाँ तक
number 11, where Lordship was pleased to direct the personal appearance. My Lord, we have, my Lord, the learned AG also we have just discussed, my Lord, I am on his behalf, my Lord. My Lord, I am not saying anything, only, my Lord, if my Lord gives us a week's time, my Lord, we have got a understanding, my Lord, that will be done within a week's time.
I have seen for the last 3 weeks of understanding of your state, of your finance secretary, of your advocate general, of yours and the other, but the understanding has gone in the.
But I bow down. I bow down. I only beseech your Lordship as your Lordship.
Let he come. Let he come. I will
As
also
your
see the face of this finance secretary who is having a guts to write this type of the letter to
Because,
the court.
my Lord, subject to
Very good. He is having a very good guts to write this letter.
Lordship, the dilemma of
Court is asking the amount to release and is telling that the petitioner may be asked to file a made an application to the authority.
My Lord, I bow down, my
This
Lord.
is the way of the your finance secretary to dealt with the order of the court.
My Lord, I appreciate, my Lord, Lordship understands, my Lord, only one thing, my Lord, our predicament, my Lord, one side, my Lord, we are the officer of the court.
Yeah.
The other hand, my Lord, we are the creatures.
Sir, I was that side and for the authority for 5 years.
My Lord, I bow
I
down.
was never on the shoe of the authority.
My Lord, I bow down. I bow down.
I was never on the shoe of the authority.
But I can only
if
pray.
the court has said it has to be done, it has to be done.
My
if
Lord.
If you are not having guts, you could not appear on behalf of the authority. If you are not a guts to control the authority.
My Lord, Lordship appreciates, my Lord, sometimes we are the creatures of instruction, my Lord.
Nothing.
We try, my Lord, but as your Lordship.
Let him come. Let him come. I will teach him how to deal with the advocates of the panel advocates. I will teach the finance secretary. If it is not set aside by the high division bench, if my order is not set aside. If he will come before this court, I will teach him how the advocates is to be dealt with by the authority.
My Lord, we are, my Lord. I am
very short.
My Lord, Lordship understands our dilemma, my Lord. We are the officer of your Lordship, my Lord. At one hand, my Lord.
Call the letter.
Grateful.
This was mentioned at our instance. You know, this is challenging an NGP order regarding the Mandarmani hotels.
My Lord, before my learned friend start, my Lord, we have the respondent numbers 10 to 12. There is West Bengal Pollution Control Board. My Lord, I have served my learned friend almost a year and a half back. My Lord, may I just file the affidavit?
Reply file kore?
Na reply দেয়নি
reply দিইনি এটা কোথায় গেল
reply দেয়নি
reply দিইনি এটা
Have you received?
Yes, they have received. I have not received any reply.
Told I have received, I don't know, I haven't seen it.
I
am told if Mr. Bihani, no, of course, if he is there, then there is no question. I must have received it, but we have not given a reply. Arey na, arey bolecho dada এর থেকে বেশি
এটা তোদের কিনা দেয় সাকেত পান্ডে স্নেহা সিং ফর সাকেত পান্ডে
আমাদের এই কে রে received Sneha Singh advocate by Saket Pandey. No, this is not ours, Manoj.
Must have been changes of advocates because this is not very new, but if he wants, obviously, I'll give it to him right now again.
We just give a copy. And Milord, I was anyways, we had mentioned this yesterday. Your Lordship will recall, I have those orders. 4 identical matters are fixed on 24th of February. Same order is under this court. It's fixed on 24th.
At 2 p.m.
At 2 p.m. If this could also be tagged, that is also Mandarmani Hoteliers Association.
What is the number?
Yes, Milord, I'll just give the order, Milord. এরকম আরো কটা আছে all these your Lordship will see paragraph 3 and 4 2 separate matters are no another matter is mentioned. I'm told there are 2 more like this, same issue, same order, same hotels. I'm also a part of this Mandarmani Hoteliers Association. And in the meantime, if I could just give a reply to this, Milord.
One thing, I was making a request to my learned friend. But if he has got any other matter, then he's request to give a list to your Lordship.
I wish, but I don't have. I have only one.
Yes.
Kindly come, Lord, to the earlier order dated 25th August 2025.
Yes.
para 8.
Runs the business in accordance with the license, permission, consent established and operate issued by the competent authority.
In 2023, the stay order was obtained against demolition order. But they are running the business since then absolutely illegally. And this has to be implemented para 8. Because under the pollution control system, whosoever runs a hotel or any other thing, he has to apply for consent to operate and consent to establish every year. Otherwise, he cannot run the business. This part your lawsuit will kindly enforce. And whether the continuation of interim order is at all be made in view of this order.
Okay, my lord, I respond numbers 10 to 12. My instructions are we have not received an affidavit. If
But I tell you, Lordship, I will give it.
must have given, my lord, I don't want to get into that.
No.
If you could just give us a copy.
At that point of time.
Okay, whatever it is.
If you could just
So
give us a
the
copy,
matter has to be disposed.
please, my lord. On that day, the interim order is expiring today. It has been there from 2023. All the other matters, your lordship has extended the interim order till 24th. And if it could be taken up on that day itself.
Learned Counsel for the petitioner submit that, and the Learned Counsel for the respondent number 10, 11 and 12 have filed their affidavit in opposition. After serving the copy to the Learned Counsel for the petitioner. Counsel for the petitioner pressed for a week time to file affidavit in reply. Counsel for the petitioner further submits that the connected analogous matters are already fixed by this court on 24th of February 2026 and prayed for fixing this matter also on 24th of February 2026. The learned ASGI appearing for the Union of India submits that the petitioner is enjoying the interim order since the year 2023 in the premises.
No, this is with regard to my hotel.
The matter of the hotel of Sanjay Singh to the petitioner, WPA 2779 of
2023, and as said, the matter is to be disposed of as early as possible. In view of the submission made by the council.
That is our Mandarmani.
Mandarmani.
Hotel is our Mandarmani.
The submission made by the council for the parties. The petitioner given liberty to file affidavit in reply within a week from date. List the matter on 24th February 2026 along with another connected application being WPA 27403 of 2024 and 20015 of 2025 on 24th February at 2 p.m.
The interim order be extended.
Interim order is extended till 24th February.
On that day, Mr. Bihani will supply your lordship the instruction as to whether they were obtaining consent to operate and consent to operate.
It's in my affidavit. I'll make my.
I'll look at that and respond to it. Yes, certainly. Very grateful.
Next.
I appear for the petitioner. Well, the petitioner is aggrieved by the rejection of his tender bid. Well, the rejection may kindly seize your lordships at page 81 of your lordships, please. Well, here is my affidavit of service.
Your name is?
My lord, my name is
Biswanath
Laya.
Rejected due to insufficient credential.
Yes.
As per clause 4 of the instruction of the bid.
Right. My lord, your lordship will now find the clause 4 of the instruction of the bid is at page 30. The NIT starts at page 21.
Who is appearing for the state? You are appearing? Yes. Next.
The NIT starts at page 21 and page 30 starts the instruction to the bidders. My lord, has seen at page 81 the cause of rejection. Page 30, point number 4 is the cause that has been mentioned there. May I please, ma'am? Participation in more than one work. Any contractor can submit tenders for maximum 2 number of works in this NIT depending on his credentials and financial capabilities. Normally, separate completion certificate of 100% completed works is required to be submitted for participating in separate works under a particular ENIT. However, completion certificate for one particular work may be considered as eligibility for participation in maximum 2 number of serials of e-tender, provided requisite credentials of 2 such works to be added arithmetically satisfies the requirement in all respect out of 1 such completion certificate. If found the bidders violating the above terms and conditions for submissions of participations in the tenders, all his submissions will be summarily rejected. But what I understand,
normally the contractor submit maximum 2 numbers of the works.
Yes.
In NET depending on his credential and the financial capability.
Right.
Normally separate completion certificate 100% complete is required to be submitted participant separate works under the particular. However, completion certificate for one particular work may be considered as eligibility participation in maximum 2 numbers of the serials, provided requisite credential for 2 such works satisfy the requirement in yes.
Yes. Well, what I understand from this, my lord, that subject to corrections, that a tenderer may apply for 2 number of tenders, which the petitioner has done. At page 81 and 82 are 2 rejections. And his credentials will be valued at 100% of the earlier, of his earlier credentials. Yes. But the petitioner's credentials could be valued, my lord, based on his previous 1 credentials of 100% to the 2 credentials that he is seeking
out of 2.
Yes, my lord.
Out of 2.
Out of 2.
One is 100% completed work.
Yes.
Is required to be submitted.
Right.
Separate completion certificate 100% completed work is required to be submitted. Separate works under the NIT CC. One particular work may be considered eligibility.
Yes.
For participation in maximum 2.
Page number 43 onwards are my credentials. I am an very regular participants in tendered works in irrigation department. My lord, I will take your lordships to that. Before that, my lord, may I say this, that this instruction to bidders, this instructions to bidders at page 30.
Huh? Where is he? Okay, I am taking note. I will not pass order without hearing.
And my lord, what I have gathered is that this 100% credentials, seeking of 100% credentials, perhaps was not right, given the earlier and the forthcoming tender works that the authorities have floated. It was 40% that the credentials could have been valued at. It is 100%. Although I have participated under this, this instructions, but
what certificate you have disclosed?
Page 43 onwards, kindly takes. My all previous certificates. 43 yes. Is the MSME certificates. Thereafter, the GST registrations, etc.
No, where is your experience certificate?
Yes.
No, work completed certificate of 2.
Yes. My lord, will takes at page 50. Excellent.
(67B).
My lord, I stand corrected, my lord. It starts from 67. B. Extremely grateful to your lordships. My lord, Water Resource Investigation Department. This is a completion certificate of dated 2021.
What is the work?
My lord, the work is
Construction of water detention structure. And what is the
And
work
this
here?
this work is, my lord, re-excavation of an existing dam. My lord, will takes at page 19 the NIT. 19, no, 21.
Re-excavation of
My lord, column number 3, re-excavation of Chitarman Barod Bad. And column number 5, serial number 5, re-excavation of Kotaldi Badaband.
and this construction of work detention structure. Ulda. Yes, then
Thereafter, my lord, page 67D. 18th November 2025. It is Gerur Band, construction of SFMIS. The authorities has, my lord, opined with a certificate at page 68. 68A, it's a block development work. My lord, 68B also, this is a certificate issued by the executive engineer.
yes. 68 then?
Well, at 68D.
Yes. Water detention structure.
I have been given the work, payment was made 69. 69A.
Whether this document was submitted by you?
Yes, my lord.
Along with your tender document.
But on instruction, I say, my lord, it was submitted. It is an online portal by which we had to submit, my lord. My lord, kindly take 70A. Excavation of 2 number of water harvesting structure. 2019.
Yes, 78.
Well, 70 capital A.
70A.
Yes, my lord. Yes.
Yes.
Serial 5. 81, 82. Well,
yes.
My lord, thereafter, kindly take 70 capital C. Zilla Parishad's tender. Well, each and every, all these documents, I say, my lord, were uploaded as my credentials to the authorities while having my bid placed before the authorities. And it is that the financial bid, but the financial bid is yet to be opened. My lord, I say, my lord, that I may be given an opportunity to at least get over this. I have the credentials. It is not that I have not have the credentials and I have not placed this on record.
Okay. That's all.
And just to add one more line, my lord, the authorities in subsequent tenders also have evaded the 100% part and have prefixed the 40% part that the authorities ought to have made, my lord. I have got those documents.
But you have to consider which
yes.
present. Yes. Yes, Mr. Sen.
my lord can first, my lord, straightway come to lordship once more. My lord, that two communication with regard to my lord the rejection. My lord,
81, 82.
yes, my lord, the out of 7 items, my lord, the petitioner participated in 2.
3 and
My
5.
lord, yes, 81 and 82.
Correct.
Now, my lord, in 81 and 82, if you lordship kindly come to my lord serial number 3, serial number 4, 81. My lord, the rejection is, my lord, rejected due to insufficient credential as per clause number 4 under instruction to bidders of the NIT. My lord, same rejection, lordship on 82 also in respect of other bid. Now, my lord, kindly come to my lord, the tender condition, NIT condition at page 23.
Yes.
Have you just got it, my lord? At
Yes.
page 20. Now, my lord, kindly come to page clause number 4.1.
Yes.
This is eligibility criteria for participation in tender.
Correct.
The prospective bidder shall have satisfactorily completed as a prime agency during 3rd November 2020 to till date at least one work of construction of surface flow minor irrigation scheme construction of WDS in any state, central government, state undertaking, statutory body constituted under the statute of the central state. This is important. Next, and having a magnitude of 40% of the estimated amount put to tender in a single work order. First, let us, my lord,
magnitude of 40% of the estimate amount
put to tender in a single work order. First of all, that 40% of the total work order, I mean not work order, the floated tender, total amount, value of the tender, 40% in one work, at least, he has to satisfy. That he has completed. Then it has to be read with. Then lordship kindly come to page 30.
participation.
Page 30, some relaxation. Page 30, instruction to bidders. Further instruction, or my lord can say it, rider. In addition to that, then again, lordship kindly come to 4. Clause number 4, participation in more than one work. My lord, may I pause here for a moment? If somebody, my lord, participates in one, my lord, the item, one work, then, my lord, 40% minimum in one particular similar work he has done on earlier occasion. 40% of the total value of the tender. Then some relaxation with regard to, suppose somebody, my lord, participated or wants to participate more than one, but not more than 2. It is, my lord, the prevented hearing. No. In 2, then what will? Participation in more than one work. Any contractor can submit tenders for maximum 2 number of works in this NIT, depending on his credential and financial capability. Now, my lord, he participated in 2. No problem. Then, my lord, Roman 2. Normally, separate completion certificates of 100% completed works is required to be submitted for participation in separate works under a particular NIT. May I pause here again? This, my lord, sentence says that so far that, my lord, that minimum, that 40% of the total value of the tender work you want to participate, you have to put it that yes, this is my credential certificate. More than 40% I have done in other. This is there. Then he said, so, and that should be one certificate, one work. Then say, however, this completion certificate for one particular work may be considered as eligibility for participation in maximum 2 numbers of serials of a e-work NIT, provided requisite credential for 2 such works to be added arithmetically satisfies the requirement in all respect out of 1 such CC. My lord, it means, suppose in one work, in 1 CC, what he wants to submit, my lord, it would be better if your lordship, my lord, kindly come to my lord, this, lordship, kindly come to this. আমি তোমায়ও দিচ্ছি, আমি দিচ্ছি তোমাকে, কেন এটা দুটো একটা, yes, কেন? My lord, it would be easier for. A tender has been called such and such out of 10 works. Lordship, kindly, my lord, straightway come to my lord 4. Para 4. Amount put to tender of serial number 3 he participated is rupees 67,49,000. Have you also got it, my?
Yes, yes.
And for serial number 5 he participated is rupees 78,36,000 odd.
Correct.
So if we take it, my lord, separately and distinctively, then he has to put the credential certificate 40% in one certificate, not collectively. 40% of that is, my lord, the second 5 paragraph. Credential required 40% of amount put to tender for both the participated works by adding arithmetically is rupees 58,34,491.
Credential required 40% of the amount put to
If
tender
it is one certificate.
for both participated work.
Yes, if it is one certificate, the relaxation that is given, if it is 1 CC,
correct,
that yes, I have done this, and this is my certificate, that is, my lord, more than 58,34,000, then it is okay.
Correct.
In one certificate,
so this will be a 40%.
One certificate covering more than 58 lakhs, it is okay. No problem with regard to both the job. 40% cover.
Yes.
Then 6, as per clause 4 under instruction to bidder, the completion certificate for one particular may be considered as eligibility for participation in maximum 2 numbers of serials as ENIT provided. Requisite credential for 2 such works to be added arithmetically satisfies the requirement in all respect out of 1 such CC. If found the bidder violating the above term, then my lord, now lordship kindly come to 7. Why it is rejected? 7. 4 credentials given by the petitioner.
Yes.
Whose amount is individually rupees 139.84 lakhs, 115.52 lakhs, 110.83 lakhs, and the remaining 3.19 lakhs, and 4 credentials given in the, my lord, this serially. Now, my lord, kindly consider one thing. Just, my lord, may I give an example? My lord, a huge, my lord, a multi-story building, suppose, my lord, huge multi-story comes up, my lord, and my lord, it appears that the total cost of the building may be, my lord, 200 crores. Now, my lord, the e-tender plate, and it is said that 40 or 50% of the total contract value or tender value, you have to give the certificate that you have done this. Now, 200 crores, 40% naturally, lordship kindly consider, suppose 80 lakhs. Suppose. Now, in the e-tender said that if in in one certificate, there should be at least 40%. If it appears, suppose, my lord, there are other projects, and e-tender contains other projects also, and said that very good. In one certificate, if it appears more than 40%, but if you put two certificates, then that will be added. Now, suppose, lordship, suppose one promoter comes and say, yes, 40% of 200 crores, then means 80 lakh.
So as per your
So suppose he says that, yes, I have done 10 buildings and the value 10 lakh, 20 lakhs, 30 lakhs, you add it and give me. But does it satisfy my lord, the requirement?
So correct. So as per
It does not satisfy because.
So as per the authorities' concern, though he had a certificate of 4 work, but
none of the certificate
has not
contains at least 40%.
40%, which contains the 58 lakhs.
Yes.
That is the con.
Because my lord, kindly come again. My lord, kindly come again. 40% of, suppose, my lord, the serial number 3.
Yes.
Total, my lord, the value 67 lakh 49,000. Have you lost got it, my lord?
Yes, yes.
Serial number 4.
Yes.
Against item number 3, total value 67 lakh 49,000.
Correct.
Now 40% of it, my lord, comes to
26.
my lord in the 58 lakhs 34,000. Because 6 crores 74 lakhs, sorry.
No, the 40% will 67 lakhs 49,000. That the 40% will come rupees 26 lakhs 99,741.
Yes,
40% will be 26 lakhs 99,700, and the 78 lakhs 40% would be, that is also not. It can't be. Yes, 31 lakh 34,700.
Yes.
So that's why it will total 58 lakh 44,000. 58 lakh 34,000.
26 lakhs 97,000 and 31 lakhs 34,000.
Correct.
Now, what he has submitted, the credential, let's see, kindly come to again.
Yes.
Serial number
One,
7.
one is the 39 lakh 84.
Yes. All below.
That 39 lakhs.
39.
Not 58 lakhs.
No, not 50.
None of the.
No.
That is a code.
Yes.
But I may be considered at least for serial number 3 then.
Which serial number 3?
Serial number 3 of your of the tender notice, which is amounting to rupees. My lord, just your lordship has calculated 67 lakhs. But my credentials is serial number 1 at page at paragraph 7, 39 lakhs. But it comes. But if serial number 3 is unilaterally held, 67 lakhs, then I come over the 40% mark. I may be considered. I have made a representation to this effect only, that I may be.
Mr. Sen, if we come there, because 3 and 5.
Yes.
3 is 67 lakh 49,353.
Yes.
And as per your authorities calculation, the 40% will come rupees 26 lakh 99,041.
Right.
Now you come to the 7. He has given the 4 credential.
Yes.
So one credential is 39 lakhs 84. So 39 lakh 84 is within the 26 lakhs 99,000.
Yes.
No, that is true.
So singular
That is coming under the 26 lakhs 99,000.
But how at the present moment?
It is not that both the tender will 40,000, 40%. Each tender will be 40,000, 40%.
I have followed. I have followed. But the thing is this, that he relied upon this for 2, and my lord, it was my lord considered and rejected for 2. Now at this stage,
combined.
Yes, combined. Now at this stage, whether it can be segregated again, and we can go back to that stage again after this, when everything finalized, my lord.
take the financial bid has not yet been opened.
He has combined, okay, no problem, but he has given the certificate. If you are not found that in the 50th, serial number 35 is not come, but is coming under the purview of the one also, because you have given the total.
Yes.
54 lakhs.
Yes.
If not taken 54 lakh, then again he will come in both. He will be in both 39 lakhs.
If it is held
segregated,
unilaterally
be taken.
Then also I comes
in both
as per the tender.
Both it does not.
Why? Because you have not stated each tender. You have given, you kindly come to, you have quoted, you have issued the tender notice for the 10 works.
10 works.
10 works.
No, 10 works, but 3 it was not finalized. So far the 7, practically Lordship, it appears from my lord, whatever instruction I have handed over.
That's correct. See, that's why.
That 7, my lord, practically my lord,
the authority is considering the 58 lakhs with both. But that is not the condition.
No.
Condition is one.
Because he wanted to that. He submitted these documents for both. Both. He submitted for both.
Both.
And we have considered for both. Kindly, my lord, concern.
Correct.
And my lord, kindly come to again. My lord, that my lord, page number 30. Page number 30.
Yes, I am there only.
Yes. That normally separate completion certificate of 100% completed work is required to be submitted for participating in separate works under a particular NIT.
Correct.
However, CC for one particular work may be considered as eligibility for participation in maximum 2 number of serials.
Correct.
Provided requisite credentials for 2 such works.
Correct.
Satisfies the requirement in all respect out of 1 such CC.
Correct. 2 such work of the tenderer, not your. 2 such work, they have given the 4 such work.
Yes.
Out of the 4 such work, one is the 39 lakhs.
1 is 39.
One
That
is 39 lakhs. If suppose you are taking into consideration the 39 lakhs, any of the tender, so what is qualifying for one tender?
That, my lord, yes, 39.84.
Any of the tender is come, because 39 is less than both 40%. Either 29 lakhs or 31 lakhs. Because authority has given you instruction by calculating the both.
Yes.
54.
Yes.
The problem created by him because of this, because my lord, he submitted his credential for both.
Correct.
Item 3 and item 4.
Correct.
So authority, my lord, took into consideration in that way.
Even though
as per his, my lord, the participation
authority cannot decide their own. Authority could have been taken. Yes, this certificate has been taken. This certificate has been taken into consideration for one work. That's why this certificate cannot be taken into consideration of the.
Now, if it appears that he submits that, very good. At least one independent certificate carries more than 40%. Then that means I am qualified to that extent.
One work.
At least for one work.
One work.
I have. Then I have to take instruction. Also, kindly give me some time.
But not to finalize then. What is the condition as on?
It's just the technical bit that has been opened. Financial bit has
I think that the financial.
No, it has not. On instruction, I say, my
lord.
Not. My lord, kindly, and my lord, at your lordship's kind reference, if I read once again that line, NIT at page 30, NIT provided requisite credentials for 2 such works. It is yes, it is my credentials.
Yeah, that's what I'm telling.
Yes.
Because
it is not their NITs.
No, that's why the authorities have given the interpretation to Mr. Sen.
Yes,
it is
the other way
both.
around.
It is both.
Yes.
That's why they have come with the 58 lakhs.
Probably that was not the correct interpretation.
No. Because, my lord, according
yes,
to my lord,
given the certificate jointly.
Way of participation, and my lord, they have put their paper in this way that these are the credentials for my both. So we took up the matter in that way, in both. Now he says that I can give up one. Now he says that I can give up one.
No, but Mr. Sen, again you consider.
Yes.
Leave, this is the, you have given the combined e-tender notice. And he has participated in, given the total combined 4 certificate or 5 certificate. Leave, that is an. Suppose, for the same work, you have issued 2 separate tender. You have issued 2 separate tender. And he has used this certificate in this tender and this. So whether you can say, no, this document cannot be relied in.
Probably that is the, your lordship.
That's
This is that clause.
I have followed. The whole thing. Now he says that no, he can give up one.
No.
এখন দুটোই চাইবো দাদা।
না, দুটো চাইলে হবে না তো। In so far the tender condition, how can my lord, he can satisfy that he is entitled to both?
If it is no practically, if he'll go, if practically if he'll go,
what is not before us, not see kindly consider, he cannot. No, practically, may I tell? Practically, what is the difficulty is that we want to, my lord, those bidder actually, my lord, who can complete the job. So kindly consider, my lord, we have to find out the best, the fittest, the best, the fittest. So that is why, my lord, I say that, my lord, this certificate, one certificate, if it covers both, more than 40%, that means it covers both, then it is okay. That means you are really fittest person.
Interpretation of this.
But but that is why, my lord, it has the explained in this way that you cannot collectively say 15 lakhs, 15 lakhs, 15 lakhs. And my lord,
but the question is that, no, we cannot go by the authorities' interpretation. We have to interpret our own as per the legal terms. Because that's why I given the example. They have given the 10 work order in a single tender notice. So whether he can, and you are telling
that I have followed. What fell from your lordship is that so far that 39 lakhs odd is concerned, if it covers that, my lord, so far that, then, my lord, at least one certificate, because, my lord, it is, my lord.
Okay, take a second.
May I tell? It is in the tender condition that one certificate I have to accept for one item. Lordship, kindly. One certificate at a time for 2, no. That is, my lord, the mentioned herein. And lordship, tender condition, my lord knows that.
Whether I can dispose of here? Consider this,
yes. But yes, but not for both. My lord, not, but it does not appear. My lord, I want to draw your kind attention once again that one certificate for one job, but if that one certificate, my lord, it appears that the total quantum of the one certificate, it is above that, my lord, or covering 2, then only I can, my lord, take that, my lord, account with regard to 2. One certificate, if it covers more than 40%, then one certificate that is for that particular. Then he has to choose that in against which item, my lord, I have to take into consideration that item 3 or item 5.
No, then you can then you come to page 30.
Page 30.
Page 30 for II. Normally, separate completion certificate 100% completed is required to be submitted for participating in separate work
under a particular NIT. Separate works, so under a separate certificate in separate works. So kindly consider.
However,
normally,
completion certificate in one particular may be considered as eligible participant
maximum numbers of serial of e-tender you want may be considered eligible for participation.
So what is the meaning of that?
Provided. That is the provision.
No, what is the meaning? However, CC completion certificate one particular work may be considered as eligibility of participation in maximum 2 numbers of serials.
Of provided is the
provided requisite credential for 2 such work to be added arithmetically. Okay. Arithmetically.
Be added arithmetically satisfies.
Okay. So I am disposing of here.
Disposing of, lordship may dispose of, but lordship kindly indicate that it is, my lord, according to his choice, that certificate we can rely upon, against which, my lord, the item.
My lord, page 86. But I have already choose for serial number 3.
Page কত বললে?
86. I have represented to the authorities that at least my serial number 3 may be considered. And in the light of the argument advanced by my learned senior, my lord, let the my lord, rejection order of serial number 3 be set aside, and I may be allowed to participate in the tender process.
So 81 you want to continue. 84, 82 is to be
81, my lord, I want to
it is
continue.
81 you so
Serial number 3.
81 এ টোটাল কত ছিল?
81 টা স্যার এই তো 3 নম্বর সিরিয়াল।
হ্যাঁ 3 নম্বর সিরিয়ালে এখানে তোমার টোটাল
81 is 26 lakhs 99,000.
কোনটা? 81 my lord, serial number 3.
Yes.
It is 67 lakhs that
No, that's why the 30
and it is coming around to
26 lakhs.
26 lakhs.
26 lakhs 99,744. Yes, record a note. Thank you. The petitioner has filed the present it application.
win-win situation for both.
50-50.
State government never wins, my lord.
সেটা ভালো।
The petitioner has filed the present it application challenging the impugned communication issued by the respondent authorities, wherein the respondent authorities have rejected the tender of the petitioner on the ground of insufficient credential as per clause 4 under instruction to the bidders of the NIT. Counsel for the petitioner has brought the attention of this court to clause 4 of the instruction to the bidder, wherein it is mentioned that any contractor can submit tender for maximum 2 within bracket 2 numbers of works in this NIT depending on the credential and financial capacity. Then II normally separate completion certificate of 100% completed work is required to be submitted for participating in separate works under the particular E-NIT. However, completion certificate for one particular work may be considered as eligibility for participation in maximum 2 numbers of the serials of E-NIT, provided requisite credential for 2 such work within bracket to be added arithmetically bracket close satisfies that the requirement in all respect out of one such completion certificate. Full stop. Counsel for the petitioner has drawn the has submitted that the petitioner has submitted altogether four completion certificate, which proves that the petitioner has completed the works of the 40%, completed the have submitted 4 completion certificate, and submit that if this certificate is considered, the petitioner is eligible to be participated in the tender process, but the respondent authorities have not considered the completion certificate filed by the petitioner and rejected the request of the petitioner. On the other hand, the learned advocate appearing for the state,
Yes, ma'am. Learned additional advocate.
State, draw the attention of this court to the terms and conditions of the tender notice clause 4 subclause 1, which says that the prospective bidder shall have satisfactorily completed as a prime agency during 3rd November 2020 to till date at least one work of the construction of surface flow minor irrigation scheme, construction of WDS in any state/central government, state/central government undertaking / statutory bodies constituted under the statute of the central/state government and having a magnitude of 40% of the estimated amount put to tender, in a single work order. Counsel for the Respondent also relied upon clause 4 of the instruction to the bidder and submits that the petitioner has participated in the two work that is serial number 3 and serial number 4 of the
Five, madam. Three and
serial
five.
number 3 and serial number 5 of the tender notice and the work of the serial number, the estimated cost of this work serial number 3 is rupees 67,49,353 and the amount put in tender of serial number 5 is 78,36,874. And as such, if the 40% of the two works is 40% of the serial number 3 is to be taken into consideration, it will come rupees 26,99,741, and the 40% of the serial number work of serial number 5 is taken into consideration, the same will come rupees 31,34,750. And if it and both the work 31,34,750, and the total amount would be rupees 58 lakhs, and the 40% the total and the total amount would be rupees 58 lakhs 34,491. Full stop. He submit that the petitioner has submitted 4 completion certificate, out of which the first completion certificate is amounting to rupees 39.84 lakhs, second is 15.52 lakhs, third is 10.83 lakhs, and fourth is 3.19 lakhs. He submits that none of the work completed by the petitioner is of 58 lakhs 34,491, and as such the authorities have rejected the tender of the petitioner. Full stop. At the learned counsel for the respective parties peruse the materials on record. It is found that as per clause 4 of instruction to the bidder, clause 4 within bracket II, of the instruction of the bidder, the completion certificate of 100% completed work is required to be submitted for participating in separate work under the particular NET. However, the completion certificate for one particular work may be considered as eligibility for participation in maximum 2 numbers of serials of e-notice, provided requisite credential for 2 such work within bracket to be added automatically satisfy the requirement in all respect out of one such completion certificate. In the present case, the work appearing at serial number 3 in which the petitioner has participated, the estimated amount put to tender is rupees 67,49,353. And the estimated amount put to tender with regard to the work of serial number 5 is rupees 78 lakhs 36,874. 78 lakhs 36,874. Full stop. If the 40% of 67, if 40% is taken into consideration with regard to the work of serial number 3, the amount would come rupees 26 lakhs 99,741, and the 40% of 40% of the work at serial number 5 is taken into consideration, that will come rupees 31 lakh 34,750. 750. Full stop. As per the tender condition, comma, comma, the bidder shall have the satisfactorily completed as a prime agency during 3/11/2020 to till date at least one work of the construction of surface flow minor irrigation scheme, comma, construction of WDS in any state/central government, comma, state/central government undertaking / statutory bodies constituted under the statute of central/state government and having a magnitude of 40% of the estimated amount put to tender in a single work order. Single work order. In list of the estimate amount put to tender with respect of serial number 3 with respect of the work at serial number 3 is 67,49,353, and the one of the completion certificate which the petitioner has disclosed in the tender document is rupees 39,84,000. Full stop. Full stop. The said certificate is full stop is more than the 40% of the tender amount of work number 3 of the work mentioned at serial number 3. But the respondent authorities have considered the 40% of the amount of both the work and calculated the amount 58,34,491, which is not in accordance with it. And as such, if the one work is to be taken into consideration, if any of one work which the petitioner has participated in the tender is to be taken into consideration, comma, the petitioner is qualified for the one work as the petitioner is having the completion certificate of rupees 39,84,000. Full stop. Counsel for the petitioner submit that the petitioner has made a representation to the authorities on 3rd December 2025, requesting the authority to consider the request of the petitioner by taking into consideration of the completion certificate of any of one work, that is at serial number 3. That is serial number 3. Full stop. Considering the representation submitted by the petitioner dated 3rd December 2025, which has not been considered by the respondent authorities. Thus, this court is of the view that the petitioner is eligible to participate in the tender process with regard to the work at serial number 3, as he is having the certificate of completion certificate of rupees 39,84,000, which is more than the 40% of the amount, tender amount, estimated amount put to tender with respect of the serial respect to the work at serial number 3. In view of the above, the authorities are in view of the above, the impugn notice with respect of the work of serial number 3 is set aside, which is appearing at page 81, annexure P3 is set aside and quashed, and the authorities are directed to allow the petitioner to participate in the tender process with respect of the work appearing at serial number 3 in the e-tender notice. That's all. WPS so disposed. Thank you, Mr. Sen. Original side. Yes, what can be disposed of?
Item number 23 in the case of 20 Constable Millet, the Lordship has disposed of the writ petition in view of this notice. Millet, clause E.
Same.
But here, my lord, they have not issued any notice. I had a talk with him. Your Lordship can direct them because the same
Have taken
department,
instructions, but the notice is being issued, your lordship.
same
can dispose
department,
it of
therefore they can issue the similar
on
notice.
instruction. I'm
What you stated in your affidavit?
my lord.
Oh, there is nothing.
No, affidavit.
Yes.
Even in that affidavit, that affidavit, they have not disclosed this notice.
No, it is a backward process.
So
EWS,
the
whether it can be converted.
revalidation renewal certificate of OBC A and OBC B category will not be applicable for those
Clause E.
Yeah.
which have been delisted from
Clause
the
E.
clear list of the OBC. So you are satisfied with this?
Clause E, my lord.
E.
E.
Income and assets of EWS.
Yes.
Same.
Now, this certificate will be applicable for sub-inspector also. This is for constable, this notice. Same recruitment board. They will have to issue similar notice indicating that
Just now, Lord, I've taken instructions, a notice is being issued. Your lordship kindly record that. On instruction, I'm saying, because officers are here, your lordship can dispose it of. On instruction, I'm saying that notice is being issued. Notice to issue হচ্ছে তো কোথায় যাও notice to issue হচ্ছে তো হ্যাঁ
Obey.
notice is being issued.
Issued.
No,
not
notice
yet
is being issued.
Do one thing.
It will
Come
be-
tomorrow. I am keeping tomorrow. Otherwise, it will be better.
or when next week, because tomorrow this can be disposed.
Dispose it of. Your lordship can dispose it of. On instruction, I'm saying it will be notice will be issued because all are.
না না court তো direction দিয়ে দিচ্ছে।
ওনারা তো বলছেন দাঁড়িয়ে।
Counsel for
আর
the
কি বলবো?
petitioner, let the same be kept with the record.
আমি তো instruction
Counsel for the petitioner has handed over the notice issued by the authorities dated 20 January
Recruitment board
2026,
for the post.
wherein
Hmm.
clause E stated as follows: income and asset certificate for inverted comma, income and asset certificate for candidates belongs to the economical weaker section within bracket EWS, valid for the year 23-24 or onwards, bracket close, inverted comma close. Police counsel for the petition submit that this notice has been issued on with respect of the post of constable. But the present writ application is with for
Sub-inspector.
the post of sub-inspector of police in the state of West Bengal. He submit that if a direction is issued to the respondent authority to issue the same notice with respect of the post of the sub-inspector of police in the state of West Bengal, the petition will
On
be
instruction, I'm saying, Lord,
satisfied. Full stop. Learned counsel appearing for the state on instruction submit that the respondents are ready to will be issued the same notice with respect of the post of the constable in the state of West Bengal. According
Post of sub-inspector.
Sub-inspector, post of sub-inspector in the state of West Bengal. And accordingly, the writ petition is disposed of by directing the authorities to issue the same notice by stating that income and asset certificate for candidates belongs to the economical weaker section within bracket valid for the year 23-24 or onwards. Within a week from date. The WPS disposed.
I'm not the report as per your lordship's direction has been filed, taken on record.
Taken on record.
And instruction, Lord,
On instruction you are submitted.
Yes. No.
Yes, next. Oh, original site.
Position of respondent, Lord.
Yes.
Position of respondent fell down. Can't stand.
এটা বলি দেখা চেম্বারে নিয়ে
May I have your lordship's kind leave to draw up and complete the order dated 11th November?
Just a minute. Let the officers take the charge first.
May I have your lordship's kind leave to draw up and complete the order dated 11th November 2025?
Your Lordship, may I have your kind leave to mention item number 43 and 47, Your Lordship.
Number?
43 and 47 of your Lordship list, Your
43
Lordship.
and 47.
Yes, Your Lordship. I'm mentioning upon notice, Your Lordship, the interim order is expiring tomorrow, Your Lordship.
Tomorrow.
Yes, Your Lordship.
Kal rakh do. To be mentioned.
Grateful, Your
Hello.
Lordship.
Extension of interim order.
May I permit to mention, my lord, this matter was mentioned by Mr. Ghosh yesterday, Mr. Devnath Ghosh. Your lordship was pleased to reserve the written notes.
चैम्बर में भेज देना. Already CAV है.
Lordship, may I mention item number 141? 141.
141, yes.
Yes, the interim order expires today, Lordship.
Expires today.
Yes, Your
Who is
Lordship.
for the other side?
The
Have you
notice has
issued
been.
notice?
Yes, Your Lordship.
You are appearing. Though the matter is listed as item number 141.
Yes, Your Lordship.
141 of today's list, but due to paucity of time, matter could not be taken up for hearing. Learned counsel for the petition prays for action. Submit that the interim order is till today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till 13th of March 2026 or until further order, whichever is earlier. Let the matter remain in the list. Next.
I appear for the bank in this matter. I'm led by Mr. I have instructions to appear, that's why, and I'm led by Mr. Chaudhary, my lord.
No, it has been a while, my lord. If your lordship, I'll just give your lordship a brief recap. Look, there are total 5 writ petitions. This is that willful defaulter matter. I'll just give your lordship a brief background, my lord. Initially, this is a company by the name of EMC. This company went into insolvency. There was a default. The company went into insolvency. Post-insolvency, when the company was in resolution, at that stage, my lord, the first show cause notice was issued. This was in 2021. My lord, we had given a reply. Now, my lord, the show cause was issued to the promoter directors and to personal guarantor and a corporate guarantor as well. Now, my lord, the reply was given. Based on the detailed reply, my lord, the first committee passed an order in July 2021 recommending that all the persons, including the company, should be declared as a willful defaulter. My lord, thereafter, we made a representation before the review committee, which is the procedure prescribed under the master circular read with jar developers. Now, my lord, when we gave the representation to the review committee, detailed representation, that none of the objection raised by us has been considered by the first committee. So, my lord, at this stage, my lord, a second order was passed by the first committee when my review representation was pending before the review committee. First committee passed another order. I came up by way of a writ petition. My lord, in that writ petition, my lord, the second order of the first committee was set aside. So, my lord, then we ought to have started from
zero.
Review. No. First committee order was there. My representation was there. We ought to have started from review. My lord, at this stage,
Who
my
was
lord,
set aside?
my lord, what was set aside? High Court,
Okay.
in a writ proceeding, was pleased to set aside the second order of the first committee when the review was pending.
Pending review.
Correct. So, my lord, at that stage, when we filed, set aside, then a second show cause notice was issued. Now, my lord, since my review remained pending, my lord, what I did is that, my lord, I challenged it by way of a second writ petition. The second writ petition was disposed of by an order where I was aggrieved and I carried the first court's appeal, the single bench's order, in an intra-court appeal. In that appeal, my lord, what was done was the order of the first committee was set aside, including what was pending before the review committee, And it was directed that so far as the second show cause notice is concerned, I should give a detailed reply to the second show cause, and based on the second show cause, the proceeding will be brought to a logical conclusion. So I gave a representation, detailed representation to the second show cause notice. That gave rise to a identical recommendation made by the first committee, complete non-application of mine. This is the order of 11th of January 2024. Representation before the review committee by us, and the review committee, once again, as your lordship is aware. Another, my lord, verbatim reproduction of the first committee's report. So, my lord, the review committee's order was on 15th of April 2024. So now in the present writ, what is under challenge is the recommendation made by the first committee in January 2024 and the affirmation made by the review committee on 15th April 2024. This is under challenge in the review petition. My lord, we have multiple grounds of challenge. My lord, if your lordship recollects, the first challenge, now my lord, there are 5 writ petitions. My lord, the first writ petition, which is, my lord, item number 1 possible in your lordship's list, which is WPO 424 of 2024, Mr. S.N. Mukherjee had addressed your lordship, and he had concluded his arguments. So, your lordship, so, my lord, I am appearing on behalf of the writ petitioner in item number 2 and item number 3.
Yes. So you are appearing for the 2.
So 2 and 3. So, but I will refer to the documents which are in item number 1, because the documents are the same. So unnecessarily troubling your lordship with the same documents from the second writ petition will just make it more inconvenient. So when the documents are same, it is the same show cause, it is the same order, and it is the same review committee orders.
Only the parties are different.
Parties are different. So my lord, your lordship had already made markings on your lordship's brief so far as the first writ petition is concerned. So my lord, we thought, my lord, it will be convenient for your lordship if we refer while addressing the second and the third writ petition. Third writ petition cannot be, that's on a different point altogether. Second, we will refer to the documents which is there in the first writ.
There are 4.
There are 5.
5.
Total
So
5.
one is
I appear for 2 and 3. Mr. Mukherjee had appeared for 1.
And you are for 4 and 5.
4 and 5. You are for 4 and 5.
Yes. Yes.
So the first point that we had taken is constitution. This goes to the very root of the matter. If the constitution of the review committee, we had taken the point of the constitution of both the committees. I'll address your lordship first on the constitution of the review committee. Now, if the constitution of the review committee, which in terms of the master circular, it is prescribed who would constitute, or which are the authorities or which are the personnels which would comprise of the review committee. Now, my lord, if the review committee, which appears to have passed the order, is not appropriately constituted as per of the, then my lord, everything is a nullity.
The committee will be over.
So review goes. So what review committee has done is affirm the order of the first committee. So if the review goes, then my lord, our challenge to the first committee, then my lord, effectively becomes a academic exercise, because there cannot be any recommendation. So if there is any confirmation by the recommendation, nothing remains. So my lord, kindly take first the master circular, which indicates that what should be the constitution of the review committee. That your lordship will find at page 568.
Of your writ petition or the first?
No, of the first writ petition.
So that is 558.
My lord, 558.
Yes. Who is for the authority? You are appearing?
Well, they are the bank, IDBI Bank. Well, kindly take page 568. It starts at 555.
Yes, 568.
558.
Clause
Kindly
D.
take 568.
Clause A.
Yeah, mechanism for identification of willful defaulter. It starts at clause 3. My lord, kindly turn to page 568. The order of the committee, my lord, this would be clause C. On top of the order of the committee should be reviewed by another committee headed by the chairman, stroke chairman and managing director, or the managing director and chief executive officer. This is my lord one. This is number one. Person number one. Then my lord, then the and chief executive officer, stroke CEO, and
Two independent.
consisting, comma, in addition, comma, two independent directors or non-executive directors of the bank. So, my lord, this is the constitution. Managing director, chief executive officer, two independent directors. Now, my lord, kindly take now page 551 once. No, the order of the, now I have to show the review order.
It starts at 540.
Lord, kindly now come to page 541.
Five
541 of the same volume, my lord.
Yes.
Lord, this is a letter. It's a covering letter of 18th April, 16th April.
Yes.
Kindly, my lord, have a look at the content of this forwarding letter. It says, Willful Defaulters Review Committee order dated 15th April. Dear Madam, my lord, immediately below that, please find enclosed order issued by IDBI Bank's Willful Defaulters Review Committee dated 15th April. Kindly note that the enclosed order is final and in view of the order of IDBI Bank, take a decision to declare the willful default in accordance with the RBI circular. Now, my lord, kindly turn to the next page, page 542. My lord, on top, your lordship will find meeting held on 15th March, order number WBRC such and such. So this is the name of the proceeding at on top of page 542.
Yes.
So now, my lord, kindly turn to page 557. Now, my lord, as your lordship, if your lordship flips through the pages, your lordship will find that this is the order, or at least this purports to be the order passed under the master circular. My lord, the question now is by whom? There is an order. Now, my lord, the order is by whom is the issue now, presently, as I address your lordship. My lord, now kindly take page 557. Your lordship will find at the bottom of page 557, it ends towards the middle of the page. By the order, there's in capitals, it is by the order of the Willful Defaulters Review Committee. Then, my lord, your lordship will see Subramaniam CM. Who is he? The Chief General Manager, NPA Management Group, 15th April.
Yes.
So, my lord, if your lordship recollects, and my lord, if your lordship turns to the relevant page 568, which is a part of the master circular, your lordship will find that the Chief General Manager does not form a part of the review committee. He is not at all, neither is he a part of the review committee, nor does he have in any way connection with the review committee. On the contrary, Now, my lord, interestingly, your lordship will find no chief general manager is chief general. So, my lord, he at best could have been a part of the identification committee because the constitution provides him, but he could not be a part of the review committee. Now, your lordship will kindly see. My lord, this is our stand. We say that this is what was served upon me. Now, my lord, here, if your lordship will kindly consider apropos this, if your lordship will kindly come to the forwarding letter by which this review committee order was served upon us, which page 541.
Yes.
Deputy General Manager forwards a review committee's order. So, my lord, my cause of action to challenge, to accept, starts when I'm served with a copy of the order in terms of jar developers para 23. Now, my lord, what has been served upon me by this forwarding letter is what appears from page 542 and ends at page 557.
Correct.
557 has the signature of a person who does not form a part of the review committee.
Correct.
So now, our first contention is that this order of the review committee has been passed by a person who does not form a part of the review committee.
Yes.
So, my lord, this order is contrary to the master circular and as such is a nullity. No effect can be given to this order of the review committee, or in fact, it is not an order of the review committee because it would have only become the order of the review committee if it was passed by a committee constituted in accordance with the master circular. Correct. If the constitution is incorrect, well, the question of the propriety of the order or going into the merits of the order does not arise. So our first point is that this order is by a authority or by a personnel who does not even form part of the review committee in terms of the master circular. Now, when the opposition comes, my lord, they try to justify this order. Now, my lord, kindly once take the opposition. My lord, at page 29 of the opposition, now, my lord, as I take your lordship to page 29, my lord, kindly take their pleadings, which is at page 5. They try to justify the order by saying that this is in fact the order of the review committee. My lord, kindly take paragraph I at page 5 of the opposition. One of the grounds of challenge is based on the allegation that the review committee, WDRC, has not been properly constituted. Such allegations comes to be on the basis that the order of the WDRC has been signed only by Subramaniam, CM, being the chief general manager of the respondent bank. Such allegation does not have any basis. WDRC held its 46th meeting on 15th March and comprised of Mr. Rakesh Sharma, Managing Director and Chief Executive Officer and Chairman of the committee. Besides, Ms. Samaresh Parida and such, both were independent directors in this context. A copy of the resolution in the 46th meeting of the WDRC held on 15th March in the boardroom of the respondent in Mumbai is annexed. Well, this your lordship will find at page 29. My lord, allow me to read a few more lines. It says, it would appear from the said resolution that while a reasoned order was passed by the review committee, the concerned chief general manager, being CM Subramaniam, was authorized to sign the reasoned order. My lord, kindly make a note of that. Authorized to sign the said order. of the events of willful default and the dealing group was authorized to communicate the said decision to the review committee by the petitioner. Well, pardon me for saying this, well, it's like saying Justice Krishna Rao heard the matter. Justice Krishna Rao dictated the order in the chamber, but it was signed by the court officer, Mr. X. So would that become the order of Justice Krishna Rao, which I can challenge in an appeal before the... So my first point in the appeal would be the order not signed by Justice Krishna Rao, or not the order of Justice Krishna Rao. So they are now trying to justify. Will kindly allow me to read this sentence once again. Was authorized to sign the reasoned order. The principles of delegation of power, this is the understatement so far as if you talk about delegation of power. He has been authorized to sign an order when the master circular prescribes and contemplates that it is only a properly constituted committee, and the designation of the officers of the bank are prescribed under the circular, that either chief executive or the managing director or X will become one person and the other two independent directors. So now, apropos this, my lord, kindly take page 29, months. "46th meeting of the Willful Defaulters Review Committee held on 15th March. Your lordship will see directors present, they write MD and two independent directors. Now, my lord, your lordship will see. Now, my lord, if your lordship recollects, in company matters, when there is a board resolution passed by a company under the Companies Act, there is a statutory requirement under the Companies Act that in an annual return when you file at the end of the year, there is a column where you have to indicate the number of board meetings and the date of the board meetings that you have held. So there's no scope of interpolation in order to, if I want to justify an action of the company, to say that this, suppose I challenge it in a court, saying that no such resolution was ever taken by the company. So company cannot then interpolate its books and say that, yes, there was a board meeting which was held prior to this transaction or prior to this action taken by the company. Because there has to be a reflection of that particular board meeting date in your annual returns. Now, here your lordship will see there is none. There is no mechanism by which we can check that whether there was in fact a meeting of the committee held on the 15th of March. Now, if your lordship will kindly turn to page 31. Well, interestingly, at the bottom of page 29, your lordship will find there is chairman's initial. There is no date. I'll just indicate to your lordship will see. Even on the next pages, your lordship will find there is no date. Now, my lord, kindly come to page 30. My lord, towards the bottom of page 30, it is said resolved. My lord, kindly take page 30.
Yes.
My lord, WDRC, allow me to, my lord, place this, my lord, then it will become relevant. Even, my lord, this is without prejudice to our arguments that there was no review committee and the order was not by the review committee. WDRC deliberated on the memorandum of 5th March 2024 seeking to review and confirm the order passed by the... To review and confirm the order. So, my lord, with deepest of respect, my lord, the master circular does not contemplate that he will automatically confirm. It says you will review the recommendation made by the identification committee. So there is sufficient authority with the review committee to examine and come to a conclusion or to reject the recommendation. It was just a mere recommendation by the identification committee, no more than that. Seeking to review and confirm the order passed by the Willful Defaulters Committee. So it's like means justify the ends. to declare promoters, erstwhile directors, guarantors of EMC, such and such, the names are mentioned, as willful defaulters in terms of the RBI circular of 2015 and report to credit information. It was submitted that the company is under liquidation through NCLT. Hence, it was excluded from the willful defaulters declaration proceeding. After discussions, WDRC passed the following resolution. Resolved that the promoters, erstwhile directors, guarantors of AMC, then the names are mentioned. My lord, kindly turn to the next page. Are fit to be declared as willful defaulter in terms of the criteria, clause number such and such, as laid down in RBI circular on willful defaulters and report to credit information companies. Hence, the order number such and such, this is the order of the identification committee, 11 January 2024, issued by the willful defaulters committee as annexed in the memorandum dated such and such, be and is hereby confirmed.
So they are the confirming authority.
So, confirming authority, absolutely. Your lordship has put words into my mouth. Not the deciding authority, they're just the confirming authority. So, the entire process as contemplated by JAR developers and the master circular, that you are the review committee, you will examine. So that's why there is a procedure for making a representation before the review committee. Now, my representation before the review committee was what? Where the identification committee went wrong. So you are effectively an appellate body. You are not only considering the recommendation made, the show cause, the response, the recommendation, but also the grounds taken by the person who is sought to be identified as the willful defaulter, the representation that he makes or the appeal that he files before you, that these are the grounds on which I am aggrieved and this is why the recommendation ought to be rejected. Nothing. He becomes the confirming authority.
So
Then
in one line, so they have not given any reason.
no, not that. There is no order.
Correct. That's
to start
why
with.
no order,
The-
only confirmed it.
It starts here. Kindly now, this is the tip of the iceberg. Now, kindly have a look at the next sentence. Resolved further that to pass a reasoned order recording the fact that the events of willful default were committed by the promoter directors such and such, then my lord, kindly come to the towards the bottom of that paragraph. In terms of criteria clause number 2.1.3 such and such, as laid down by master circular willful defaulters dated such and such. So, my lord, to pass a reasoned order recording such and such, resolve further that the concerned CJM is authorized to sign the reasoned order of the events of willful default committed by the promoters. So, my lord, A, to pass a reasoned order, you confirm it first, then the reasoned order will follow the confirmation.
Yes.
It's not just the cart before the horse, but they made a complete mockery of the entire master circular and the Supreme Court judgment in the case of JAR developers. So first you confirm, then you you delegate it to somebody else to pass the reasoned order. And you, my lord, it doesn't stop there. Then you authorize that person to sign the reasoned order as well. And that is what came to us. That is the order signed by Mr. Subramaniam, the Chief General Manager. So, my lord, this minutes has made things easier for us. My lord, this establishes the fact that this order is not passed by a committee constituted in accordance with the master circular, and this could not have, and it is not the order of the review committee. Okay. And my lord, interestingly, so this meeting which was held on this 15th March 46 meeting of the WDR review committee,
yes,
So there was no order that was passed. What happened on that day? They confirmed the order of the identification committee. The recent order was not there that day. So if I take your lordship once back to page 31, resolved further to the middle of page 31, that to pass a reasoned order recording the fact that the events of willful defaulter were committed by such and such, Biplab such and such, in terms of the criteria as laid down by RBI certain such and such, the concerned CJM is authorized to sign the reasoned order. So 26th or 15th of March, there was no reasoned order. Mere confirmation. And the reasoned order came when? Well, which is on the on 15th of April. Signed by the review committee.
Yes.
So, well, now, apropos this, well, kindly have a look at that paragraph of jar developers once. Jar developer now. Well, jar developer has been given to you by Mr. Mukherjee. Just one paragraph from jar developers. But it is 2019 volume 6 Supreme Court cases 787.
Yes. Para 24. Para 24.
Well, kindly take para 24 page 803.
Yes.
I'll just not trouble your lordship with the entire. I'll just take your lordship to the relevant portion. Mallet, kindly come to placitum D. Equally under section 29 capital A of the Insolvency and Bankruptcy Code, a willful defaulter cannot even apply to be a resolution applicant. Given these drastic consequences, it is clear that the revised circular, being in public interest, must be construed reasonably. This being so, and given the fact that para 3 of the master circular dated such and such permitted the borrower to make a representation within 15 days of the preliminary decision of the first committee, we are of the view that the first and foremost, the committee comprising of the executive director and 2 other senior officials, being the first committee, after following paragraph 3b of the revised circular of 2015, must, well, kindly make a note of the language used by the Supreme Court, must give its order to the borrower as soon as it is made. The borrower can then represent against such order within a period of 15 days to the review committee. Such written representation can be a full representation on facts and law, if any. The review committee must then pass a reasoned order on such representation, which must then be served on the borrower. So it is must, and must. So it is the obligation. It is a statutory obligation on the part of the review committee, which has been judicially approved, that you have to give a reasoned order.
Correct.
And there is no order for the review committee. Even if we assume that there was a review committee which was constituted based on their opposition, for the sake of argument, if we assume that there was a review committee constituted, where is the order of the review committee? My lord, let alone a reasoned order. Right now, my lord, we are not on reasons. We are only on order. Thereafter, my lord, we'll examine whether there is reasons or not. First thing is that there is no order in accordance with the master circular. So the entire proceeding must fail there and then.
Yes.
Now, my lord, if your lordship will kindly take now the show cause notice. My lord, before I take your lordship to the show cause notice, my lord, may I just first take your lordship once to the master circular. It's there in volume 4 as well.
558.
Yes, my lord. My lord, what constitutes a willful default? My lord, kindly take 561. My lord, there is a gulf of difference between a default and a willful default. My lord, admittedly, my lord, this is a company, if your lordship kindly takes once, volume 1. Kindly take, my lord, para 3 of volume 1, my lord.
Yes.
My lord, kindly once take paragraph 3 of the writ petition once. My lord, EMC, this is the company which they allege that this is the company which was in willful default. So the entire lending by the bank, this is a consortium lending. My lord, the IDBI is one of the members of the consortium bank. It is a member of the consortium. Now, my lord, kindly have a look at what this company, what kind of business this company was engaged in. It was engaged in the business of setting up electrical substation and installation of transmission and distribution network for power sector and railway electrification project in India and elsewhere. The company executes projects through special purpose vehicles formed through joint ventures and through subsidiaries, which is a common structure arrangement scheme for a company engaged in engineering, procurement, and construction projects. This gives rise to usual course of business monetary transaction between the company and its joint venture companies and subsidiaries. The company has been awarded a good performance award by the Power Grid Corporation of India. So, my lord, we are not talking about a closely held family company of something running a small unit or something of that sort. My lord, this company had a global presence. So, my lord, there was admittedly a default. So, my lord, a default in its regular course of business has now been converted after years together into a willful default. Now, if your lordship will kindly come to page 561. Well, the company defaulted in the year 2017. And my lord, what happened in 2018? The company was admitted into insolvency. And my lord, the first show cause notice was issued in the year 2021 for alleged
17.
defaults of 16-17. Now, my lord, kindly have a look at the definition at page 2.1.3 at page 561.
Yes.
A willful default would be deemed to have occurred if any of the following events is noted. The unit has defaulted in meeting its payment / repayment obligation to the lender, even when it has the capacity to honor the obligations. So not otherwise. So if there is a regular
defaulted in meeting his payment or repayment obligations, lender
even when it has capacity to honor the obligations. So regular default does not constitute a willful default. I have the means, but despite having the resources and the means, I did not repay the debt.
Correct.
Then it constitutes. Then similarly, your lordship will see a unit has defaulted in making payment and repayment obligation to the lender and has not utilized the finance from the lender for the specific purpose for which finance was availed of, but has diverted the funds for other purposes.
So the main purpose is the diverted if it is proved.
So, my lord, the diversion has been not which funds, the fund which has been disbursed.
Correct.
If you divert that fund for other purposes, that constitutes an event of willful default.
Not utilized and diverted.
Correct. Similarly, your lordship will find the other events of default as well. Kindly consider C, my lord, the unit has defaulted meeting its payment repayment to the lender and has siphoned of funds so that the funds have not been utilized for the purpose for which finance was availed, or nor for the funds available to the unit in forms of other assets. Then, my lord, the unit has defaulted in meeting its payment obligations to the lender and has also disposed of removed, movable, fixed assets or immovable property given for the purpose of securing a term loan without the knowledge of the bank. Then, my lord, comes the definition of diversion of funds and siphoning of funds.
Yes.
Lord, I am told, my lord, your lordship has a matter fixed at 3:45 today. So we are aware of all this.
Thank you.
My lord, this is fixed once again on the 5th at 3 p.m. So I can continue on that.
Already fixed on 5th.
Yes.
Learned counsel for the petitioner in WPO 525/2024 has argued the matter at length, but due to paucity of time, hearing could not be completed. It is fine from the reading. The matter is already fixed on 5th of March at 3 p.m. February, 5th February 2026. Let the matter appear on 5th February at 3 p.m.
Well, could it be, my lord, your lordship has said arguments in WPO 424, well, also 425.
425.
425.
424, Mr.
Yes,
he has already argued the matter.
25 will leakage.
Lord, I appear for the petitioner, and I have served, my lord, since the matter was fixed, my lord, on all the respondents, my lord, who are to appear.
Serve the notice to all.
Yes, yes, I have given, my lord, the copy to all. Now, my lord, this application, when I move, my lord, I am little emotional because, my lord, lordship will understand, because lordship is from the bar, that, my lord, when somebody comes, my lord, to a temple every day and has to go against the temple, then, my lord, obviously there is a huge emotion which is involved. But this happens sometimes, my lord, when things needs to be corrected. Now, my lord,
When the gods go beyond that.
yes. And that is why, my lord, we are before my lord to find out a way out.
Now we put your lunch.
Now, my lord, in this matter, my lord, the petitioner is a candidate, my lord, who had not applied for, but was referred to in 2018 itself by now one of the most senior most judges in this court. And, my lord, usually what happens, my lord, when a reference is made by an honorable judge is that the Chief Justice's office, my lord, thereafter makes enquiry and seeks a consent from the person. Whether, my lord, he gives a consent is of primary, my lord, importance, because thereafter the entire procedure starts. Now, my lord, in 2018, initially, my lord, his name was referred by, my lord, the honorable judge, and the Chief Justice's office, my lord, thereafter said, my lord, had sought for consent. He gave consent and accordingly had filed his candidature. Now, my lord, kindly comes to the 2018, my lord, rules which were framed, which is of most importance, my lord.
What your challenge?
My lord, I have challenged today. I have a very innocuous prayer. There are two interim measures I am seeking for, as, my lord, in the other courts which has happened and in the Supreme Court. Is that, my lord, a surety? Because, my lord, this is a court of records. Therefore, my lord, now these are all records of the court. So, therefore, my lord, in terms of, if your lordship kindly takes the prayers, before I take my lord to, my lord, the facts of the case, page 40, I have a very innocuous prayer, and I don't think, my lord, maybe Mr. Mithro may, my lord, oppose to it. But, my lord, I have a very innocuous prayer. My lord, seeing the candidature is prayer C, my lord, is what I am seeking for. This, my lord, the Supreme Court in the matter had asked for in a sealed envelope to be, my lord, put in the court, so that only, my lord, the person concerned and the, my lord, respondents can look into it along with the judge, honorable judge, my lord. Now, my lord, this is what I'm seeking for in terms of prayer C at page 41 is the interim, my lord, measure. And, my lord, The other prayer that we are seeking for, or I am seeking for, my lord, is that of prayer J. Kindly comes to prayer J also, my lord. Is that, my lord, in the meantime, there have been no rules which have come out. But, my lord, there should not be, my lord, also any rules which should come out, because that would cause an hindrance in the sense, my lord, that the person concerned will not be able to apply for the next 2 years if the rules come out, because he cannot take an advantage of the rules which are, my lord, which may be framed. So, my lord, what I am seeking for today is, my lord, in terms of the Shashore, my lord, is the minutes of the permanent committee, my lord, designation and the full court held in connection with the designation of the senior advocates, that is at page 41, my lord, of the notification dated 19/1/2024 and 26/11/2024. Then, my lord, is that kindly sees Roman 3, the, my lord, cut-off marks, and, my lord, the marks of all 130 candidates, my lord, who were part of the, my lord, procedure. So, my lord, these are the 3 interim measures I am seeking for, and in the meantime, my lord, they should not proceed with coming out with the rules, because otherwise, my lord, that would, my lord, make this application a little infructuous, my lord. So this is all I am seeking for today, and we can come back after that, my lord. But, my lord, to say, my lord, why I am seeking these reliefs, my lord, kindly sees the notification, why I am asking for it. Kindly sees the, my lord, first notification which came out, my lord, which is at page, my lord, 46. Now, my lord, 46 is the first notification of 2018, against which, my lord, there was an order of injunction passed. Later on, it was, my lord, vacated. In this, kindly will come to, my lord, the next page 47, and we'll see, my lord, how this procedure was done. My lord, kindly comes to 12. My lord, kindly sees, my lord, 12. My lord, before that, kindly sees 6 ones. Kindly sees, my lord, 5 and 6 ones, my lord. The permanent committee will be headed by the Chief Justice, 2 senior-most judges of the High Court, and the Advocate General for the state of West Bengal. The above 4 members of the permanent committee will nominate a member of the bar who himself is a senior advocate to be the 5th member of the permanent committee for a term of 2 years. So that is the tenure. Then, my lord, kindly sees 4. The Chief Justice shall constitute a permanent committee to be known as the Committee for the Designation of Senior Advocates. Now, my lord, kindly comes apropos this to 12, my lord. The honorable judges of the High Court may in writing propose name of a learned advocate regularly practicing in a High Court to be designated as a senior advocate. So, my lord, this is a candidate before my lord who was, my lord, referred to in writing by an honorable judge of this court. He is not, my lord, an applicant who had applied for a senior gown. Now, my lord, kindly sees 13. On receipt of the proposal from the honorable judge, the secretariat, through its secretary, shall inform the advocate of the proposal of the honorable judge, and, my lord, will kindly mark, seek his consent for consideration of his name for being designated as a senior advocate. So, my lord, his consent is taken upon being satisfied by the, my lord, secretariat. Then, my lord, in case the advocate consents to have his name considered, the secretary of the secretariat shall request, kindly sees the words, my lord, shall request the advocate to furnish the particulars in the prescribed formula with supporting documents and a declaration in the pro forma prescribed hereunder duly filled up. Now, my lord, kindly sees 14. On receipt of the application in the prescribed pro forma, in either cases, the secretariat will compile the relevant data and information with regard to the expertise, reputation, conduct, and integrity of the advocate concerned, including his and her participation in pro bono work reported and unreported judgments of the matters in which the concerned advocate had appeared. Now, my lord, will kindly mark this because this would be very relevant when the records will come before my lord. And actually argued, not a person, my lord, who sits beside and assists, but actually argued, evincing formulation of legal points for answer by the court as evident therefrom. So, my lord, the judgments which would be given should demonstrate that the person concerned who is being referred to by the honorable judge and whose consent is being sought by the Chief Justice's office, my lord, is a person of such repute that, my lord, he has argued matter formulating, my lord, legal issues before the court, and not a person, my lord, who is in the stage of assisting a senior. Now, my lord, kindly sees evident therefrom and the number of such judgments during the last 5 years preceding the application submitted in the formula. So, pro forma. So, therefore, my lord, in 2018, the candidate was to give judgments for the last 5 years. And I will show to my lord as I read forward and show the, my lord, notifications, how it is diluted. My lord, it comes down to lastly 5 judgments. Not 5 years judgment where I argue a matter, but it comes down to 5 judgments. It is diluted to that extent. Now, my lord, kindly sees below that what are the requirements. The Secretariat shall collect the information data in respect of the applicant advocates from the following sources. Judgments reported in recognized law journals. So the Secretariat will do this. Unreported judgments to be collected from the applicant advocate. Then, my lord, kindly sees D, Bar Council of West Bengal or such other state bar council with which the applicant advocate is enrolled in regard to disciplinary proceedings. So unless these are there, my lord, he cannot be a candidate who can be looked down upon. Police authorities in regard to any criminal proceedings, civil courts in regard to civil proceedings. Now, my lord, I'll demonstrate that this particular candidate had neither of these disqualifications even till the end. Now, Lordship, now Lordship will kindly come to 15. The Secretariat, my lord, next page. I'm sorry, my lord, extremely sorry.
Yes.
The Secretariat shall publish the proposal of designation of the advocate in the official website of the Calcutta High Court, inviting suggestions, views from the stakeholders within 2 weeks from such publication. The suggestions, views of only those stakeholders who disclose their identity and addresses would be considered as valid. And, my lord, as far as this particular gentleman is concerned, none of the stakeholders have opposed against him. Then Lordship will kindly come to 17. After receipt of the suggestions, views of the stakeholders, the Secretariat will compile all information, data, views, suggestions of stakeholders, as also the information directed to be collected by the permanent committee, and put the case before the permanent committee for scrutiny. So, my lord, my lord, petitioner, when my candidature was put before the permanent committee in 2018, neither did I have, my lord, any disqualification. Neither, my lord, I was a candidate who had not argued cases. Neither, my lord, I was a candidate who had not fulfilled the years of practice. And that is why, my lord, I show, my lord, the next box which is there. Kindly sees 2A again. Judgments, evincing, reported or unreported, applicant advocates formulation of legal points for answer by the court in course of arguing a case. Again, my lord, this was to fetch me 40 marks. Although, my lord, we put in years of practice, but, my lord, then we were like students who were to obtain marks from, my lord, teachers. Be that as it may, my lord, I was a candidate who was to get 40 marks. Then, my lord, kindly comes to 19, which is very important. 40 marks. Now, my lord, kindly sees all members of the permanent committee shall provide separate marks. This is why, my lord, I am asking for this disclosure before my lord as a certiorari. All members of the permanent committee shall provide separate marks in individual score sheets, and the marks of all the members should be compiled by the Secretariat to calculate percentage of marks secured by each applicant advocate. So, my lord, Ultimately, my lord, it would be reduced down to a percentage of marks of the 5, my lord, permanent committee members. And my lord, one would look into what is the marks which has been obtained by all. And I put forward, my lord, because of this, that I am ready and willing that my marks should also be looked into by this honorable court. I am not shying away from it, my lord. Now, my lord, kindly sees 20. Very important, my lord. This would be the touchstone, and this has not been followed. I'll show. Only those applicant advocates who secure at least 60 marks shall be designated as a senior advocate. So in 2018, the marks were very high, 60, my lord. Then, my lord, kindly sees the leverage. However, in a deserving case, for favorable consideration, the permanent committee may relax the benchmark of 60 marks up to a maximum of 10 marks and designate an applicant advocate as senior advocate. So, my lord, if we go by this 2018, my lord, notification, 50 was the cutout marks. Nobody.
As on date, this
No,
notification.
no, my lord, I'll show, my lord, this has been diluted.
Correct.
Now, my lord, 60 was the cutoff marks. And this, my lord, is the time when I give my consent and I file my reports for the last 10 years. Now, my lord, kindly comes. Yes, and my lord, the cutoff marks in 2018 would have been minimum, my lord, would have been marks what I had to obtain was 50, not below that. And because, my lord, this says only, the word is only, so I wouldn't even, my lord, come in the consideration even if I am below 50, according to 2018. Now, my lord, kindly comes to, my lord, 21, because that is very important. Why we say, my lord, that these details should come before my lord. If any of the information supplied by the applicant advocate is found to be incorrect and or misleading, his or her application will be considered as cancelled and he or she will not be considered for designation as senior advocate subsequently. So today, my lord, if somebody, my lord, gives, my lord, judgments where I sit beside with, my lord, with great respect, I say, I've done a lot of matters with Mr. Mitro. If I sit beside Mr. Mitro and assist him in, my lord, 100 matters, I do not qualify to become a designated senior, my lord, and I cannot give those judgments to my lord as my candidature, my lord, that I am to be, my lord, designated as a senior advocate. I have to argue a case, my lord, and that too, my lord, for the last 10 years to show my repute in the bar to be, my lord, eligible to give those judgments.
Yes.
So today, if the records come before my lord and lordship finds a candidature whose judgments are such that he is sitting beside X, Y, and Z, that candidature, my lord, is giving misleading statements to the court and to the full bench.
Okay.
Now, my lord, kindly takes, my lord, 22. Names of advocates cleared. This is very important, my lord. Cleared by the permanent committee shall be placed in the meeting of the full court. Upon consideration of the full court, will take a final decision. Now, my lord, will kindly mark. This will also be seen from the minutes by 2/3 majority of the total number of judges present in the full court. So therefore, my lord, according to 2018, when the full court takes place, I have to have not only 50 as my cutoff marks, but a 2/3 majority supporting by raising of hands or by saying yes or whatever it is, which should be minuted to show that the candidature of the petitioner should be designated as a senior advocate and not, my lord, otherwise. Now, my lord, the minutes would show whether, my lord, there was a 2/3 majority which supported a candidature or, my lord, a minority who objected to the candidature. Now, my lord, if the minute shows that a minority, my lord, is objecting to a candidature, then, my lord, otherwise he is a successful candidate. And that is exactly why, my lord, the certiorari is, my lord, prayed for. Because, my lord, if the minute shows that there are, my lord, let us take, my lord, there are 25 honorable judges, my lord, in the full court meeting. 5, my lord, judges feel that, my lord, this candidature is not nice. And they raise their, my lord, hands that he should not be. Then, my lord, with greatest of respect, he will become because the rest of the 20, my lord, in majority has raised their hands supporting that his candidature. We have no objection.
Yes.
So, my lord, kindly, bol, aste bol. Now, my lord, kindly comes, my lord, to see 22. It is the permanent committee, my lord, which would clear. And, my lord, the decision of the full court, my lord, would be restricted to the majority decision to, my lord, pass out a candidate. Now, my lord, apropos this, my lord, he had given his candidature. My lord, will kindly see with, my lord, kindly comes to page, my lord. P2, this is at page, my lord. The page number 53, my lord. 53, my lord. My lord, for my lord, the sake of the court, my lord, the name of the honorable judge is, my lord, not there. But, my lord, if lordship wants, we can produce the original which is there, my lord, and show it to my lord and to the, my lord, the respondents. My lord, kindly see, as your name has been proposed by the honorable such and such of this court to be designated as senior advocate. The terms of selection of senior advocate has been notified in Gazette notification dated such and such, a copy whereof is annexed herewith. If you are agreeable to the proposal, kindly send the undersigned a consent letter together with prescribed pro forma duly filled in as specified in the notification. So, my lord, kindly sees 3 words, my lord. One is that if you give consent, so consent is sought for. This is at page 53, my lord.
Yes.
Consent is sought for. 2, my lord, if you are agreeable. So, my lord, I am not a candidature who has applied for. If I am agreeable, then only. Thirdly, my lord, proposal kindly send the undersigned a consent letter. So there was a special consent letter in a pro forma. Like, my lord, I believe, my lord, lordship is experienced, my lord, for elevation, my lord, which is to be given, my lord, by this candidature. Now, my lord, apropos this, kindly sees, my lord, the next letter, which is at page, my lord, 35, the next page. Sorry, 54, my lord. My lord, kindly sees, he has given consent to be designated, and he has filled in the consent form also, which is in the pro forma, my lord, which is there. Now, kindly sees, my lord, the next page, which is very important, where the names come out in 2018. 10th of August 2018, my lord, is the date, and lordship will see in those days there were 80 people who were there. Amongst them, my lord, kindly will come to page 62. He is the 55th candidate, my lord. So, my lord, cleared by the 55, my lord. He is cleared, my lord, by the Secretariat of the Chief Justice. His consent is taken. He has produced his judgments. He has produced, my lord, there is no, my lord, complaint by any of the stakeholders. He has been given the marks, and his name comes out, my lord, as a 55th candidate to be considered by the full bench. Now, my lord, at this juncture, my lord, there was, my lord, a litigation which was filed in this court. And this, my lord, proceeding came to a standstill because, my lord, there were orders which, my lord, had restrained designation to be given. Now, my lord, in 2023, my lord,
So what has happened?
this has stood like that. Yes. No, this lost its force because of the 2023 rules, which I'll show to my lord now.
Subsequent rules.
Yes, my lord, the matter was taken up then, and, my lord, the interim order was set aside, and ultimately, my lord, new rules were formed because by that time, my lord, the Indira Jai Singh Part 1 judgment had come. Now, my lord, kindly comes to this page, which is at page 65, which is, my lord, we are concerned about.
Yes.
Which is 27 of July 2023.
Correct.
Now, my lord, kindly.
This is now in force.
Yes, this is now in force. Now, my lord, kindly comes to, my lord, the next page, the definition, page 66. Kindly sees, my lord, permanent committee means the secretariat established by the Chief Justice of the High Court at Calcutta under Rule 4 of these rules.
3 subsection 2.
Then, my lord, senior advocate means, my lord, then stakeholders. Very important, my lord. Who can be the stakeholders? Because if some of them, my lord, amongst these have, my lord, given anything against me, I would be out. And I'll show I was not one of those candidates. My lord, kindly sees present and past presidents and secretaries of the Bar Association, Bar Library Club, incorporated law society of which the applicant advocate is a member, designated senior advocates, such other person or persons, if any, that the permanent committee may decide from time to time under subsection 7, subsection 3 and 5. My lord, these are the stakeholders only who can object against me. Now, my lord, kindly takes 3.1 in the same page. The Chief Justice shall constitute a permanent committee to be known as the Committee for Designation of Senior Advocates. So this is quite similar to the earlier one. And so is 2 also, my lord, quite similar to the earlier clause which was there. Now, my lord, kindly comes to clause 5. Next page, my lord, clause 5. Qualification for designation of an advocate as a senior advocate. If the Chief Justice or
all matters relating to designating permanent committee final.
My lord, before that, my lord, kindly takes clause 3, subsection 5 once. All matters relating to designating senior advocates in the High Court shall be dealt with by the permanent committee. And then it would transfer it to the court, my lord. Then, my lord, kindly comes to 5.1. My lord, 5.1 is very important because I am one of these candidates. If the Chief Justice or any other sitting judge of this court is of the opinion that an advocate, by virtue of his ability, standing at the bar, or special knowledge or experience in law, is deserving of such distinction so as to be designated as a senior advocate, the Chief Justice, the judge, may, in writing, recommend not more than 3 names of such advocates for being considered for designation as senior advocate. Such a recommendation shall be submitted to the Secretariat. No judge shall make more than 1 recommendation within a span of 3 months. So the same, my lord, clause remains here, little modification that, my lord, the honorable judges cannot give more than 3 names, and, my lord, 1 name every 3 months, which is quite high, but, my lord, 1 name every 3 months. Now, my lord, kindly sees the, my lord, clause which is very important is 2. 2, my lord.
So in a year, 12 names.
In a year, no, every 3 months, 1 name, my lord. 4 names. 4 names. Yes, lordship can give, my lord. That's only lordship has the powers, my lord. None of us. My lord, kindly sees 2 now. No person shall be eligible to be designated. Yes,
Thankfully, my lord, at the time when we became the senior advocates, we didn't have to.
all these rules.
We were invited by the learned Chief Justice and we were given them.
Well, I think this is a candidate who is in the same, my lord, same manner in which he was also invited by the Chief Justice, my lord. This is the same thing. But, my lord, I believe, my lord, those were the golden years when Mr. Mitru, my lord, had, my lord, come to this honorable court, my lord.
No, prior to this senior designation, when was the last senior designation?
I think, my lord, 2013.
2013.
No. 16.
That is also, there is no rule.
No, then there was no rules. No rules. It was also invitation.
Like that, just
Full court meeting, everyone. No, sir.
I think last of them was his father. So, my lord, he must be. My lord, it was by invitation, my lord. I don't think it was the same as Mr. Mitro's case, my lord. It was by invitation.
Then, my lord, on that point, that's 2016.
2016, that's it.
Now, my lord, kindly comes to 2, my lord. But this is very important. No person shall be eligible to be designated as a senior advocate unless he. Now, my lord, I have a strong, my lord, objection to this. My lord, in the earlier rules, lordship will find he / she was there. Although, my lord, we are taught to read he as both. But, my lord, here kindly sees that she is gone. It is only unless he is there. No, my lord, I take a strong objection. It was there. It should have been here also, my lord. Because we, my lord, have the respect of both. My lord, kindly sees 1, small I, is ordinarily practicing, my lord, again, very important, this is preserved, and actually argued cases in the High Court at Calcutta or its circuit benches or courts subordinate to it, including tribunals within its jurisdictional territory, not less than 10 years preceding the last date of submission of this application for designation. So, my lord, this was a strict criteria That, my lord, he has to argue by himself. Then, my lord, kindly sees, my lord, 3, Roman 3 also. The permanent committee and full court shall take into account the caliber, merit, ability, and academic distinction of the advocate concerned, including his character, conduct, and behavior towards the court and other members of the bar. So, my lord, the my lord, minutes would show if there is anything against me even. Now, my lord, kindly comes to the next page, my lord, which is, my lord, 68.
Yes. Procedure.
Procedure. An advocate may be considered for being designated as a senior advocate on his name being proposed in writing by the Chief Justice or any sitting judge of the High Court of Calcutta. Then, my lord, on receipt of a proposal from the Honorable Judge, the Secretariat through its secretary shall inform the advocate of the proposal and seek his consent. My lord, this is kept identical as the last one. Now, my lord, kindly comes to 7, the procedure for designation. This is very important. On receipt of the application as prescribed in Appendix A in either cases, the Secretariat shall compile the relevant data and information with regard to the expertise, reputation, conduct, integrity of the advocate concerned. So, my lord, I stop here and I say to myself and to this honorable court that when my name goes into this list, it is taken that, my lord, the Secretariat has considered the information with regard to my expertise, reputation, conduct, and integrity. I pass that stage, and then my name goes into that list, my lord. Concerned, including his participation in pro bono work, reported and unreported judgments of matters in which concerned advocate has appeared and actually argued the case. So this has been emphasized always. And the number of such judgments during the last 5 years. So now, my lord, it is diluted from 10 years to 5 years. Last 5 years preceding the application, etc., as submitted by the pro forma. Then, my lord, kindly sees.
No, in this procedure,
yes, my
the
lord,
name of the petitioner was in the list or
yes, yes, my lord, yes. He had passed all these stages.
Because earlier it was the recommended by the Chief Justice.
Yes.
Subsequently,
No, this, my lord, also has that recommendation because in this rules, there is a clause that, my lord, if you were recommended in 2018,
correct. That's why earlier was taken into consideration.
yes, my lord, he would add on to his candidature. Correct. He would add on to his candidature.
The list which you have shown at page.
He was 55th name.
Page 62.
Yes.
So total list was taken into
consideration. And there was an addition to it. I'll show.
Subsequently.
Yes, 80 became 130.
Correct.
But why I'll say this, my lord, because the, my lord, restriction was by operation of law, because somebody filed a writ petition and it happened. So that continued, my lord. Correct. Now, my lord, kindly comes to 3. The Secretariat shall publish the proposal for the designation of the advocate in the official website of the Calcutta High Court, inviting suggestions, views from the stakeholders within 2 weeks from such publication. And this was done. Now, my lord, kindly sees the next 2 clauses which are important, 4 and 5.
What is your against you? What?
Nothing is against me.
What is troubling you in this?
Yes, I'll show that, my lord. Now, my lord, kindly comes to, my lord, 7. All members of the permanent committee shall provide separate marks in individual score sheets, and marks of all the members should be complied by the Secretariat to calculate average percentage marks of secured by each applicant. That is why, my lord, I asked for a surety before, my lord, to see that whether, my lord, I have, my lord, got the marks which the others have got or not who have been designated. I may be, my lord, just, my lord, at some marks which is, my lord, in single digits. Now, my lord, kindly sees only those applicants, my lord, will kindly mark it. Only those applicants who have secured the cutoff marks as decided by the full court shall be designated as the senior advocate. And that is why, my lord, I call for a surety. What was the, my lord, cutoff marks?
So earlier, what was the 50?
That is gone.
60, then it has reduced
to 50. Today the cutoff.
Now it is up to the full court. What is the cutoff?
Yes. It can be 10 also.
Correct.
It can be, my lord, 80 also. So that is why, my lord, the question is that one should know what is the cutoff marks. and whether I am below or above that. If I am below, my lord, then, my lord, it says only those applicants, the word only is retained. My lord, I go out of this court. And if I am, my lord, above that, then, my lord, I have a further case before my lord. Now, my lord, kindly sees 9. If any of the information supplied by the applicant advocate is found to be incorrect and or misleading,
That is okay.
my lord, that is retained again.
Correct.
Now, my lord, kindly comes to 8, which is very important again.
Procedure.
Procedure before the full court. All the names of the advocates with the points awarded by the permanent committee shall be placed in the meeting of the full court. So, my lord, here, pausing here, the permanent committee, which, my lord, is a committee, my lord, made by the, my lord, 5-member, then, my lord, hands over the, my lord, records to the honorable court, and they then become the records of this honorable court. They are no longer, my lord, a record which is, my lord, of the permanent committee. Now, my lord, upon consideration, the full court shall take a final decision. Now, my lord, kindly mark here, by simple majority again. So, my lord, as it was earlier, it is again here that the simple majority would only give, my lord, a person the designated senior advocate, not, my lord, the minority objection.
No, upon consideration, full court shall take final decision by simple majority.
Of the total number of judges present in the full
And
court,
the quorum shall at least half of the total is.
yes.
So total number of simple majority. If it is 10, if the 6 is
6.
there, then
Same as last, but it was then 2/3. Now it is simple majority. But again, my lord, I have to say, my lord, it cannot be a minority objection.
Correct. That's why.
Now, my lord, 8 also says
Simple majority means automatically.
yes.
Simple majority means if it is minority is less.
Because, my lord, that is why we have called for, my lord, the certiorari with regard to the minutes of the full court meeting, which would demonstrate that, my lord, there was a simple majority for all candidates. And, my lord, 8, which I had already let out, my lord, it says only those applicants who have secured the cutoff marks. So not only simple majority, but also cutoff marks. হ্যাঁ বুঝতে পারছি সেটুকু ইংরেজি বল সেটা তো সরাসরি বলবে এখন কেন বলছিস তুই Now, my lord, kindly comes to 3. My lord, this gives, my lord, also those honorable judges who were not there in the full court to participate in a sealed cover, or, my lord, through an email, or, my lord, by video conferencing if it is so. Now kindly comes to 4, which is very important. My lord, where the rules are, my lord, completely given a disarray. I'll show that. All cases that have been favorably considered by the full court have not been favorably considered by the full court. I'm grateful to Mr. Mitra. Have not been favorably considered by the full court may be reviewed, reconsidered after the expiry of a period of 2 years from the date of publication of the notification designating the senior advocates. Such review, reconsideration shall be on the basis of fresh application received pursuant to a notification being such and such. So there is, my lord, no case of deferring any candidate. No power to defer any candidature. So, my lord, this candidate before my lord, or the other 47 candidates who have been deferred, was not even there in the rules. There was no rejection. Let us read again, my lord. All cases.
Yes.
All cases that have not been favorably considered by the full court may be reviewed, reconsideration after a expiry of a period of 2 years. So till 2 years, my lord, I will not be reviewed or reconsidered. So there is no question, my lord, of deferring me. Now, from the date of publication of the notification designating the senior advocates, then, my lord, such review, reconsideration shall be on the basis of fresh application. So, my lord, a deferred candidate is not on, my lord, is giving a fresh application. I'll show that has not been followed also. On the contrary, what has been done, my lord, my candidature has been deferred. And thereafter, I've been rejected. Deferred means, my lord, a question where in a selection process is, I have qualified, but my decision would be taken later on. Here, that right is not there in the rules. So deferment is not something which is prescribed in the rules in the selection procedure. So therefore, rejection post this is something which cannot be even thought of.
Yes.
Now, my lord kindly sees the final, this is also very important. The final decision of the full court shall be communicated to the applicants individually. So, my lord, if I am deferred, let us take, my lord, deferred was in the rules. Then I had to be communicated individually, not, my lord, a poster, my lord, or a notification which will come out, my lord, in public. Just as, my lord, a designated senior advocate is, my lord, individually, my lord, given the information by way of a letter, my deferment was also, my lord, to be, my lord, informed to me if it was in the rules, or my reviewing or my reconsideration, which was to take place as a fresh candidate after 2 years. Now, my lord, today, with greatest of respect, I was never informed that, my lord, my candidature is to be reviewed, reconsidered after 2 years. All that I was informed with the others, my lord, in a, my lord, notification which came out in public, that amongst 48 candidates, I am also deferred till April 2026. 2025. Now, my lord, 2025 April was nowhere in the picture of the notification. That's a rule which has been framed, and that amendment or modification, nobody has seen the light of the day. Now, my lord, kindly considers, my lord, apropos this, today, my lord, I cannot have a full hearing of this. I can understand, my lord, because that would be, my lord, my final reliefs. All that, my lord, I am seeking today is that, my lord, I had, in fact, my lord, filed a RTI also, which was rejected. But today, my lord, I don't need that, because, my lord, I can argue on that, saying that the rejection was also improper. It is contrary to the Right to Information Act. Because, my lord, this is an institution formed by the Constitution of India, and my rejection is on the ground saying that these are documents which, my lord, does not qualify for an institution which is framed under, my lord, 2, 3 and 8, 1, which is very unfortunate, my lord, that we have to see such, my lord, results, my lord, of a RTI. Be that as it may, today I am seeking for certiorari. My lord, all that I am asking for, my lord, I can read that Supreme Court judgment if your lordship wants, my lord, is that this court, my lord, calls for, as I said, my lord, in a sealed envelope, the, my lord, minutes of the, my lord, meeting of the full court, the cutoff marks, which would also, my lord, have the, my lord, marks of all individuals who are designated and who were deferred contrary to the rules, my lord, which has been framed. And, my lord, this would, my lord, give a clear picture to my lord. I am again saying, my lord, I don't want this in public, because, my lord, we are not against somebody who has been designated, because he is qualified to be designated. But we are, my lord, against the procedure by which the 48 has been deferred, which was contrary to the rules. So, my lord, this is what I am seeking, my lord, on the, my lord, as an interim measure today before my lord. If, my lord, lordship permits this, we can come back, my lord, subject to, my lord, Mr. Mitra
Let
making.
me hear Mr. Mitra for 2 minutes. What is the instruction on? Let me hear.
Because my pleadings are there, my lord, that there are candidates who have not obtained, my lord, cutoff marks even. But, my lord, I am not going into it. I am simply saying that, my lord, that my records would speak for itself. And, my lord, since this is a, my lord, court of records, lordship kindly calls for the records. Because, my lord, I'll show one paragraph of the Supreme Court judgment, my lord.
Okay, let me hear Mr. Mitra.
Mr. Mitra has an
What is the
objection to that, my
instruction
lord. Let us.
on overall.
Nishit.
Well, this is, I must frankly tell you, lordship, that I had been clamoring for, my lord, the full court meetings to be held for the purpose of, my lord, induction of senior advocates. I had been, my lord, personally going and mentioning to the learned judges. So now,
which I can vouch for, because, my lord, I was the person who had taken him many times, my lord, which I can vouch for, my lord.
but then again, my lord, once I have briefed by the High Court, my lord, I have to say whatever has to be said on behalf of the High Court. Lordship, will you please to come to the prayer. Page 40. Okay. Etc. I, passing the following order. Impugn notification dated 26/11/2024 and the disapproval letter dated 18/12/2025 issued by the respondent to be set aside and or quashed and or cancelled. This is the main prayer. Kindly may not come to page 102. The first one, 26th November.
Yes.
Kindly may not come to page 10. Your Lordship can mark it, my lord, at page 40. The 26th November 2024, my lord.
This is
at page 20. Now, 16th November 2024, this is the document by which designation of the senior advocates took place. And your Lordship will be pleased to see, my lord, there are about 81 names which have been there at pages 102 to 104. These are the gentlemen who have been, or ladies and gentlemen, I should say, who have been, my lord, given
senior
advocates now. Now, my first submission is this. Then when you are asking for quashing of this particular notification, you are affecting their right.
So they may be, they may.
Do they or do they not have the the authority or the right to come before your lordship and defend? They should have been made parties.
Made a party. That's correct. Okay.
If they are not made parties, then my lord, they cannot sustain this prayer.
With regard to 26/11.
That's my first submission. Therefore, my lord, the first prayer, which is, my lord, the main prayer, on the basis of which, my lord, the other prayers have been asked for, with regard to disclosure of documents and other things. My lord, they cannot be sustained unless, my lord, my lord, make them a party. Number two, and it comes to the letter. And first is the notification, which I have shown to your lordship, page 102.
Yes.
Then kindly come to the next letter, 18 December. 18 December letter is at page 124. This is the final letter which has been issued. And again, I was just wondering what should be the position. I am sure, my lord, my husband will be able to assist your lordship. I shall try also to assist your lordship. This additional registrar is writing this letter, giving an information to my lord, the writ petitioner, that I am directed to inform you that in terms of so and so meeting held and on such and such date, under notification number so and so, learned advocates were designated senior advocates with effect from the said date of notification. This your lordship is to see 26th November. The consideration of the said remaining 48 advocates, including yourself, who had applied online in response to this court notification dated so and so, was deferred to a subsequent full court meeting. Thereafter, as for the decision under agenda number 5 at the full court meeting held on 11/12/2025, the Honorable Full Court considered each of the eligible deferred candidates for designation of senior advocate and by majority disapproved and their candidature. Accordingly, the process for designation of senior advocate initiated under designation number so and so stands concluded. So, my lord, now after this, the position is this: these names will again come up for review after 2 years. This is, my lord, as per the notification. This is another question I am asking to myself: who have been made parties? Parties have been made, my lord, the administrative staff. The decision making, my lord, body
authority has not been made.
Is not before your lordship. I would just, this is something, my lord, is troubling me also as to what is to be done about this. Kindly, my lord, see the cause title and, my lord, the parties who have been made as respondents in this. My reference says that this is the committee, but the committee is not the, my lord, it is High Court administration through registrar general, additional registrar OAC, and, my lord, permanent committee of designation. My lord, kindly come back to the notification my lord was showing your lordship, the last notification.
in terms of which all these things have taken place. Notification at page 65. Well, my reading is slightly different from my learned friend's reading of this notification. My reading is this, that this committee, the permanent committee which has been formed, is only a committee which will collate all the facts and place it before the full court. It is the full court which is taking the decision. The decision not to, my lord, make my learned friend's client a my lord, senior advocate, my lord, is a decision of the full court. It is not of the kind, my lord, come to the notification, it will be made very clear. Your lordship kindly come to page 67. This notification starts at 65. Kindly come to 67. 67, 2, 5, 2, qualification for designation. 2 is no person shall be eligible to be designated as senior advocate unless he. Then kindly come to III. The permanent committee and full court shall take into account the caliber, merit, ability, and academic distinction of the advocate concerned, including his character, conduct, behavior toward the court and other member of the bar. So both permanent committee as also the full court will take. Then, my lord, kindly turn over the page. What you will be pleased to come to page 68, clause 7, procedure and designation. What is the duty of this permanent committee? On receipt of the application as prescribed in Appendix A, in either case, the secretariat shall compile, kindly note the words, compile the relevant data and information with regard to the expertise, reputation, conduct, and integrity of the advocate concerned, including his participation in pro bono, reported and unreported judgment of matters in which concerned advocate has appeared and actually argued the case, and the number of such judgments, etc. Therefore, he is to compile these facts. Then, my lord, kindly come to clause 3, 7.3. The secretariat shall publish the proposal. Kindly see, this is a proposal for designation of the advocate in the official website of the Calcutta High Court, inviting suggestions, views from the stakeholder within 2 weeks from such publication. So, my lord, this proposal is being put forward before the stakeholder for their. Then, my lord, kindly come to the next page, page 69. Subclause 5 at the top. After receipt of the suggestions, views of stakeholders, the secretariat shall compile, kindly note the words, compile all the information, data, views, suggestions, stakeholders, and also information directed to be collected by the permanent committee, and put up the same before the permanent committee for scrutiny. So the scrutiny will be done by the permanent committee. Then permanent committee shall examine each case and then make overall assessment. This is the way the assessment is to be made. Then, clause 7. All members of the permanent committee again shall provide separate marks in individual score sheets, and the marks of all the members should be compiled with the secretariat to calculate the average percentage of marks secured by each applicant advocate. Then, my lord, only those applicants who have secured cut-off marks as decided by the full court. Kindly see, the decision is to be of the full court. Compilation by the permanent committee, but decision is by the full court. Decided shall be designated as senior advocate. Well, this is the cause of action. Only those applicants who have secured cut-off mark and as decided by the full court shall be the designated as senior advocate. And then, my lord, kindly come to 8.1, makes it more clear. All the names of advocates with points awarded by the permanent committee shall be placed in the meeting of the full court. Upon consideration, the full court shall take a final decision by simple majority of the total number of judges present in the full court. The quorum shall be so and so. So, my lord, my second submission, first is with regard to the parties. The persons who are going to be affected should be before the court, so that if they have got anything to say, because their valuable rights will be affected. If the prayer one is granted ultimately, then, my lord, they must be having a say. So they must be made part. Second is, my lord, this is something full court is taking a decision, and that decision which is at page 124, that is being assailed before your lordship. Now, who is going to be before the lordship? Who is going to produce the record? Without the permission of the full court, which has taken the decision. Will, my lord, the respondents number 1, 2, 3, and 4 be able to produce this record? Certiorari proceeding is, my lord, made against the party who is responsible, either for production of documents or the person being personally present. The person who is responsible for it is the person who is taking the decision on the basis of this. One is compiling, collating all the facts, placing it before another committee, which is taking a decision on the basis of majority. Therefore, my lord, second thing is this. I personally feel, subject to what your lordship feels, my lord, party one has to be there. And my lord, insofar as the calling for records is concerned, under the full court, my lord, says that the record should be produced, my lord. I respectfully submit to your lordship, perhaps, my lord, this cannot be done. I am submitting to your lordship today that let my lord, my lord, bring the necessary parties before your lordship. Because without they being there, this matter cannot be heard. This is absolutely a preliminary point. And second, my lord, the person who is responsible for production of record, they are not before your lordship. They must be given. And my lord, these are the two preliminary submissions I am making before my lord.
Yes.
Or may I give a reply, my lord? First of all, my lord, kindly comes to my lord page 68. My lord, the full court, my lord, is only to, my lord, do two things. One, my lord, is that to, my lord, fix, my lord, a cutoff marks. And second, my lord, is to consider by way of a majority.
Correct.
That is the only work left for the full court.
No,
The
but
entire,
the first point is
my lord, I'll come to the first point, my lord. At the first instance, I said I did not want, my lord, petitioner did not want to harm them, my lord, because we have respect for them. So we do not wish to, my lord, bring them, my lord, or to do something to them or set aside something which is already done. But that's the last resort one could think of in an institution. Now, my lord, that is why I'm, my lord, addressing the second point. My lord, this is the same situation which had happened in the Delhi High Court, which went up to the Supreme Court and the, my lord, Orissa High Court. Now, my lord, and Allahabad High Court. My lord, kindly sees, my lord, page 69. Page 69 shows, my lord, that the entire exercise is to be done by the permanent committee.
Correct.
My integrity, my lord, efforts, my judgments, my marks, and my recommendation on the basis of that. Now, my lord, if the submission of Mr. Mitro is to be taken as, my lord, the full court being sacrosanct, then, my lord, my marks given by the permanent committee can be also nibbled with by the full court, which cannot be, my lord. The permanent committee, my lord, is the committee which sets my standards. Because prior to that, my lord, the secretariat collates and collects information about me. My lord, when, my lord, the entire thing goes to the permanent committee, my lord, before that, even the stakeholders have to give an objection, not prior to that. Now, my lord, therefore, my lord, kindly considers, that, my lord, my lord, permanent committee is the committee which, my lord, gives the marks based on which the cutoff marks also is fixed by the, my lord, full court. Full court cannot, my lord, give up, my lord, make a cutoff marks if the permanent committee does not set a standard of, my lord, let us take, my lord, 60.
No, the cutoff mark is to be fixed by the full court.
Yes, but
not by the permanent committee.
That's exactly what I'm saying. So the full court will only be able to fix a cutoff marks based on the, my lord, array of marks which has been received by the candidates. Let us take, my lord, today, there was no permanent committee, which has now happened. The latest judgment of Indira Jai Singh says permanent committee should not be there. It is given a go by. Because, my lord, it says that a reputation of a lawyer cannot be given by marks. It is to be, my lord, as is standing in the bar. Now, my lord, therefore, if there was no, my lord, permanent committee, then, my lord, there is no question of a cutoff marks. Kindly, my lord, visualizes this. The work of the full court is only in
as on date, the notification is valid.
Yes,
Correct.
my lord, we are guided by the earlier Indira Jai Singh judgment.
Correct.
Now, my lord, for me,
so, and the permanent committee and the full court has acted in terms of this notification.
Not the, my lord, not the, my lord,
What
full-
violation, whatever it may
It is
be, that
different.
is the allegation
Yes.
with regard to.
Yes.
With the permanent and the full court.
Yes,
has
the marks has been given by the permanent committee.
Correct.
Now that, my lord, goes to the full court. Looking, my lord, let us take, my lord, I find, my lord, when we, my lord, lordship is in the full court, let us take it like this, my lord, that the, my lord, array of marks is such that nobody has crossed 30. Let us take it, my lord. Then, my lord, the full court will decide that our cutoff marks will be 15.
Okay, leave aside all these things.
So, my lord,
You are-
therefore,
you are not pressing the prayer one.
my lord, my
not
lord,
pressing
at
the
the
prayer one.
present, my lord,
Not at the present. You have to see.
my lord,
then,
my lord,
because
I would,
there are two things. Mr. Mitro has taken the 2 point of maintainability, and both are the genuine point with regard to the if you are going to cost stick on the setting aside the 26/11/2024, the 80% will be affected. Then the opportunity of hearing is to be given.
my
then
lord,
they have
I
to-
thought,
they have
yes,
to made a party.
yes, my lord.
And with regard to the 18/12/2025, the production of the document, I have some reservation. I will make up. I will submit. I will say what is that. First, you say with regard to this 26.
My lord, I would rather suggest this, my lord, when the petitioner came to court, is that, my lord, we wanted a midway, like all high courts have done and the Supreme Court has also done. My lord, it
Mr.
is.
Mitro, sorry. Mr. Mitro, can you take the instruction from the Chief Justice and the committee or Chief Justice? Can this matter be reconsidered by the full court?
That's exactly what has happened, my lord. We'll be grateful.
Can it be taken by the full court so that it will be referred and let the take appropriate decision?
Happiest if that happens.
I mean, we will be also, my lord. As a petitioner, I would be the happiest.
On that, on this score, if this has been taken.
My lord, I will be. May I be very candid? May I be very candid, my lord? Mr. Mitro, my lord, is perhaps the, my lord, only person in this court. Not because of this matter. Let this go away, my lord. Is the only person who has been the best mediator of all these issues, whether it is East Bengal Mohan Bagan, whether it is CAB, whether, my lord, any other organization. And, my lord, I think if he persuades this, my lord, I think, which has happened in Delhi, Allahabad, and Odisha. If this has been sorted out, my lord,
Going to the judicial order.
that is why I said we are not, my lord, pressing the first.
Why I am telling, once the writ petition is filed, then the judicial order is
Yes.
required, and we don't know where it will stop.
Absolutely, my lord. We have faith in Mr. Mitro.
We have to see the integrity of the court also.
Yes, my lord.
I can tell your lordship, my lord, I can assure your lordship that after receiving this brief, I was more disturbed than my learning.
I was very, my lord. My lord. It's as I started off with my submissions, my lord, that nobody, my lord, goes against the temple.
After 2 weeks, I am fixing it.
My lord, may it be a week, my lord. My lord, it has been a delayed.
Because chief is also not directly, he cannot take the decision.
I'm being informed that the Honorable Chief Justice would not be there and he would be.
That's why I'm telling the Chief Justice will not be able to take decision singly. It is the committee has to take the decision. He has to.
That's exactly. That is, my lord, very fair enough, my lord.
Next week.
Next week.
My lord, definitely sit this week. I cannot assure that anything will happen within 1 week. But then again, my lord, I can make my best attempt.
I think that would be the best. And your lordship, my lord, I have one only prayer, my lord, is that. My lord, only one prayer, my lord, since as lawyers we have always faith in the court, my lord, is that, my lord, kindly like this, my lord, fixes a time and a date, my lord. Because this, my lord, involves 48 lives. My lord.
Hard in part is making the trouble to me.
Kindly make it hard in part.
My lord,
This is the only prayer. Hard in part is the only prayer I am acceding.
and my lord, when a senior of such stature says, my lord, I think, my lord, it is something which should be respected. Yes, nothing to say.
My lord, may I submit this?
Yes.
Your lordship is fixing. My lord, today is we are on the
Second, third.
চিফ নেই তারা কবে বলছো
আপনি বলুন না 8, 9,
20, 9, 10, 12 তারিখ থাকবেন না 9 তারিখ করুন বা 10 তারিখ করুন স্যার
চিফ তার না থাকুক না তার আগে তার আগে
আপনি যা বলবেন হ্যাঁ হ্যাঁ আপনি যাবেন আপনি যেটা করবেন
I should in the meeting I should advance we can make it 12th of
12 में 345 खाली है खाली है कब खाली है देखो 13
13 unlucky
13 is unlucky
13 is a good thing.
Can it be possible 11?
11th we have no issue.
Counsel for the parties have argued the matter at length. Full stop. This court is of the view that counsel for the High Court administration is directed to take instruction. Accordingly, case is adjourned. Let the matter appear on 11th February at 3:45.
Malad, the time, Malad.
3:45.
And Malad part heard, Malad. That request of Mr. Mitro cannot be turned down.
As part heard, matter.
Grateful, Malad. Grateful, Malad.
So you persons are making me as a
that we can only, Malad, since my lord is from the bar. And I am aware of it, Malad. Grateful, Malad.